Test. Seems like it's working.
Yes, I can see and hear you.
Thank you so much.
Ms. Boulay, are you ready?
Good morning, Chair. I'm ready.
Thank you. Ms. Federico, are you ready?
Yes, I am.
All right. Good morning. We're now on the record. It is 9 a.m. on March 11th, 2024. This is an evidentiary hearing in proceeding number 23A-0392EG, Public Service Company of Colorado's Clean Heat Plan application. I'm Eric Blank, the chair of the commission. Can my colleagues introduce themselves for the record, starting with Commissioner Plant?
Plant, Commissioner?
Good morning. This is Commissioner Megan Gilman.
Thank you. Let's continue with entries of appearance. Mr. Larson.
Good morning, Mr. Chair, Commissioners. Matt Larson, Wilkinson Barker Nauer LLP, on behalf of the applicant, Public Service Company of Colorado. I'd also like to enter the appearance of Tana Samard Pacheco with Public Service Company of Colorado, Philip Roselli with our firm, and Samuel Eisenberg, also with our firm. Thank you.
Thank you. Trial staff.
Good morning, Commissioners and Chair. My name is Assistant Attorney General Ross Smith. I'm representing trial staff in this proceeding. I'm joined today with my colleague, Assistant Attorney General Josh Horman. We will also at times have First Assistant Attorney General Paul Kide with us as well.
Welcome. Thank you, sir. UCA.
Good morning, Kate Crampton with the Office of the Attorney General on behalf of UCA. I'm joined by my colleagues Patrick Wittersheen and Michelle Singer-Nelson.
Thank you. Colorado Energy Office.
Morning, Commissioners, parties. This is Jackie Colicchio on behalf of the Colorado Energy Office. I would also like to enter the appearance of Second Assistant Attorney General Jessica Lowry and Assistant Attorney General Gabby Falcon as well. Thank you all.
Thank you. City and County of Denver.
Good morning, Commissioners. My name's Chuck Solomon, Assistant City Attorney, representing the City and County of Denver. And I would also like to enter the appearance of Co-Counsel Amanda McDonald. She's not with us this morning, but she will be joining shortly. Thank you.
Thank you. City of Boulder.
This is Veronique Van Giem with the City of Boulder. I'm also entering appearance for Deputy City Attorney Roberto Ramirez.
Thank you. City of Pueblo.
Morning, Mr. Chairman, Commissioners. Mark Davidson of law firm Fairfield and Woods, appearing on behalf of the City of Pueblo.
Thank you, sir. County of Pueblo.
Good morning, Commissioners and Mr. Chair. It's Francis Consilia on behalf of the County of Pueblo, and my body and mind still tell me it's 8 a.m. for this hearing.
Don't mess with me. All 40 of us didn't screw up, did we? Thank you, Ms. Consilia. CEC.
Good morning, Mr. Chair, Commissioners. Michelle King of the law firm Holland and Hart. I'm here on behalf of the Colorado Energy Consumers, and I'd also like to enter the appearance of Austin Rushoff.
Thank you. Project Canary.
Good morning, Mr. Chair and Commissioners. Penfield Tate with the law firm of Tate Law, appearing on behalf of Project Canary.
Thank you. Holy Cross Electric. Black Hills, Colorado Gas.
Good morning, Chairman, Commissioners. Emmanuel Koshin, representing Black Hills, Colorado Gas.
Thank you. NRDC Sierra Club, the Conservation Coalition.
Morning, Commissioners. Matt Gerhardt, representing the Conservation Coalition. I'd like to also enter the appearance of my colleague, Jim Dennison.
Thank you, sir. CRES, Colorado Renewable Energy Society. EOC.
Good morning, Chair and Commissioners. Gabriela Stockmeyer of the law firm Dietza and Davis on behalf of Energy Outreach Colorado. Mark Detsky and Daniel Rubin from our firm are also entering their appearance at the hearing.
Thank you. Kosa Sia.
Good morning, Mr. Chair and Commissioners. Ellen Howard Coots, our General Counsel for the Colorado Solar and Storage Association, also representing SIA. Thank you.
Chevron Occidental Petroleum and Williams, the Decarbonization Coalition.
Good morning, Mr. Chair, Commissioners. Jim Martin from the law firm of Beatty and Wozniak, representing the Colorado Decarbonization Coalition. Also entering the appearance of my colleague, Mr. Devin Bill.
Thank you. Local 208 pipe fitters.
Good morning again, Commissioners. Francis Consiglio on behalf of the pipe fitters.
Thank you. Laborers International Union of North America, Local 720.
Good morning. Stanley M. Gosh on behalf of the law firm of Rosenblatt, Gosh, and Rankin, on behalf of LIUNA, Local 720.
Thank you. Sweep.
Good morning, I'm Michael Hyatt with Earth Justice, appearing on behalf of SWEEP, and I also like to enter appearance on behalf of my co-counsel, Robert Ragonen.
Thank you. Western Resource Advocates.
Good morning, Commissioners. Parks Barroso on behalf of Western Resource Advocates.
Thank you. APCD, is anybody here from APCD? Commission Counsel.
Good morning, Chair. I'm entering my appearance as Attorney General Lindsay Dundas, and I'm also joined by Assistant Attorney General Wendy Rosati and Ruth Harper this morning.
Thank you. Did I miss anyone? Could be the first time in 3 years I got everyone. We're going to conduct this hearing using electronics exhibits. A spreadsheet marked as Hearing Exhibit 2300 lists the latest versions of the pre-filed testimony exhibits. With that, any objection to the omission of Hearing Exhibit 2300? Right now, it's just the spreadsheet listing the exhibits, not the exhibits themselves. Mr. Larson?
Yeah, no objection to the omission of Hearing Exhibit 2300. There were corrections that were filed late in the day on Friday. I don't know if you want to handle those witness by witness or get to that as we move forward this morning. But I just want to note that the corrections came in under the scheduling order, close of business Friday.
Yeah, I think I'd like to handle that witness by witness, if that's all right.
Perfect.
Any objections to the omission of Hearing Exhibit 2300?
No objection from the company.
Hearing none, so admitted. Subject to Mr. Larson's caveat that there's going to be a bunch of changes and revisions as individual witnesses come before us. Is there a stipulation among the parties admitting all the items listed on Hearing Exhibit 2300? Or is there any objections to admitting all those documents with the understanding that they're going to be updated witness by witness? Mr. Larson, is there a stipulation?
Yeah, Mr. Chair, we reached out to all of the parties on Friday. My understanding is that there is no objection to the omission of the exhibits that are in 2300.
Excellent. Let me just ask, any objections? Hearing none, all those exhibits listed on Exhibit 20, all the items listed on Exhibit 2300 are admitted. Witness excusal. I think we have 22 witnesses who are not scheduled to have any cross-examination, who I'd like to excuse if possible. And let me just start with Commission Counsel. And the witnesses I have are for the company lead, for staff, Lamar and Turner, for Denver, Rogers, For Boulder, Lerman. For WRA, Nelson. For CDC, Vitus, Speedus. For CEO, Otteson. For CREZ, I have Kuchar, Denning, Howarth, Rains, Martin, Lake, Rao, Klebel, Swain, Hopkins. For EOC, I have Elderton. For Local 720, I have Trujillo. For WRA, I have Sebulko, Billsback, and Pierce. So Commission Counsel, can you let me know if you have cross-examination for any of those witnesses?
Commission Counsel will not have cross-examination for any of those witnesses, Chair.
Okay. Let me just go through my colleagues and then I'll turn it back to Counsel. Commissioner Plant?
I may have questions for Billsback and Pierce.
For Pierce, and who was the other one?
The name in front of me. Also from WRA on health impacts. Starts with a B.
Is that Billsback?
Billsback, yeah.
Commissioner Gilman.
Yeah, I likely have questions for Lemaire from staff. And I have like one question for Otteson from CEO, but I do believe Mr. Hay can probably deal with it. So I feel optimistic I'll get it done with Mr. Hay.
So Ms. Otteson is not excused, but may be excused. Mr. Larson.
Just one note, Mr. Chair. So Dr. Lieb, who testified in direct on behalf of the company, she has left the company. Her testimony has been adopted by Ms. Quillian. So Ms. Quillian is available for cross-examination with respect to Dr. Lieb's direct testimony.
Let me just pull up the cross. All right. So Ms. Lieb is no longer part of the hearing, and Ms. Quillian is available to answer the questions, and she will. Looks like multiple parties have crossed for her.
That's
Mr.
correct.
Barrasso.
Thank you, Chair. Just wanted to confirm what I heard from the commission. I heard that the commission has questions for Dr. Billsback and then also for Mr. Pierce, or is it just for Dr. Billsback?
I think both is what I heard from Commissioner Plant.
Great, thank you.
Ms. King.
Thank you, Mr. Chair. We wanted to, if now is the appropriate time, we've reached a stipulation with two of the parties with respect to admission of exhibits that will likely reduce, if not eliminate, the need for cross of CEO witness Hay and sweep witness Brandt. And so I can address those now if it's the appropriate time, or can take it up in the ordinary order of their testimony.
Yeah, well, let's see if we can excuse the witnesses, and then we'll go to reducing the cross, if that's okay.
Perfect. Thank you.
Mr. Davidson, anything on witness excusal or?
Yes, Mr. Chairman. As some of the parties may know, Mayor Gradisar, who submitted answer testimony on behalf of the city of Pueblo, is no longer the mayor in Pueblo. I'm trying to find someone there who can adopt his testimony on behalf of the city. I think there was one party that reserved 10 minutes to cross-examine Mayor Gradisar. And I just wanted to alert the parties that it will be someone else if that cross is still necessary. But I just wanted to bring that to your attention and that of the commissioners in advance of when that individual would be called on behalf of the city. Thank you.
Ms. Kutzer, any thoughts? I think you're the only party
Yes.
that had.
Excuse me, Mr. Chair. Yes, Mr. Chair, we will waive cross of the Pueblo witness. Thank you.
Thank you. I think that makes your life a little easier, Mr. Davidson.
Yes, it does, Mr. Chairman. Thank you.
And thank you, Ms. Kutzer. Ms. Colicchio.
Thank you, Mr. Chair. Sorry, our audio. We did not hear Mr. K mentioned in the list of witnesses that did not have cross time reserved, and we wanted to clarify whether or not the commissioners or staff to the commission had any questions for Mr. K.
Commissioner Plant,
No, I do not.
Commissioner Gilman,
I do not, and I also don't have any questions for the mayor, either. So the Pueblo issue is not an issue for me.
Commissioner Plant, you okay, letting the mayor go?
Yes.
As am I. And a commission council, any questions for Dirk A?
No questions for the Pueblo witness or Mr. K, but I don't believe they're up for. Oh, okay. Yes. No questions for Mr. K from CEO. Sorry about that.
Okay. I think she can be excused, Ms. Colicchio.
Thank you very much.
Sorry. Yeah, sorry for the oversight on my list. Ms. Van Geem.
Thanks, Commissioner Blake. We also didn't hear Matthew Lehrman's name in the list of witnesses that didn't have crossed. We were wondering if he might be able to be excused.
I think he was in the list. I may, well, as far as I'm concerned.
Rogers, sorry, under City of Boulder, so I might have missed it.
Oh, maybe I confused them, but I'll confirm. Commissioner Gilman, questions for Mr. Lehrman?
No questions.
Commissioner Plant?
No questions.
Commission Council?
No questions.
Mr. Lehrman is excused.
Thank you.
Seeing no more hands up, let's follow up with Ms. King. It sounded like there's a stipulation that reduces cross.
Yes, thank you. If we can please, we have 4 hearing exhibits that are discovery responses that I've reached agreement with counsel for CEO and counsel for sweep, where I would try to introduce these exhibits with their respective witnesses, Mr. Hay and Mr. Brandt. And so the admission of these exhibits, I think, reduces, if not eliminates altogether, the need to cross either of these witnesses.
Would you like to give
Yes.
new evidence, new times for Mr. Hay and Mr. Brandt?
Well, if we can admit these exhibits, I think the time for Mr. Brandt should be 0. And I'm not quite ready to reduce Mr. Hay's time all the way to 0, but I might be able to do that a little bit further into the hearing.
All right. Would you like to make a motion to do we what's your would you like to do it now, or would you like to do it with an Excel witness?
No, I can do it now. So if we can please pull hearing exhibits 2100, 2101, 2102, and 2103.
Any objection to admitting these exhibits?
No objection from CEO.
We have not seen these exhibits yet, Mr. Chair. So
yeah, let's not
we'd
do
appreciate
it now.
the opportunity to take a look at them. I don't anticipate having an objection, but
no, I understand. Let's not do this now. Ms. King, let's assume we're going to reduce the cross for Mr. Hay and Mr. Brandt. If you could circulate those exhibits to the company, and we'll find a way to get them admitted at an appropriate time. So
absolutely,
thank you.
We'll send those to all the parties and see if there's any objection. We can reduce the time for Mr. Brandt to 0, and let's leave Mr. Hay at 10 minutes just as a placeholder, please.
Yep.
Thank you.
All right. Put Mr. Brandt one. Mr. Calvano.
Yes, Chair and Commissioners, I apologize for missing the earlier introductions, but I wanted to enter my appearance on behalf of the Colorado Renewable Energy Society and the Physicians for Social Responsibility Colorado and ask if you had any questions of any of our witnesses.
We have already confirmed that we do not have questions for Kuchar, Denning, Howarth, Rains, Martin, Lake, Rao, Klebel, Swain, and Hopkins.
Okay, and then I also wanted to update you and let you know that we are waving our cross on Mr. Eiley and Mr. Gardner.
Hold on. So you had 30 minutes for Eiley, that's waived, and 15 minutes for Gardner.
Yes, sir.
Thank you. Mr. Smith.
Thank you, Chair. Staff just would like to, I know we had the most time reserved on Ms. Fickling, and staff is going to waive that cross time on Ms. Fickling. In addition, we would like to reduce our cross time on Mr. Hay from 35 minutes to 15 minutes. That's just the only two things that I have right
now. Thank you. Well, say 4 hours. Anybody else? All right. Before turning it to the parties for any preliminary matters, I did have one issue I wanted to raise on my own. As I understand the record, the company has presented a cost-benefit analysis model and study conducted by E3. Several parties have raised questions about the model's inputs regarding the scalar mechanism applied to the cost measures as adoption approaches 100%, and the specific measure of replacing AC units at the end of the life with air-sourced heat pumps. Without in any way addressing the merits or any other aspect of the case, for me and advisors, I believe the record could benefit from additional runs which modify those two inputs. So I'd like to ask the company if we could rerun the model holding the scalar at 1 for all years in the CHP period, and for the model to contemplate end-of-life AC replacement with air source heat pump units. And if my colleagues agree with that request, I'd suggest that we issue a bench order this morning asking for the additional modeling runs, maybe by Thursday, close a hearing. And then, we'd give the company an opportunity to present the sponsoring witness and then make that witness available for cross. So I don't know, Commissioner Plant, any comments on that? Would you be willing to support that request?
Yeah, absolutely. I think that would be really valuable information to get. And I think that the E3 modeling will run the program administrator cost test or utility cost test. If not, I'd like to request that also be run, but I believe that's a part of their process in addition to the TRC.
I would like to see the utility cost test also. Commissioner Gilman, you may have your own request, but any thoughts on that request? And then I'll turn it over to you more broadly.
I agree with that request. And just to be clear, we'll be asking them to rerun each of the portfolios.
Okay.
With those assumptions,
that was my request. Yes.
Okay. Each of those, as I think through like how that'll look when they do it, obviously cost target has a pretty fixed variable. So does the emissions target. So does the full electrification. The flex is probably one that doesn't really, right? Like it was essentially a middle ground in terms of emissions and budget. So I don't know exactly what we'll see when those rerun, if they re-optimize, but I would just maybe emphasize some reasonable mix of attributes as they look to re-optimize that run.
So Mr. Larson, you may need time to confer with your client, but any thoughts on that request? And maybe at the first break, you could let us know if there's any issues or process concerns with this approach. I think we're getting better at trying to raise our record requests at the beginning of the hearing, just so there's appropriate time for due process. So any thoughts, Mr. Larson, with the understanding that you may have to talk to your client?
No, I appreciate that, Mr. Chair. And I think we'll have to confer with E3 in terms of what the run times on that are and what's possible. So as I understand it, it's another look, and it's a look at emissions target, cost target, flex, base, electrification only, flex high as well. I just want to make sure we got the full picture of what's being asked.
Yes, with those two assumptions, setting the scalar at 1 for all years, and to contemplate end-of-life AC replacements with air source heat pumps.
So we will confer with E3, and we'll have to confer as a team over here, and then perhaps at the first break or later on today, can give you an update on what the possibilities are there.
Yeah, that'd be great. And the thought was, sort of at the end of the company's case, you could put a witness on laying that out, so that witness would be available for cross. And if it went later into the hearing where we had to do that, we'd accommodate what we needed. But the key is to hopefully get the materials out, so the commissioners and the commission advisors and the parties have a chance to look at it. And then there's an opportunity for informed cross and informed commission questions. And I think we'd all commit to turn that around, in 24 hours, something like that.
No, understood. We'll start with, what the technical feasibility of doing this is, and then we can move to kind of the process side, depending on what that looks like.
Greatly appreciate it.
Chairman, I did just want to add one thing in that request. To the extent that the values that come out of the modeling are used in attachment JWI-4, I think it would be very helpful to see those replaced with the values from the new modeling in JWI-4, if that's a possible portion of this.
We will check on that as well as part of the holistic ask.
Commissioner Goen, did you have anything else on this or any other preliminary matters before I go back to the parties?
Just that additional, if you two both agree, if they're capable to also update the values in JWI-4.
I think Mr. Larson largely agreed, but I would echo your request, Commissioner Plant.
Yeah, that sounds great. Thanks.
All right. Thank you. Anything else from the parties on preliminary matters before we jump into our first witness?
Mr. Chair, there are some witness availability issues, but I don't think they're implicated yet until later in the week, but there's potentially some witnesses that'll need to be taken out of order. I think we can handle this in due.
Yeah, I guess, Mr. Larson, could you work with the parties and just get sort of a comprehensive list of everybody's constraints? I guess sometimes we see it on the cross-examination matrix, but this one didn't have it. So if you could work with the parties and just get all that clarified, that'd be really helpful. Ms. Dundas?
Oh, just Chair, it is on the matrix on the second tab, but as far as I understand, we should be good today to just work through Mr. Eiley, and I imagine that'll take us most of the day.
Okay.
So we'll check in
Oh, I
tomorrow
do see it.
morning
I
on.
do see it. My apologies. I do see it. Mr. Martin?
Mr. Chair, just to clarify, have you ruled ultimately on waiver of witnesses?
Yes, maybe not. Fair enough, Mr. Martin. Lieb, Lemaire, Turner, Rogers, Lehrman, Nelson, Vitas, Otteson, Kuchar, Denning, Howarth, Rains, Martin, Lake, Rao, Klebel, Swain, Hopkins, Ilderton, Trujillo, Sabolco, are excused, as is Mayor Gratishar. That's my understanding. Did I get that right, Ms. Dundas?
I had that Commissioner Gilman had questions for Lemaire, so I believe we're not excusing him at this point. And same
My
with
mistake.
Otteson.
Yep.
And then just for the record to reflect, Lieb is excused as no longer being for the company, but questions directed to Lieb will be answered by Ms. Quillian.
Got it. And my understanding is there are no questions for Ms. Lieb.
Correct. And then what I think I'm going to beat Ms. CEO's counsel, and also Dirk Hay and the mayor of Pueblo have been excused.
Yeah. Dirk Hay, Mayor Gratishar. Appreciate it. Any other preliminary matters?
Nothing further from the company, Mr. Chair.
All right. I did have one personal thing on my own behalf. My dad's funeral and burial were yesterday, about 6 weeks after my mom's. I'm still in Philadelphia and struggling to deal with some personal issues. As such, I've asked Commissioner Gilman to lead the hearing forward from here. So Commissioner Gilman, if you're still willing and able, would you like to take over from here?
Sure, thank you. I can't back out now.
I think I had you committed from before, so thank you. Would you like to call Mr. Eiley?
I will. Just real quick on witness availability. Mr. Miller from Project Canary looked to have pretty limited availability. He needs to be taken by tomorrow, is my understanding. Mr. Tate, you confirm that?
That is correct, Commissioner Gilman. He's available today and tomorrow.
Okay. So he will likely need to be kind of interspersed with public services witnesses. So just a heads up to the city of Boulder and WRA, who are the two parties with questions for him. I think we'll aim to take him tomorrow morning. Some of these chunks of time for some of the public service witnesses are pretty big. So I want to get him in tomorrow morning so that we don't inadvertently kind of miss the window tomorrow, if that makes sense for everyone.
Thank you, Commissioner. I will alert Mr. Miller and let him know to be ready at 9 o'clock tomorrow morning.
Excellent. Thank you. And then I know there are a few other restrictions that look to fall somewhat close to where some folks were coming. So a few of those we will just check as we go with respect to, like, Mr. Haglund, Ms. Copeland, Mr. Kruger. We might just have to take some folks out of order somewhat. I don't think it'll be dramatic, maybe a couple witnesses out of order to make those availabilities work, but a few of those I'm continuing to track. So Mr. Miller seemed like the biggest one to alert you all to, because it'll come pretty quick. Anything else before we get started? Okay. We will have public service. Please call your first witness.
Thank you, Commissioner Gilman. The company would call Jack Eiley.
Good morning, Mr. Eiley.
Morning, Commissioner Gilman, Commissioner Plant, Chairman Blank.
Can I please have you raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Is anyone currently communicating with you in any way?
No.
If that changes during the course of your testimony, will you please stop and let me know?
I will.
All right, you may begin, Mr. Larson.
Thank you, Commissioner Gilman. Good morning, Mr. Eiley.
Good morning, Mr. Larson.
Can you please state and spell your name for the record?
My name is Jack Eiley, spelled J-A-C-K-I-H-L-E.
And did you cause to be filed 4 different pieces of testimony, those being hearing exhibit 101, which is your direct testimony, hearing exhibit 110, which is your supplemental direct testimony, hearing exhibit 115, which is your additional supplemental direct testimony, and hearing exhibit 116, which is your rebuttal testimony?
I did.
Were those prepared by you or under your direction?
They were.
And do you have any corrections to that testimony this morning?
I believe we have one minor correction to the rebuttal testimony.
That's correct. Ms. Federico, are we able to pull up hearing exhibit 116 out of our box?
Yes, give me just a second.
Thank you. And if we could go to page 101, line 8. Mr. Eiley, does that change at page 101, line 8, reflect the correction that was filed with the commission on Friday pursuant to the schedule order?
It does.
So the other exhibits have been admitted into evidence. We would also move hearing exhibit 116, Rev 1, with this change at page 101, line 8 into evidence.
Any objections? Okay, granted.
Thank you. And with that, Mr. Eiley is available for cross-examination.
Okay, sorry about that. We have first up, staff. Mr. Smith.
Thank you, Commissioner Gilman, and good morning, Mr. Eiley. I believe you and I have met before. My name is Ross Smith. I'm an Assistant Attorney General representing trial staff in this proceeding. I can assure you I do not believe my questions will take 45 minutes this morning, so I'm hoping to get in and out pretty quick here because I know you've probably got a long day ahead.
Good morning, Mr. Smith. Good to see you, and I appreciate that.
Yeah. So my examination this morning is generally just going to cover a couple of areas. I want to talk about rate increase mitigation as it's contemplated under the Clean Heat Plan statute, as well as the relationship between that mitigation and the statutory cost cap. And 2, I want to talk about what you've referred to in your rebuttal testimony as the 3 verticals, if I may. So let's get started by talking about this rate increase mitigation and cost cap. And are you generally familiar with the Clean Heat Plan statute? And if you need the reference for that, I can give it. But I just want to ask if you're generally familiar.
I'm generally familiar with it. If we go into specific language, I may ask you to bring it up.
Sure. And are you familiar with the provisions of the Clean Heat Plan statute related to the Commission's ability to approve a clean heat plan with costs that exceed the cost cap?
I am.
Okay. So if we can go ahead and bring up what has been marked as hearing exhibit 304 in staff's box folder, Ms. Federico, that would be really helpful. There we go. And if we can go down to page 3, I believe that would be great. Okay. And if we can go to the bottom of page 2 and the top of page 3 there, that would be perfect. Thank you very much. So I would like to first start out here. And actually, Ms. Federico, if we can scroll down just a little more, that would be good. There we go, to where we can see D there. Okay, thank you. So I'd like to turn to this sentence that states, among a few other things, the commission may approve, and this is, I don't want to read the whole thing to take up too much time. The commission may approve a clean heat plan with costs greater than the cost cap only if it finds that the plan includes mitigation of rate increases for income qualified customers. Do I have that correct, Mr. Eiley?
I believe so. I'm not sure I'm seeing that here. Apologies if I'm missing it.
Let me see. Should be under, I apologize, it's under 2D. If we can go to 2D, that would be great. And I apologize, when I pulled this, it did not pull over exactly the way it's supposed to. There we go. I see something under there under cost cap. And if we can't find it,
I see the
yes.
definition of cost cap. I'm not sure it gets into the conditions that I think you're heading toward.
I see. Would you accept, so that we don't have to go scrolling through looking for it, would you accept that I've generally encapsulated what the statute says regarding the cost cap?
Yes.
Subject to later check. Okay.
Yes.
Now I'd like to turn, we can take this down. I'd like to turn to your rebuttal testimony, which is marked as hearing exhibit 116. And this time I do have, I believe, the correct page number, specifically turn to page 84, line 8. Okay. And here you indicate that you strongly disagree with staff's position that the company's direct testimony is vague and insufficient as it pertains to the satisfaction of the statutory requirement that we just looked at. And have I encapsulated that correctly?
Yes.
Okay. And your response to that strong disagreement on lines 9 and 10 is to indicate the company's plan includes, and I'm quoting here, a host of mitigation measures for income qualified customers that satisfy this requirement, end quote. Have I read that correctly?
Yes.
Okay. So if I can broadly summarize your testimony here, if I may, you testify that the host of mitigation measures that you speak to here can be broadly split into two categories. One, we have affordability programs such as the PIP, and two, what you call rate mitigation measures that will reduce the bill impact of clean heat to all customers, including income qualified customers. Is that a fair summary of your testimony?
I think it is, yes. Sort of described further on pages 84, 85. Yeah, 84 and 85, my testimony.
That's right. So let's just start with that first category, and that's the company's affordability programs. The company didn't propose any modifications to these programs in its direct testimony, did it?
No.
Okay. And it didn't propose any modifications to these programs in its rebuttal testimony, correct?
That's correct. Those programs are generally adjusted in other proceedings than a clean heat proceeding.
I see. And so it would be fair to say then that these affordability programs are not necessarily creations as part of the company's clean heat plan, right?
The programs described on, I think you're referring to sort of EAP and GAP. Those two programs do not arise from having been proposed under the clean heat plan.
Okay. Thank you for that. So in other words, these programs are not designed as part of the company's clean heat plan, and there was not a proposal in either a direct or rebuttal to modify these programs. Have I got that right?
For I'll spell it out. For the electric affordability program and the gas affordability program, that is correct.
Okay, I see. So what these plans describe is a version of targeted spending. Is that right? Is that a fair way to describe them?
The EAP and GAP?
Mm-hmm.
I'm not sure I fully understand your question. Apologies.
So these affordability programs that we've been talking about, those are targeted spending plans, right? They're targeted ways of the company spending its money, correct?
They are programs aimed at customers who have qualified for those programs, which is generally an income qualification process, if that's what you need.
I see. I think when you said the EAP and GAP, I think I was a little confused. I meant that when we're talking about this first category of affordability programs, such as the PIP, not the EAP and GAP. That's my fault for not correcting you there. I'm speaking of the first broad category of mitigation measures that you propose, which are programs such as the PIP that are affordability programs.
They
So
are.
is that okay? So would you agree that targeted spending is not necessarily the same as mitigating rate increases, right?
I'm not sure I would agree with that. I think it's intended to mitigate the effects of rates, which are really expressed as bills for the customers that qualify for these programs.
I see, but they're not directly programs designed to specifically mitigate rate increases, right? It might be an ancillary effect, but it's not the main purpose of the
Well,
program.
they mitigate the bills that these types of customers would receive, both with and without the clean heat plan.
I see. So really, what we're talking about here is it's I see. I think I understand what you're saying. So you're referring to reducing bills for participants, correct?
Yes, customers pay bills.
Okay.
And
I
these
see.
programs allow them to pay lower bills at the end of the day.
I see. I see. So aside from being broadly grouped in as part of the company's mitigation measures in its plan, the actual design of these programs really, we've agreed they really don't have anything to do with the company's clean heat plan as it was filed, correct? The company's taken existing programs, classified them here as mitigation measures in order to satisfy the statute, right?
But those programs are independently proposed and operated right now from this plan. I would agree with that. We have in this plan proposed to direct 20% of the intended rebate spending toward income qualified and disproportionately impacted community customer groups.
I see.
Specifically under this plan.
Okay. So I just want to jump now to the second category of these mitigation measures that you talk about. And these are what I would call general mitigation measures that your testimony states will reduce the bill impact to all customers. And I think we've kind of touched on that, but I just want to kind of dig down just a little farther on that. And the first example you give, and this is on, if we can go to page 85, line 5. Okay, and it's the company's APP reduces costs compared to the emissions target and electrification only portfolios. Is that a fair summarization of what it says here?
Yes. And I would
Okay.
say the Clean Heat Plus before that was striving to do that as well.
I see. So if I'm understanding this correctly, the company's position is that any clean heat plan proposal that reduces costs compared to any other clean heat plan proposal would count as rate mitigation and therefore satisfy the statutory bar on exceeding the cost cap. Is that a fair description?
I think with the other factors in play here, our statement here is that our efforts to make this as cost effective as possible, recognizing the challenge of reducing these emissions in this sector is part of the set of factors that would lead to the commission's ability to judge that a rate mitigation package, if you will, has been proposed with these clean heat plan proposals.
Okay, and I appreciate that description. So if we look at the company's originally modeled portfolios, does the company consider the emissions target portfolio to be rate mitigation because it reduces costs compared to the electrification only portfolio?
I think it's a relative statement. Yes, it's cheaper than the emissions, or I'm sorry, the emissions target is lower cost than the electrification only portfolio under our modeling. So it is, it is one pathway by which the commission maybe, could approve a portfolio that's cheaper than another one.
Okay. So let's just look at one other example of the general rate mitigation you provide. You argue that you consider a longer amortization period for the clean heat plan rebates to be a form of rate mitigation, correct?
Yes.
Okay. And would you agree that the statute indicates the mitigation of rate increases? It doesn't specify mitigating bill impacts?
Could you direct me to that portion of the statute?
Yes, if we can go back to, if we can bring back up staff's first hearing exhibit, that would be, let's
The
see,
statute
hearing exhibit
1304?
304. Yes, that's correct. Thank you. And give me just a moment. I'm bringing it up on my end as well. I apologize. It's taking it a second.
And I apologize, Mr. Smith. I do think the words matter here. I think
Sure. No, I agree.
I just want to be really careful about it.
I understand, and I agree with that entirely. Give me just a moment here.
As this is an issue that could bear on the commission's selection of a portfolio, so I want to be careful for all of our sake.
Okay, and then I think if we go to 6A1, that's where the definition will direct us to. So if we go to 6A1, that would be great, Ms. Federico. And I believe that begins here on page, yes, on page 9. Okay. And give me just a moment here. I'm just making sure that I've got that. And I apologize for this, that not having the full citation here. And then it would be in 6A3. Okay. And so I think in this language here, does it say anything about and excuse me for a sec, does it say anything about bill impacts?
I still don't see 6A3. Apologies. I don't see the rate impact.
Oh, I apologize. If we can scroll down just a little bit, Ms. Federico, and I'm sorry, if we can go to 6D3 as well. If there's a way, I don't know if we can get both of them on there, but if we can go to 6D3, that would be great.
I can
That's fine. Just it's okay. We can just go to 6D3. That's okay. Okay, and here we go. So if we see down here at the bottom of the page, 63, the commission may approve or amend and approve a clean heat plan with costs greater than the cost cap only if it finds that the plan is in the public interest, cost to customers are reasonable. The plan includes a mitigation of rate increases.
Mr. Smith,
Yes?
could you please slow down?
Sure. I'm not going to repeat all of that. But Mr. Eiley, do you see section this section to which I'm referring?
I do, and apologize for leading us through that, but I do see that, and I feel more comfortable now. Thank you.
Okay, and so I'll just repeat. Do you see anything regarding mitigating bill impacts in that statement?
There's nothing literally
Objection.
stated there about bill impacts.
Sorry.
Object to this line of questioning to the extent he's asking Mr. Eiley to render a legal opinion.
And if I may respond, Commissioner?
Yes.
I'm not asking Mr. Eiley to render a legal opinion. I'm asking him to explain to me whether he sees the words mitigating bill impacts in that line. I'm not asking him to give me any kind of opinion on the legal nature of the statute.
Yeah, overruled. Mr. Eiley, you're not required to give a legal opinion here, but just indicate what you do or don't see.
Okay, I'm sorry, I already did. I do not see bill impacts. I'm not sure under D3 it says the word bill. I guess I would venture to say that I certainly understand the difference between a rate and a bill. If we were to modify rates in this case, that sort of ventures straight into the terrain of a phase 2 rate case and would have further expanded the scope of this hearing.
Okay, and I appreciate that. And Ms. Federico, you can take this down. If we can just go ahead and bring up what's been marked in staff's box folder as hearing exhibit 1305, that would be great. And Mr. Eiley, do you recognize this is a staff discovery response? Do you recognize this? And if we can scroll down, Ms. Federico. Oh, that's plenty. If we can just get the main portion in there. Thank you. Appreciate it. Mr. Eiley, do you recognize this discovery response?
Not offhand. I'd like to read it if we're going to go into
Sure,
this.
absolutely. Take your time.
Sure, thanks. It's short. Appreciate that. Okay, I got it. Thank you.
Sure. And so for the record, this is staff's discovery response to the company's discovery request 2-14. And is that what you read as well, Mr. Eiley?
Yes.
And in this discovery response, it indicates staff has calculated that under the company's amortization proposal, ratepayers will pay $1.71 for every dollar of rebates the company issues. Do you see that?
Yes.
So under this analysis, the company's position is that an amortization proposal that costs all ratepayers an estimated $1.71 per dollar of rebates issued by the company is a rate mitigation measure that is sufficient to satisfy a statutory requirement of inclusion of mitigation of rate increases for income qualified customers in order for the commission to approve a plan that exceeds the cost cap. Is that a fair description of the company's position?
I'm sorry, can you please repeat that?
Sure. So in other words, the company's position is that an amortization proposal that under staff's view costs all ratepayers an estimated $1.71 per dollar of rebates issued by the company is a rate mitigation measure sufficient to satisfy the statutory requirement that allows the commission to approve a plan that exceeds the cost cap.
Objection compound.
I can rephrase it, Commission.
Thank you, Mr. Smith.
The company's position is that this amortization proposal, under staff's analysis, this amortization proposal costs all ratepayers an estimated $1.71 per dollar of rebates issued by the company. Isn't that correct, Mr. Eiley?
That's staff's analysis.
Okay. And the company's view is that this amortization proposal is a rate mitigation measure, correct?
Yes, it's part of the package of rate mitigation because it will reduce the initial rates that customers are charged. Acknowledge that financing costs money, but it will reduce the short-term costs and therefore the rates that customers will pay to help bring this program into action.
Okay. I think that's all the questions I have on that. I want to change now our topic of discussion to the second area, what you would refer to in your rebuttal testimony as three, and they're called verticals. And this is, Ms. Federico, this is in hearings at 116 on page 19. This is labeled as JWI-R-2. Thank you, I appreciate that. So is what I'm looking at here, Mr. Eiley, is this the three verticals, the infamous three verticals?
Yes, hopefully they're not infamous, but these represent the three verticals, basically the three rows denoted by the gold arrows to the left.
Okay, I see. So I really want to focus on two of these verticals, the compliance clean heat strategy at the top and the market transformation portfolio, or the MPT. So let's start with what I'll call vertical one, which is the compliance and clean heat strategies. Do you see that there?
Yes.
Okay. Now, correct me if I'm wrong, but you don't recommend a specific portfolio within this vertical, do you?
In the first one?
Yes.
At this point in the case, we decided to bring three portfolios forward as updated and, encourage a discussion and thought around which one of those three made the most sense and let the commissioners decide that.
I see. So let's go to line 10 on page 20, if we could. Okay, and you indicate that here that you see some benefit to the flexible approach. Is that right?
Yes.
On lines 10 and 11? Okay.
Yes.
Now, as far as process, the flex approach would essentially mean the company would provide data regularly regarding early clean heat plan adoption in its 2026 annual report, correct?
Yeah, to be a little bit more specific, I would see that data being provided in the 2020, there would be a 2025 annual report, which is, I believe, due March 31 of 2025. And then we would similarly follow suit. We asked for a waiver such that information would be filed, I think, now I'm struggling, June 30th or July 31st in 2026. So a little bit later than that annual report. So there'd be two provisions of updates of data, if you will. Is our intent.
I see. Okay, I appreciate that. And then from there, after that's that data is provided, they would propose an allocation of this $119 million that was, I guess, quote, held back, for lack of a better term, correct?
Yes.
Okay. And from there, the commission would decide how or whether that $119 million is spent based on separate rounds of commentary, right?
Yes, that's the proposal. Okay. Yes.
Okay. And that commentary would sort of would take the place of a litigated proceeding. So we would do the commentary period as opposed to a litigated proceeding, correct?
In our view, it would provide a new form of flexibility under the terms of a litigated proceeding that we're in right now, which would be presumably approved.
I see. But
I'm not sure I view it as replacing a litigated proceeding. I view it as a flexibility mechanism, thus the portfolio name. That is, suggested as a potential option under this portfolio.
But rather than going through a litigated proceeding on that issue, it would be done through commentary, correct?
Well, I don't view it as replacing a litigated proceeding. I think we're in that litigated proceeding right now, this one.
Okay, but there would be no additional.
I don't think I agree with your assessment or your characterization there.
Okay. Would you agree there's really no reason the commission couldn't apply those dollars to a different portfolio or even a different amount of dollars that have been held back, right?
I'm not sure I understand. I'm sorry, I'm not sure I follow you exactly.
The commission could apply those dollars to a different portfolio if they so chose, correct?
Which dollars? The 119 million?
Yes.
I'm still not following you because there's three portfolios. You could apply the sort of flex concept to another portfolio, and we basically sort of, we're suggesting a process check-in and adjustment element. So I may need a specific example.
Okay. I actually have an example here in a moment that we can get to.
Okay.
The commission could, I mean, in theory, the commission could hold back any amount it chooses, correct? It doesn't have to necessarily be the 119 million. You could apply the flex concept to any portfolio, right?
Yes, I think you could. And we suggested a quantity of holdback that made sense to us in the context of our thoughts on these portfolios.
Okay. So the flexible approach, which you acknowledge the company sees some benefit, again, could be applied to any of these portfolios or spending levels.
I think it could, yes.
Okay. So just quickly by way of an example, the commission could approve a portfolio that is both compliant with the cost cap and also hold back additional funding until the company demonstrates mitigation of rate increases for income qualified customers, right?
I guess I would concur that they could apply the portfolio adjustment process. Because as we see it, it's actually similar to Commission Rule 4733. And it's also similar to what a motion process could look like. I mean, we could come in 2026 and do this through a motion as well as, what we did here is to sort of project it ahead of time. I don't know if I have an opinion about whether they could do that with a sort of conditional judgment on whether rate mitigation has occurred or not. I hadn't thought about that.
Fair enough. Fair enough. So I just have a few more questions, and this time I just want to turn to vertical 2, which is the market transformation portfolio, and I might refer to it as the MTP if that's okay with you.
Right.
So if we can turn your rebuttal to hearing exhibit 116, page 2 in the bottom paragraph. And so what we're looking at here is the executive summary of your rebuttal testimony, correct?
That's right.
So here in this paragraph, you state that you support the commission's approval of an amended market transformation portfolio. Is that correct?
Yes.
Okay. So maybe you can clarify for the record, what exactly has the company amended about the MTP in the company's rebuttal case as compared to what it presented in the company's direct case?
I believe so. I think the main changes occur in there is a hydrogen blending project in the market transformation portfolio as proposed in our direct case. The modification to the amendment, if you will, to the market transformation portfolio refers to 2 other routes of inquiry that we suggested with respect to hydrogen. And Mr. Gardner can go into more details on those, but I could describe those briefly if that's helpful.
That's okay. I think we can talk to Mr. Gardner about that, but it is my understanding that the modification is really only referring to these changes in the hydrogen blending project, right?
Yes.
Okay. The budget is the same overall, correct?
Yes.
Okay. So if I were to state to you that the MTP budget in the company's direct case was approximately $65 million, do you have any reason to dispute that?
I don't think so.
Okay, and if you need to, I can bring it up. I just was trying to save us a little time.
No, I think I'm fine with that, Mr. Smith. Thank you.
Okay. And in your rebuttal testimony, and again, we can go to this if we need to, the budget for the MTP program is approximately $65 million, correct?
Correct.
And no party in this proceeding, to your knowledge, supported the MTP in full as it was proposed by the company, did they?
We had fairly broad support for the MTP as a concept. I'm not sure that, well, there were certainly a number of parties that did not support certain elements in the MTP. There were a lot of parties that did support certain elements in the MTP. There were a couple of parties that supported our original or the amended preferred portfolio. I'm struggling to remember if they opined on the MTP.
I see. And in fact, much of the proposal was actually opposed by several parties, right?
When you say much,
several of the proposals were opposed by several different parties, right?
There were there were several proposals that were opposed by several parties, certainly, yes.
I see. Okay. So and despite the opposition,
the clean fuel, frankly, the clean fuels proposals had more opposition than those that involved electrification, I would say.
I see. Yeah, I would agree with that. So, but despite this opposition, the company did not reduce the MTP budget at all in its rebuttal case, as we've just talked about.
That's correct. We made the modification on hydrogen because we thought it was a good, thoughtful modification to make, having reflected on the answer testimony. But we did not reduce the overall budget of the market transformation portfolio.
Okay, and so if we, and Ms. Federico, I just have one more thing I'm going to ask you to do real quick is go to hearing exhibit 101 at page 93, lines 9 and 10. Okay, I'll give you just a minute for that. And in here, you acknowledge that nothing in the clean heat statute or the commission's clean heat rules explicitly require anything like the MTP. Is that right?
That's correct. We think the value of the MTP is in the early stage of where we are with respect to clean heat and the general objective of reducing emissions in the gas LDC. And these projects made a lot of sense to us, and we had quite a few partners on specific elements of these projects.
Okay. And I appreciate that. And if you'll give me just a moment, I think that is all my questions, but let me just check through my notes here and make sure I don't have anything else. I really appreciate you taking the time with me. I really appreciate your time for getting us started today. I know you have a long day ahead. So Chair, I have no further questions for Mr. Riley.
Thank you, Mr. Smith. Appreciate it. Next up, I have CEC, Ms. King, for 45 minutes.
Good morning, Mr. Eiley. We've met before. I'm Michelle King. I'm here on behalf of the Colorado Energy Consumers.
Good morning, Ms. King. Good to see you.
Nice to see you as well. Commission Rule 4732 requires the commission to consider whether the plan can be implemented at the lowest reasonable cost and rate impact. Do you agree?
I'd like to see that rule, if you would.
Well, we can refer to your testimony at Exhibit 101, page 81. Lines 10 through 12, please.
Appreciate that. Thank you.
So yes, you agree?
I do.
Okay. And you mentioned affordability. Thank you, Ms. Federico. We're good with this one for now. You mentioned affordability in various forms in your testimony, both in your direct and your rebuttal, about 20 times each. And so is it fair to say that the affordability of the Clean Heat Plan is one of the company's critical objectives?
Yes, it is.
And you'd agree with me, wouldn't you, that if we can't transition affordably, we may not be able to achieve the company's or the state's goals?
Affordably is, a pretty broad concept. I think it's important to the company that the clean energy transition, both the economy-wide targets and then the specific clean heat targets. It's important that a good level of affordability is maintained for our customers.
For all customers, right?
Yes.
I wasn't sure if you said our customers or large customers.
Oh, I said our customers.
Okay.
Yes, we can keep all of them. Yes.
In fact, the emissions reduction targets provided in the Clean Heat Plan statute must be met unless the commission finds that a clean heat plan is not cost effective.
I believe it says that, and I do think the commission has a lot of discretion as to render judgment on what is cost effective.
You present several plans for the commission's consideration in this proceeding, right?
Yes.
And so if we can please, Ms. Federico, turn to Hearing Exhibit 116, page 126. Thank you. And there if we can scroll down to the bottom to table JWI R7. Thank you. Mr. Eiley, in table JWI R7, you present the modeled budgets and projected emissions reductions for the cost target, flex base, and emissions target plans. Is that right?
That is right.
And if we look to the bottommost set of data, over the 5-year plan, the cost target budget is $290.7 million. Is that correct?
Yes, and to be clear, that represents sort of the vertical 1 + 2 + 3 total for the commission's benefit, just so we're tying all that together from the previous conversation.
Most specifically, that includes the addition of the market transformation portfolio, correct?
It does.
Okay. And that cost target portfolio responds to the statutory directive to present a portfolio that uses clean heat resources to the maximum practical extent that complies with the 2.5 cost cap in the statute. Is that right?
Yes.
Next, over that 5-year plan, the flex-based budget ranges from $645.1 million to $741.8 million, again, incorporating the MTP. Do you see that?
Yes.
And finally, over the 5-year plan, the emissions target budget is estimated to be 1,371,371.4 million, right?
Yes.
And you acknowledge that the magnitude of costs among the portfolios to reach the 2030 emissions target in the Clean Heat statute are relatively expensive.
I think that's, yeah, if they're achieving the target or getting near the target, they're relatively expensive, relative to, say, the annual gas revenues on the gas system.
They're pricey plans, right?
I don't know if I'd say pricey, but I mean,
but you would say they're relatively expensive.
We're in the realm of synonyms, I suppose. It's, you know, they're significant dollars as set against, you know, the annual revenue currently collected to serve gas customers.
But you would agree they're relatively expensive.
I think the cost.
I can refer you to your testimony if you would like.
I think the costs, that's fine, but the costs are relatively significant relative to the annual revenues we use to serve gas customers.
Okay. You stress that there are many uncertainties inherent in implementing the inaugural Clean Heat Plan, right?
I do.
And the company has never undertaken some of these activities before.
Some of them, I think, yeah, some of them I think that is true.
And for those which the company has previously undertaken and has some experience with, like DSM or beneficial electrification, this Clean Heat Plan presents a never experienced before scale. Wouldn't you agree?
I would agree with that.
It's ambitious.
I think the emissions targets call for it to be ambitious in order to provide some means of reaching them.
Okay. So, Mr. Eiley, I'd like you to keep the numbers in terms of the 5-year costs of these various plans in mind, and we can keep referring back to this document as needed. Okay. But if we can please for now turn to Exhibit 101, page 73. There at lines 12 through 22, thank you, you present the company's plan for flexibility. Is that right?
I'm just refreshing my context on this. This is the plans for budget flexibility.
That's right.
Yes.
Now, you seek, with respect to flexibility, the ability to move dollars between approved mechanisms within a portfolio subject to a cap of 150%, right?
Yes.
And
I would say we modified this somewhat in our rebuttal testimony in response to some of the interveners' answer testimony. I'll just mention that.
Okay. And you seek the ability to move the budget between years, right?
Yes.
And is that still the company's position?
It is. I think it's sort of a lesson learned on implementing programs, especially when you launch inaugural programs. We certainly learned some lessons from the TEP with respect to that. I think it's an important flexibility, but short answer, yes, Ms. King.
Okay. And so to clarify, if you don't use the full budget in a particular year, you want to be able to carry that budget approval for those unspent dollars forward to the remaining years of the plan, right?
Yes.
Next, I'll refer your attention here in lines 21 through 22, where you seek the flexibility across the 5-year plan to spend 125% of the budget. Is that still the company's position?
No, we adjusted that in the rebuttal, and I believe that we reduced that. Well, we altered that such that the 125 applies to BE and electrification and DSM.
The 125 applies only to BE and DSM?
I believe so. I'm going into my rebuttal, and I will, yeah. We can find that in our rebuttal as needed here, but I believe that's the case, that we limited to the 125 asked to the BE and DSM side. So It was sort of a nod to the answer testimony, which generally favored electrification options.
And so with respect to electrification, recall our conversation about the cost target budget that was 290.7 million. Do you remember that budget figure for the 5-year plan?
Yes.
And 25% of that on the BE and DSM is how much? Do you know?
Well, I would say this, the 25% applies to vertical one, not the totality of the 291. So I with respect, I'd probably answer the question as 25% over the electrification and DSM budgets from the compliance portfolio, aka vertical one. Is that fair?
Sure, I'm tracking you. So if we can now flip back to hearing exhibit 116, page 120. Yeah, exactly. Thank you. And so what we're looking at when you say that is that flexibility would apply to, with respect to the cost target, that first tranche of data that's here being the 169.4 million for electrification and the 43.4 for DSM. Is that correct?
Yeah, I would agree. I think the answer to your question is 1.25 times that 212.8.
Okay. And so that would be roughly an additional $50 million subject to check.
Yes.
Okay. And so that $50 million would bring that total budget up to $262 million, upon which we would potentially add level 2 and level 3. Is that right?
I would agree. Yeah.
Okay. Then on the flex budget, that would be an additional 25% on top of roughly $450 million for the flex base, which is the total of the 366.3 and 84.3.
Just to read that back, it would be 25% over the 366 plus 84. Is that what you're asking?
Yes.
Yes, I would agree.
And likewise for the flex high, it would be 25% above the 463 plus 84.
Yes.
Okay. So on the flex high, that's another, let's say, let me do a quick calculation. So that would bring the total of the flex high portfolio to 568 million if we include the 25%. Does that sound right? Subject to check?
That was flex high.
Mm-hmm.
Which is 463 plus 84 times 1.25. I actually think it's a bit higher than that.
Yeah, no, it is. And my math was incorrect. So the 25% of that 463 plus 84, 25% of that is 136 million. Is that right?
25% of 463 plus 84.
Mm-hmm.
That sounds about right.
Okay. And so just as a point of comparison, you're familiar with the company's transportation electrification plan, are you not?
Yeah, I am.
And that incremental flexibility of $136 million, that's more than the company spent on its entire 3-year transportation electrification plan from 2021 to 2023. Is that right?
Maybe you can share with me the value we spent between 2021 and 2023. It sounds
Your budget was $138 million. Is that right?
That's what we spent in those 3 years?
No, that was the approved budget.
Oh, yeah, I think it was, I want to say it was 108, and then it also had a flexibility piece on top of that.
And the company didn't spend the full extent of that, did it?
No, did not spend all of it, no.
Okay, and so when you say on page 74, if we can flip back to the 101, please, and toggle to 74. Thank you. Where you say at line 4, as the company's experience in implementing its first TEP has shown, this flexibility will avoid unintended consequences of limited funding. You acknowledge that the company didn't need that flexibility, the full extent of that flexibility in the inaugural TEP, did it?
I'm not sure I do, because this discusses limited funding for certain programs. And so we're sort of talking about a different level of flexibility, which is inter-program flexibility. So I'm not entirely sure we didn't use that inter-program flexibility, because we had some quite popular programs that I think we had to move funding from less used programs into. So not sure I agree with you.
That's a fair point, Ms. Riley. I appreciate you bringing that up. That's a fair point. But with respect to the 125% of the budget, you acknowledge that the company didn't use that.
In totality, no, we did not.
And if we can just sort of order of magnitude, what the flexibility would be on the emissions, let's go back to the emissions target budget. And if we could toggle back to 116, please. Thank you. On the emissions target budget, we're looking at 125, or we're looking at 25% over and above 720 million and 79.5 million. Is that right?
Yes.
Okay.
It'd be about 200 million.
That's right.
We're even on this one handily.
Okay. And so the flexibility alone would run about $200 million on that emissions target portfolio. Is that correct?
Yes.
And in your testimony on exhibit 101, page 73, lines 22 through 20 at the bottom, thank you, where you reference the 125% flexibility, your testimony doesn't limit that only X% of that 25% flexibility can be used in a particular year, does it?
We did not testify to that, no.
Okay. So in the case of the emissions target portfolio, if this flexibility is granted, it's possible that the company could add, say, $200 million worth of new capital investments, rebates, or some combination thereof in a particular year without seeking commission approval to do so, without seeking further commission approval to do so.
Under emissions target, I think that is true. Yes, I would note that this plan is proposed as a 5-year plan per commission rules. The TEP was proposed as a 3-year plan.
Okay. But to go back to my question where we were discussing whether the company could introduce $200 million worth of new capital investments or rebates or a combination thereof, it could do so in a particular year of that 5-year plan without seeking commission approval to do so. Is that right?
Yes.
And then recover those costs through current cost recovery through the riders.
Yes.
And earn its WACC on those investments. If we're talking about capital and rebates.
Yeah, to the extent the rebates that are amortized, yes.
And so if we can please return back to hearing, if we can go to page 74, please. And there at line 7, beginning at line 7, you state that the flexibilities described here will allow the company to make maximum progress on emissions reduction without burdening the commission with additional and unneeded procedural tasks. Is that right?
Yes.
And so you don't think that ensuring due process in determining whether a plan is cost effective is an unneeded procedural task, do you?
Can you repeat the question? I'm sorry.
Sure, it's not your testimony that ensuring due process in determining whether the plan is cost effective is an unneeded procedural task, is it?
I think it's what we're doing in this proceeding under commission rules that ask for a 5-year plan in the context of a statute that's seeking a 22% emissions reduction by 2030. It's a big task. We have a 5-year pathway that we proposed here per rule. And this is what we found in terms of the magnitudes of dollars that may be needed to do that.
And you noted previously the commission's discretion to determine whether it's cost effective.
Yes.
The commission might want more scrutiny over additional expenditures above and beyond the already relatively expensive plans, right?
I don't know. I don't know if I want to speak for the commission.
And particularly given the competing interest in this plan being affordable, right?
I think I was neutral on the last question, so I'm not sure I can respond to the particular, which I think was amplifying the last question.
But you do acknowledge that the plan needs to be affordable.
Yes,
And that's a core company goal.
it is.
And so if that additional flexibility is permitted, such investments might run through the 60-day process. Is that right?
Can you repeat the question? Sorry.
Sure. If additional flexibility is granted and the company, let's say, wanted to add an additional $200 million worth of new investments or rebates, those additions might run through the 60-day notice process.
The 60-day notice process is generally about establishing new programs, or then the 90-day one for ending programs. That may be possible. I'm just thinking through the hypothetical on that. I'm honestly not totally sure.
Do you want to refer to your testimony on the 60-day notice process? If we flip to page 71, you're welcome to review.
Yeah, thank you. Yeah, I think it's possible. I just hadn't thought through the hypothetical quite that way, Ms. King. I think it is possible under the condition that this plan, that portfolio is approved, inclusive of that 25% flexibility. So those are pretty big conditions. It is possible that you could route additional programming. I seriously doubt it would be in one large swath. I suspect it'd be a series of 60-day processes across a variety of programs. Potentially that could lead into that magnitude.
And so while you seriously doubt that it would be in one large swath, there's no language or agreement from the company that it wouldn't be, right?
Yeah, I don't think we got into that level of detail as far
Okay.
as the application of the 60 and 90-day process.
And so in the 60 to 90-day process, after a 30-day notice period, the company will receive stakeholder consideration and feedback, right?
Yes, that's how it has worked. Yes.
And then the company puts that in a report with some explanation of whether it accepted or rejected the feedback it got and some explanation of why, right?
Yes.
And you propose to eliminate the notice of deficiency process, correct?
Yes.
You assert it's unnecessary as staff and other stakeholders may file appropriate pleadings with the commission, raising concerns that are not resolved in the stakeholder process. Is that right?
It is a fact that they can.
And that's your testimony that that notice of deficiency process is unnecessary. right?
It is a fact that staff and other parties can file motions and other vehicles in these plans.
Ms. Federico, can we please go to page 72? And lines 13 through 19, please. And there, Mr. Eiley, beginning on line 16, carrying into line 17, explaining the elimination of the notice of deficiency procedure, you say it is also unnecessary, as staff and other stakeholders may file appropriate pleadings. Do you see that?
I do, and staff can also comment to us through the process, and other parties can as well.
And there's no discovery afforded in a 60-day notice process.
No.
And so if we bring this to life, let's assume that the company does in fact bring forth a 60-day notice identifying a $100 million distribution investment to support electrification. Do you have that in mind?
60-day process to do what?
$100 million for distribution investment to support electrification.
I don't think we have distribution investments in the purview of this case at all.
How about $100 million of new rebates to support electrification?
I think that's in the purview of the case, yes.
Okay, so let's go with that. Parties provide responsive comments saying it's too expensive or it's not needed through this process. But given the lack of discovery, they don't have the same access to information that the company has. Do you have that in mind?
I do. I'd further point out that we usually have stakeholder discussions to try to educate the parties on this. We don't usually just file a 30-day notice and hope that it works.
But there may not be a paper trail of all of the company's rationale. Would you accept that?
I think there's, an intent and a practice of informing parties.
And so the company informs the parties. Parties provide their comments saying they don't like it. And the company considers these comments through the 60-day notice process and determines to forge on with those rebates, upon which it will earn current cost recovery and a return. And so it's your position, is it not, that these stakeholders and staff can simply file a complaint or some other appropriate pleading with the commission?
Objection, compound.
I'm walking through, permission to respond? Thank you. I'm walking through a hypothetical with Mr. Eiley, and these are the piece parts of the hypothetical.
Maybe just take him through one piece at a time if we can.
Okay. Mr. Eiley, we'll start at the beginning. The company wants to introduce $100 million worth of rebates through the 60-day notice process. Are you with me?
Yes.
And parties within their 30-day period provide comments saying they don't like it. It's too expensive or not necessary. Are you with me?
How many parties? All of them?
Staff and CEC.
And all other parties support it in their comments?
If you want, that works too.
Well, then we're in a bit of a pickle. We usually try to get unanimity with these processes. I think that's the spirit of how the processes work.
But it's
I think 100 million is a fairly extreme hypothetical, but I acknowledge it's a hypothetical possibility.
It's your testimony that parties provide responsive comments, and the company considers those comments and can determine and respond to the comments in its unilateral determination of how to proceed, right?
Under the terms of an approval of a plan where this process has been accepted as a component of that plan, I think that's how it could work.
And so in the absence of the notice of deficiency, even when we're in a bit of a pickle, it's still the company proceeding forward within the confines of an approved plan under this 60-day notice, right?
In the absence of a unilateral option to deploy a notice of deficiency, which is only afforded to exactly one party, which is trial staff or the commission staff, that could happen. In the absence of that notice of deficiency option, any party, including trial staff, can file a complaint, a motion, and can certainly opine to the commission in a channel that makes sense on this hypothetical example.
And any party always has that opportunity, right?
Yes, including staff. That's my point.
And so this doesn't confer any new protections on those parties. It just eliminates the notice of deficiency. Is that right?
The proposal is that they would have the same exact tools as other parties to the case who are equally interested in the case and the implementation of it. Parties that would include parties like the Energy Office who implement programs.
Okay. And so you don't think eliminating a notice of deficiency eliminates a necessary check on the company's discretion to add investments upon which it might earn its weighted average cost of capital?
I don't, because again, any party, inclusive of commission staff, can file a motion or a complaint or other type of action at the commission.
And you maintain that those other parties possess the same quality of information on the company's decision-making as the company has?
I don't know if I would say that. I would say that we attempt to try to provide a rationale for why we're doing this. Again, we try to build unanimity where possible. That can be difficult in Colorado's stakeholder environment. And that dynamic can make it difficult to proceed sometimes.
Madam Chair, I have maybe 7 minutes left, but I'm at a breaking point in terms of subject. So I just wanted to put it to you of how you would like to proceed, if you'd like to take a short break or if you'd like for me to press on.
How much longer did you say you had?
Probably 7 minutes, 5 to 7.
Ms. Boulay, you good for 7 more minutes?
Yes, Commissioner, I'm good.
Okay, go ahead.
Thank you. So Mr. Eiley, next I'd like to talk about rate and bill impacts. And so Ms. Federico, if we can please pull from CEC's box exhibits 2104 and 2105. Thank you. And with respect to 2104, excuse me, Mr. Eiley, do you recognize this exhibit as PSCo's response to CEC Discovery 2-3?
I recognize that it is. I would like a chance to take a look at it if we go into depth on this.
Absolutely. And if we can scroll down, please, just to the sponsor as well. And Mr. Eiley, you are the sponsor of this response?
Oh, yes, yes.
Okay. I'd like to move the admission of exhibit 2104.
No objection.
Okay. No worries. You may proceed. It's admitted.
Thank you. And if we can next turn to exhibit 2105 and scroll so that Mr. Eiley can see the bottom. Thank you. Mr. Eiley, do you likewise recognize 2105 as PSCo's response to CEC Discovery 2-5?
Yes.
And again, you are the sponsor of this response?
Yes.
I move the admission of exhibit 2105.
Any objection?
No objection, noting that this isn't a response over the top of an objection.
Okay. So admitted.
And the objection, just to put a finer point, is that the information sought in the request does not currently exist in that form.
Correct.
So, Mr. Eiley, in these two discovery requests, CEC is trying to understand the rate and bill impacts for all customer classes. Is that a fair summary?
I think it is.
And if we can next look to exhibit 116, and actually this time, Ms. Federico, we're going to attachment JWI-17. Thank you. And if we look to this on page 1, that's perfect. If we look to this on page 1, we see the rider impacts for gas and electric customers. Is that right, Mr. Eiley?
Yes, it is.
And focusing for now just on the electric rate impacts, we see a range of outcomes, and that range gets more variable, particularly in the later years. Would you agree with that?
You are looking at the top one or the bottom one or both?
I'm looking at the electric rate impacts only.
Okay, thank you. It gets, and the question was whether the variability increases over time. I would agree with that.
Okay. And to be clear, these costs, depending on the portfolio selected, those would be recovered through the clean heat support electric adjustment, right?
Yes, that's what this figure is focused on, is the rider piece of this only.
And so with the alternative preferred plan in 2028, let's say, that would be a 0.9% rate impact, right?
That was APP in 2029. Is that what you got?
Oh, I'm sorry, 2028.
2028. Oh, yeah, I'm looking, sorry. I was looking at the table, the figure. I should look at the table. Yes, agree.
And then for the cost target, that would be less than half of that at 0.4% impact, right?
Yes.
And the emission target is 1.7%.
Yes.
And the electrification is 4.1, just so that we're on the same page.
Yes.
Okay. And so whatever portfolio is approved, those CHSEA rider charges would be collected from customers in addition to the charges already being recovered through the TEPA, the Transportation Electrification Plan Adjustment.
Under our proposal, yes, I would agree with that.
And also in addition to those charges that are currently being recovered through the DSMCA.
Yes.
And in addition to the charges that are going to be recovered through the SEPA, the Clean Energy Plan Adjustment.
Yes.
And the RISA.
Yes.
And the handful of other riders that the company has in place, right?
I don't know how many others there are, but yes, this would be additive to the set of riders. I would agree with
In
that.
addition to the TCA,
Yes.
the PCCA,
Yes.
okay, all of the riders.
Yes. If we'd like to have a multi-year plan or future test year, we can probably simplify that field. But for now,
Not today, Mr. Riley.
working on and working with.
And that would be recovered in addition to any base rate increases as they may continue to grow between now and 2030, right?
I think that's accurate. Yes.
Okay. Thank you, Mr. Riley. I have nothing further.
Thank you.
Thank you, Ms. King. Let's see, just want to check in with the court reporter. Would a 13-minute break work for you? Come right back at 11.
That'd be great. Thank you.
Okay, I'll see everybody at 11. Just a reminder, this will stay live, will stay streaming, so please do mute yourself, turn off the cameras during the breaks. See you at 11. Want to check with the court reporter that you're ready to go?
Ready.
Excellent, thank you. All right, we will resume. Mr. Riley, I'll remind you, you're still under oath. Next up is CEO for 40 minutes.
Thank you, Commissioner Gilman. Good morning, Mr. Eiley. We've met before, but just for the record, I'm Jackie Colicchio with the Colorado Energy Office. Nice to see you this morning, sir.
Nice to see you, Ms. Colicchio.
I hope not to use the full 40 minutes, so I will do my best.
Me too.
Just wanted to start our conversation by orienting you to the company's proposals regarding hydrogen. So I'm going to start with the hydrogen blending project today. Mr. Eiley, the company seeks approval of its augmented hydrogen blending demonstration approach as part of its market transformation portfolio, correct?
Yes.
And the company is also seeking unspecified hydrogen amounts in either the amended preferred portfolio or the flex portfolio if one of those resource portfolios is chosen. Is that correct?
I think you stated unspecified. I think we've specified it by a dollar figure.
Correct, but the amount of hydrogen to be purchased is not specified. Is that correct?
It's modeled. I'd say it's indicatively modeled.
Fair enough, sir.
Within our modeling.
Okay, thank you for that. I would like to focus on the hydrogen blending demonstration project first, as I noted. The hydrogen blending demonstration approach is in the market transformation portfolio, correct?
Yes.
And the company is focusing on an updated approach that includes 3 components, right?
I think I can agree with you, but maybe we talk about the 3.
Sure. And those components are, first, the company cited or owned project.
Yes.
And the commercial customer partnership being the second.
Yes.
Both of which would allow for more developmental time and inform the third component, the residential blending demonstration project, correct?
Yes, and I think items 1 and 2 are proposed to operate potentially in parallel, but Mr. Gardner can speak more to that. So 1 and 2 are not necessarily sequential, but
Sure.
I think the combination of 1 and 2 occurring before 3 is part of our proposal.
Thank you for that. I want to call your attention to the residential blending demonstration project. The company states it is extending the timeline for the original proposed residential blending demonstration project, correct?
Yes.
And the company has not proposed any additional budget for the residential blending demonstration project to date, correct?
We have not.
So the residential blending demonstration project has an unknown cost at this time. Is that fair to say?
Well, we originally estimated it at 6 million. I believe it's 6.3 subject to check. So I think that cost indicator is out there. It's fair to say we have moved that estimate toward the other 2 projects.
Sure.
And it's really, to be very transparent, it's really sort of lack of time during the rebuttal turnaround when we made this adjustment to really do a full estimate on these projects. Also, the second one is involving a customer that's not yet been identified. So indicative is probably the best we can represent that budget estimate at.
Sure, but to confirm, in the company's rebuttal case, there is no updated cost estimate for the residential demonstration project.
No.
Thank you. But the company is proposing in the flex budget proposal, $119 million flex budget that may be used for this blending demonstration project through a check-in process. Is that correct?
I don't think so. I think the intention of that 119 million, that's called the flex reserve funding, is really toward the compliance portfolio and not commingled with the market transformation portfolio. So there's some separation of the budget concepts there, if that makes sense.
That's a fair point, sir. I just wanted to call your attention. If we could pull up hearing exhibit 116. Thank you so much. I'm looking at page 118 of hearing exhibit 116. Thank you. And Mr. Eiley, if I could just turn your attention to lines 6 through 8 of this description of the residential blending project. looking at the company proposes to provide an update on this project at the check-in point. So that proposal would not have a budget request associated with it?
It's a good nuance you bring up. So the check-in process is sort of a process point as well as this reserve budget holdback, if you will, budget reserve. The 119 million is really meant to be for the compliance portfolio. We did propose to have a discussion with the commission essentially at the same contemporaneous in this check-in process.
But to be fair then, sir, this check-in process, we would get an update, but not a budget request and not a request for that flex budget that's mentioned?
Can you repeat the question? I just want to make sure I'm tracking accurately. Sorry.
Totally fair. It's also been a long morning already. So I'm gonna just break it into pieces. So there's going to be a check-in process.
Yes.
That check-in process, we would receive an update on this particular residential blending demonstration project.
Yes, and it would also sort of include the update on the other activities, sort of steps 1 and 2 that we discussed.
Sure.
Yeah.
But you are still seeking approval for this project.
Yes.
Without a budget.
Potentially without a budget, it's in the overall $65 million for the market transformation portfolio. We did move the budget dollars toward projects 1 and 2. So there may be some need to adjust the budget for this third piece, depending on how the spending goes on projects 1 and 2.
Sure. And while not intended, as you referenced, the 119 million could be used to fund this project, correct?
That's not the intent.
Fair. It's not the intent, but it could be. There's a possibility.
I guess I'm getting into questions of how separated the dollars are. I mean, if there's a request to fund this project, it will be charged to customers. I don't know that it's included in that 119. I don't think that was our intention. Like the 119 was really meant to be for quote unquote vertical 1. We're in vertical 2 here.
That's fair. I'll move on, Mr. Riley. Thank you for your time on that piece.
Yeah.
I want to focus a little bit on the check-in process more. The company would provide all of the details of this new project through this check-in process, which we've confirmed is a comment process, correct?
Which project are you referring to?
I'm still on the residential blending demonstration project, sir.
Okay.
Go ahead.
Yes.
Okay. And there would be no opportunity for interveners to file testimony, correct? It would just be a comment.
It would be a comment in front of the commission. Yeah.
And there would be no opportunity to conduct any additional discovery. Is that correct?
As proposed, and I could elaborate on our thinking on that process as appropriate.
That's fine, sir. I think it's adequately described in your testimony, but if I need to, I'll bring you back to a certain piece. So just to summarize all of this, the company is seeking approval for this residential blending demonstration project without a set budget at this point or project details at this time.
It's seeking approval on the project that we proposed in our direct case, for which parties have had full opportunity, I would say months, in fact, of discovery opportunity on this very project.
And yet these unknown costs would be recovered through a proposed rider. That's correct?
The rider would cover the market transformation portfolio. And yes, there could be, I suspect it could be an adjustment around the market. You know, there's $65 million in the market transformation portfolio. I think we can have a discussion on how that set of funds in those projects are working at that point in time.
Thank you. And the company is not committed to date for this project to use green hydrogen, correct?
I don't think we committed to exclusively that. I think we made statements that we're very interested in obtaining green hydrogen. It's a little early in the hydrogen market to guarantee that. So I think Mr. Jensen and Mr. Gardner can address that one a little bit more fully.
Thank you for that, Mr. Riley. I appreciate that. I'm going to move your attention now to the hydrogen proposal and the flex and amended resource portfolios. Okay?
Yep.
Thank you. If either of these portfolios are chosen by the commission, the company is requesting approximately 25.8 million through 2028 for hydrogen. Is that correct?
Yes.
Thank you. And that would include both blue and green hydrogen.
Again, focusing on green, but there's a potential for some blue in that mix as well. Intending
Sure.
it to be blue with carbon capture if at all possible.
Great. No, thank you for that clarification. I know we have hearing exhibit 116 up. If we can pull up page 96. And I'm looking at JWIR4, that table of the base. Thank you. And it does, I just wanted to note, there is a separate budget proposed for blue hydrogen in both 2027 and 2028 at this point, right, Mr. Eiley?
Yes, I think that's what the model indicated. You know,
Sure.
when it was economically optimizing based on the inputs it had, that's what it was picking.
Thank you. And that 25.8 million would be recovered through a proposed rider, correct?
Yes, along with the rest of the clean heat program. Yes.
Thank you. But to date, the company has not proposed any hydrogen projects related to this budget. Am I correct?
Not to the Public Utilities Commission.
Okay. Thank you. And in addition to not proposing any specific projects to the Public Utilities Commission at this time, the company has not proposed the amount of hydrogen it intends to purchase. You had noted that if the model based it on cost. Is that correct?
It's a result of the modeling which we employed to try to represent a potential cost-effective outcome toward the emissions targets, and this is what we got from it.
Sure. You noted the company would have the burden of bringing forward data regarding the implementation of different clean heat strategies, including hydrogen strategies, if we were to go into the flex portfolio, correct?
Yes, at the flex check-in process, it sounds like you're referring to.
Yes, sir.
Yes. Yeah.
And based upon this data presented by the company, the commission could evaluate whether there is benefit to augmenting funding for any of these strategies, including hydrogen. Is that correct?
Yes, I think that's the spirit of the proposal. Indeed.
Great. And if the use of flex dollars were approved, the company could increase the affected budgets accordingly, starting, I believe you said January 1, 2027.
Yes. Yeah, exactly.
And that would include the hydrogen budgets referenced in this chart.
Yes, if it were the commission's preference to do that, they could do that.
Great. So the $119 million that we were previously discussing is a holdback of funds. That's fair to say, that may be used to increase these budgets. Correct?
It is directly in response to our, one response to the collection of answer testimony. We pulled the money out of the recovered methane budget, which was larger in the amended preferred portfolio. We created this kind of reserve fund, if you will,
Great.
and proposed it for that process. It could increase any of the budgets, including electrification. In fact, we sort of noted that could be one that we're willing for that to happen in. So it was a potential move toward electrification under the conditions of the flex check-in process.
Great, thank you for that. And that $119 million, wherever it is allocated, would also be amortized over the company's 15-year timeframe, am I correct?
To the extent it is in the form of amortized rebates. So there's a couple of conditions there. So is it dedicated toward electrification? Is it in the form of a rebate? Witness Mr. Mark has some views on what will be rebate levels and what will be administration costs. So
Sure.
I don't know. I actually doubt that a full 119 million could be amortized in that way. I think it's going to be less, even under the condition that it's 100% allocated toward electrification.
Thank you, sir, and I apologize for interrupting you. I was just going to clarify. But any monies allocated from this 119 million to any of these these clean heat resources in this chart would be amortized.
Can you repeat the question?
Sure. Just to clarify, any monies allocated from this $119 million budget would also be subject to the amortization.
If they're in the form of amortized rebates.
Okay. And the company would review data presented, and the commission would review data presented by the company to support any of these projects, including the hydrogen projects.
Yes, in accordance with the commission's rules on clean heat and also any other evidence that we feel is appropriate to support the approval of the additional spending.
And to clarify, under the company's proposal, without any discovery or testimony allowed from the parties.
Yes, and discovery and testimony was allowed on the totality of this portfolio and larger portfolios throughout the course of this proceeding since August 1.
Thank you, sir. I'm going to move on to disproportionately impacted community and income qualified customer spending.
Okay.
In the revised portfolio, you stated the company would dedicate 20% of beneficial electrification and demand side management spending for income qualified customers in DI communities. Is that correct?
Yes, yes.
And in Miss Ottison's answer testimony, she's hearing exhibit 501, CEO had recommended this 20% to be a floor and not a ceiling. Are you aware of that, sir?
Conceptually, yes.
And that would mean the 20% is the minimum budgetary amount that would be dedicated to beneficial electrification and demand side management spending for IQ and DI communities.
Under Ms. Ottison's proposal, yes.
Thank you. And can you please clarify for the record in the company's rebuttal case, whether this 20% of the BE and DSM spending is a floor?
No. It's our original proposal. We did not.
It is still your original proposal.
Yeah, we did not accept Ms. Ottison's proposal.
Thank you for clarifying
I'm
that.
getting the name exactly right. We've only met once or twice.
That's okay.
Okay.
No, I appreciate that clarification, CEO. It was not
Yeah.
clear.
Yeah, okay.
Thank you. I'd like to move to your transfer fee position, Mr. Eiley.
Yes.
So in rebuttal, you noted the company does not oppose CEO's recommendation for a transfer fee. Is that correct?
Yes.
However, you added the caveat, if the commission decides to include transport customers in clean heat programming and cost recovery as proposed by Denver, this issue may be best left for an M docket. Correct?
Yes, I would agree with that.
Thank you, sir. And are you aware that the city and county of Denver filed cross-answer testimony in this proceeding?
I am aware of that, yes.
Thank you. And in that cross-answer testimony, Denver noted CEO's recommendation for the commission to adopt a transfer fee would be a fair and reasonable step to prevent customers from opting out. Is that correct?
I actually haven't seen that. Apologies.
That's okay. If we can please pull up hearing exhibit, I believe it's 1801.
Sorry, I'm getting there. I just got to scroll all the way to the end of the sheet. Just letting you know I'm getting it.
I appreciate that. And thank you so much. And I'm on page 27. Bottom of 27, line 19 through 21 and the beginning of 28. Thank you so much. Mr. Eiley, I know that there's been voluminous testimony filed in this proceeding, both answer, cross-answer. But just to refresh your recollection, given that you said you were familiar with Denver's filing cross-answer, if I could just call your attention to lines 19 through 21. And it's saying that Mr. K, on behalf of CEO, offered a simple solution.
Yes.
Thank you. And then on the following page, that it would be a good first step or fair and reasonable step, excuse me. The print is very small for my broken eyes.
Yeah, no, I agree. And thank you
you
for indulging me on that. It is, I would say my own testimony is voluminous, so I'm doing it again.
I think the parties in this proceeding would agree, sir. So now that Denver has endorsed CEO's proposed transfer fee as a fair and reasonable step, would the company commit to developing and proposing this transfer fee as a part of this proceeding?
I think we're more interested in having a more holistic conversation in the M docket that we propose, which gets into a variety of these seams issues. I agree the concept has merit. I think that's more or less what we stated in rebuttal. We are concerned with a sort of an unintended consequence of transport customers wanting to leave the system because they can basically evade the cost of the clean heat plan. So like the idea, I think it's a more holistic discussion inside the M docket that we recommend rather than something in this proceeding.
Understood, Mr. Eiley. Thank you for the clarification. I have no further questions for Mr. Eiley today.
Great, thanks, Ms. Corfield. Appreciate it. Next up, I have Conservation Coalition with 30 minutes.
Thank you, Commissioner Gilman. Good morning, Mr. Eiley. Good to see you again. How are you doing?
Good. Good to see you, Mr. Gerhardt. How are you?
I'm fine, thanks. So I wanted to start with the topic of eligibility for beneficial electrification incentives.
Okay.
My understanding is the company is proposing that gas-only customers not be eligible for BE incentives in this plan. Is that correct?
Yeah, that's correct. And just to link conversations, that's similar to that M-docket discussion I just had with Ms. Colicchio. There's threads to that there too. But yes, that's correct.
Great. So I want to ask you some questions about the potential implications of that. Your testimony was that around 28% of the company's total gas customers are gas only. Does that sound right?
Yes, it's in the range of 400 and some thousands. I think it's in my rebuttal, but yeah, I think we're on the same.
Okay. And I can pull up the discovery response if you need to, but of those 400,000 gas only customers, around 373,000 are residential gas only customers. Does that sound correct? Subject to check?
Honestly, I'm not sure on that. If there's a discovery response in the record or something, we may visit that.
Sure. Ms. Federico, would you be able to pull up attachment AMC-15? That's an attachment to hearing exhibit 602.
Yeah, you said AMC 15, is that right?
Yes, yes.
Just a second.
Mr. Eiley, if you want to take a moment to review this and just let me know when you've had a chance to do that.
Yeah, thank you. Thank you for the opportunity.
Of course. So this is a discovery response that you sponsored?
Yes.
Okay. And it looks like in the first row of that table, you have a little over 370,000 residential gas-only customers.
Yes.
Okay. So going back to the company's proposal, those 373,000 residential gas-only customers would not be eligible for BE incentives under the company's proposal, at least for this particular plan.
Yes, that's correct.
Okay. Would you agree that all else equal, reducing the number of customers eligible for BE incentives would tend to make achievement of any given BE target more difficult?
A BE target or an emissions reduction target, or yes?
A BE target.
I'm struggling to recall if we have a numerical BE target as part of statute. We do have emissions targets.
Sure. Let me rephrase. If you have a portfolio that is attempting to achieve a certain amount of reductions based on achieving a certain amount of BE, would you agree that it's more difficult as you reduce the number of customers eligible for BE incentives to hit
Yeah,
that?
I would agree that the objective of reducing emissions will be more difficult if we have fewer customers that would be eligible for the incentives under these types of programs.
Okay. I want to turn towards discussion of this issue in your rebuttal. And we can bring it up if you need to, but My understanding is that one of your rationales for limiting eligibility to dual fuel customers was a concern that it would be unfair to have gas customers pay for a customer who electrifies and is no longer on the company's gas system.
Yes,
Is
that's
that fair? Okay. Would you agree that that rationale applies only to a gas customer who completely electrifies?
Did you say only? I'm trying to remember the exact framing of your question.
Sure, I can rephrase. My understanding is that your concern is really focused on a gas customer who electrifies all of their uses of gas and completely departs the company's gas system. Is that fair?
That doesn't represent my view. I think customers who are reducing sales substantially on the gas system also create this dynamic.
Would you agree that the company anticipates that most customers who electrify will do so piecemeal and continue to use some amount of gas?
I don't know that we've testified to that. I'm not sure I want to make that market prediction fully.
Would you agree that it's possible for customers to electrify only a particular end use? For example, only a water heater or only a space heater, and continue to use gas in other appliances?
I think it's possible, yes. I guess I hedge on this because I don't know if the market will start to develop, more holistic electrification packages and roll that into one's home mortgage. Like I see opportunity for innovation there. So I hesitate to kind of wager which way this goes over the next 3, 5, 10 years. But I agree with you that scenario is possible, yes.
I want to switch for a moment to a different topic. And again, happy to bring up your rebuttal testimony if that's helpful. But one of the things you testified to in rebuttal was that you recommend the commission base its decision on existing laws and policies and not assume future changes to laws and policies. Do you recall that?
I would like to bring the rebuttal up.
Certainly.
Just for your benefit and the rest of the attorneys, I'm going to be a little bit merciless about that, considering I'm covering 380 pages. So I realize there's a little bit of conversational friction, but just for the benefit of a cleaner record, it'd be great.
That is fine, Mr. Eiley. Ms. Federico, could we bring up Mr. Eiley's rebuttal? So it's hearing exhibit 116 and turn to page 31, please. So Mr. Eiley, the statement I'm referring to is on lines 2 to 4, if you want to take a look at that.
Yes.
Great. So my understanding is you're recommending that the commission base its decision on laws and policies as they stand today and not assume future changes to laws or policies. Is that fair?
Yes and no. I mean, I think it's a dynamic policy environment. I would acknowledge that. I think we're all trying to track that environment for planning and policy making purposes. I think we saw some pretty extreme assumptions, in my view, on policies that may come to pass, which could drive certain modeling outcomes.
Okay. Whatever approach the commission were to take with respect to assumptions around laws and policies, would it be your recommendation that the commission apply that equally to all portfolios it's considering?
I don't know. I don't know. I suppose so.
Okay. I want to turn back to the BE eligibility issue that we were just talking about. And Ms. Federico, could we scroll down to page 67? Okay. So Mr. Eiley, if you want to take a moment to review lines 1 to 16 and let me know when you've had a chance to do that.
Thank you. I have, thank you.
Great. So to summarize, my understanding is that you're providing another rationale for limiting BE incentives to gas-only customers here. And that rationale is to be on an equal footing with Black Hills and Atmos, who you say have proposed to not have BE in their clean heat plans. Is that fair?
I think it's fair as far as it goes. I think we have some other testimony here that describes kind of establishing a mental model that, frankly, Piesco has the largest gas-only utility portfolio in the state. If you just separate those 400,000+ customers, we have a substantial gas-only footprint, LDC. We're pointing out that we are in that section of customers, we look very much like Black Hills and Atmos.
Okay, thank you. You're aware that, as far as you know, the commission hasn't issued a final decision in the Black Hills and Atmos clean heat plan cases?
I don't believe they have. I think those cases actually followed ours in terms of the filing schedule. I think they were submitted several months after ours, so I think they've not been ruled on yet.
Okay, and you'd agree it's possible for the commission to not approve every element of their proposals?
Yes, along with ours.
Okay. So I guess what I'm trying to understand here is to what extent are you asking the commission to make a decision here based solely on an application that hasn't been ruled on in the Black Hills and Atmos cases?
I think we're asking the commission to look at this issue in the merits of our case, and we're just noting that there are other cases here that have similarities to them, to ours.
Okay. So the last topic I want to cover is certified natural gas, or CNG. Ms. Federico, would you please scroll down to page 115? And Mr. Eiley, if you would please take a look at the sentence that appears on lines 6 and 7. It starts with, "but I fear." And let me know when you've had a chance to review that.
I have.
Okay. And so this statement is appearing in the context of the company still requesting approval of some amount of CNG in the what you refer to as the third vertical.
Yes.
Okay. And this statement here is made in the context of various interveners raising questions about counting for CNG and to what extent it would produce incremental emissions reductions. Is that fair?
Yeah, it's in the context of this consideration of a clean heat plan, which has a good discussion and appropriate discussion around what is eligible under the clean heat plan. But the clean heat plan is a component of state policy seeking to hit a 50% economy-wide emissions reduction objective. So we're saying that this can be a tool to help toward that, and it appears to be relatively cost-effective compared to other eligible things that are eligible under 264. And it's a, you know, we really want to focus on methane. Methane is an international and national focused emission, and we're emission reduction objective. We're trying to bring a tool that we think can help with that.
Sure, understood. Would you agree that the primary, enough, if not the only rationale for spending ratepayer dollars on CNG would be to yield incremental methane emission reductions?
Could yield significant methane emissions reductions at low cost, probably lower cost than some of the other options in our modeling under clean heat.
Sure. What I'm driving at is if CNG were used, once it enters the company's gas system, it largely burns the same in customer appliances as non-CNG methane, correct?
Correct.
Okay. So in terms of direct use in appliances, CNG doesn't offer any direct benefits to customers compared to non-CNG.
No, I don't think so. Again, the benefit is it's upstream, and I think we represented it as such. And I'm, you know, kind of underlining that this is about compliance with the state's overall greenhouse gas objective. But I would agree with you.
Okay, so the extent to which, so the only real benefit that is on the table for CNG is these potential methane emission reductions. Is that fair?
The benefit on the table is about 300,000 tons of CO2 equivalent methane reductions. I think that's significant.
Sure, but going back to your statement on emissions accounting, the emissions accounting issues that interveners have raised go directly to this issue of whether CNG would in fact yield incremental emissions reductions.
Some of the questions do. Some of the questions are about whether it's eligible under 264, under Senate Bill 21-264. Ms. Quillian can talk to you in more depth about how, you know, how many emissions reductions are really achieved.
But you would agree that if CNG did not in fact yield incremental emissions reductions, that would really defeat the purpose.
I don't think that we would propose CNG that didn't yield incremental, incredible emissions reductions that were upstream.
Okay. Thank you, Mr. Eiley. I have no further questions.
Okay, let me see. I've swept for 50 minutes. Mr. Hyatt, do you think you'd be able to give us like 20 or 30 or so?
Yes, and I believe Ms. Kutzer for COSA might have a suggestion here that would help too.
Okay.
Yes, Commissioner Gilman, we have 30 minutes reserved. I think it'll be probably more like 15 minutes. We're willing to kind of skip the order and go first if that would be helpful to get done with us before lunch.
Sure. Then we don't have to break up Mr. Hyatt. Any objection to that, Mr. Larson?
No objection. Thank
Okay,
you.
great. Okay, let's go with COSA and we will just change up the order a little. Thanks, Ms. Kutzer.
No problem. Thank you, Commissioner Gilman. Mr. Eiley, it's nice to see you.
Nice to see you, Ms. Kutzer, earlier than I expected.
Yeah, earlier than we expected. I'm going to be asking you a couple of record clarifications to start out with. Could we please pull up Hearing Exhibit 110, page 49? So I believe this is one of the two versions of your supplemental direct testimony. And here on page 49, you refer to a commission request to provide the avoided gas infrastructure costs and incremental electric infrastructure costs that are going to be associated with the clean heat plan. Do you recall that?
Yes.
And Ms. Frederico, could we go ahead and pull up attachment JWI 5 that's referred to in this response? I think that's the supplemental direct JWI 5 just for labeling. Ms. Federico, would you mind blowing that up a little bit more? Sorry, my eyes are going. Thank you. So, Mr. Eiley, do you recall the preparation of this attachment?
Yes.
And just staying here for one moment, I want to ask you a couple of brief questions about where these numbers stand in light of your rebuttal case. So have you made any changes to these calculated either incremental electric capex calculations or avoided gas capex calculations in light of the rebuttal case?
Thinking through this, there are several steps of analyses that have worked through this case. We may need to talk with Mr. Oss about this a little bit too, because we have done some updated cost benefit analysis. I think they're going to be pretty similar. I believe that cost target would be the same and emissions target would be the same. Excuse me. Clean Heat Plus is likely adjusted, and I may need to confirm that a little bit. And I think electrification only would be the same or very similar.
So, subject to check, I have looked through the rebuttal case put forward by the company. I have not seen any updated calculations provided. Are you aware of providing any updated calculations, or has another witness done that?
I may ask you to discuss this with Mr. Oss in terms of he would have brought this into the cost benefit analysis pieces, which were recently updated. And so there may be some updates on these. These are sort of input factors. They're input, I would call them input factors to the cost benefit analysis.
So to maybe put just a finer point here for clarification of the record again, you have not updated this standalone table in any way, shape, or form. This has only been captured in Mr. Oss's updated cost benefit calculations. Is that your testimony?
Well, yeah, you're testing my memory. I don't know that we updated this table, but we did recalculate, especially for the flex portfolios, we recalculated customer bill impacts in my rebuttal. And the equivalent of these numbers, I believe, lives in the work papers that underlie the calculation of the customer bill impact, which is in my rebuttal on page 128.
Great. Impressive recollection of the record. If helpful, of course, to the commission in its deliberations, the company could, of course, prepare a similar table as it did in your supplemental direct to set these costs specifically aside instead of.
Yeah, I think that's pretty doable. At the end of the day, these costs are derived by calculating estimated increases in system peak demand by a factor of potentially, increased costs on incremental generation, transmission, and distribution. It's kind of a multiplication exercise. So I believe we could extract this from the work papers and update a table like this, if it's helpful.
Great. I will let the commissioners decide if that's helpful or not. So I want to ask you a couple of questions about cost recovery here. I believe in response to Ms. King's questions, I heard you say electric distribution system investments aren't in the purview of this case. Do you recall that statement?
I think so, and they're not particularly. They're just information informing these decisions.
So can you explain to me if the incremental electric CapEx that's displayed on this exhibit is proposed to be recovered through either of the riders, the rate riders that are proposed in this case?
No, good question. The riders are proposed to cover program costs associated with the clean heat plan. These numbers are provided as supporting information, and they are reflected in similar fashion in the cost benefit analysis. We showed them in a table in my direct testimony as well. But they're not, to your question, they're not intended or proposed to be recovered through the riders, I should say, in this clean heat plan.
And so then would it be fair to say, Mr. Eiley, that the incremental electric CapEx costs would be discussed as a part of the company's forthcoming distribution system plan filing?
Yes, I think this would be a component of that discussion, which will benefit from an approved clean heat plan.
And at what point would the company seek permission or a determination from the commission to recover those incremental electric CapEx costs?
That conversation could begin in the distribution system plan. Historically, these costs have been recovered through rate cases. Distribution is one of the places where a rate case has been the main mechanism by which we propose to recover distribution costs.
Okay, great. I'd like to move on and talk about clean fuels with you. Ms. Federico, could we please pull up Hearing Exhibit 116, specifically page 70? So here on line 3, when you're talking about intervener answer testimony regarding clean fuels, you start by saying, notwithstanding express statutory authorization for the use of clean fuels. Do you see that?
I do.
Mr. Eiley, would you agree with me that the legislature has not mandated that the company use clean fuels as a part of its clean heat portfolio?
I don't believe they have. I think they've suggested it as an eligible technology, which we analyzed and proposed to some extent. Okay,
great. Now, you and I have spent a lot of years doing this at the commission. Do you also agree with me that this commission has broad statutory and constitutional authority to regulate public utilities and determine if investments that they make are prudent?
I think that's a broad statement. I think they often apply that general authority against statutes to interpret the will of the Colorado General Assembly.
Great. So sticking with clean fuels specifically and talking about renewable natural gas and certified natural gas, at the end of the day, are these products methane molecules that run through the natural gas system that are the same as the methane molecules that are derived from traditional sources?
For CNG, I think it's extremely similar to conventional, fossil-derived natural gas, if you will. For RNG, there are standards that allow the injection of RNG into pipelines. They may not be exactly the same, but pretty similar to fossil-based natural gas, if you will.
So you and I aren't chemists, but at the end of the day, it's methane molecules that are being procured from each of those sources, correct?
Yeah, methane, there's a bit of ethane in there. I did have
Okay. And would you agree with me further that these methane molecules end up being used in the natural gas system in the same way that methane molecules derived from traditional sources are used?
Yes.
Okay. So will you further agree with me that the certified natural gas and renewable natural gas methane molecules are, generally speaking, more expensive than traditional methane sources?
Traditional methane sources being undifferentiated natural gas?
Correct.
Yes,
procured and extracted through traditional means.
Yes, I would say CNG appears to be available at a pretty small price premium in our assessment, and then RNG is more expensive typically than conventional natural gas.
So putting this all together, including our discussion of the commission's authority, will you agree with me that one decision this commission has to make in this proceeding is whether or not it is prudent to allow the company to spend a higher amount of ratepayer dollars buying CNG and RNG methane molecules than it would on traditional sources.
Yes, in the context of a natural gas system, which will have throughput that clearly continues past 2030, which we've illustrated in our rebuttal testimony, the commission needs to decide whether it wants to pursue some activities that can reduce emissions associated with that throughput of natural gas, which will continue certainly through the course of this clean heat plan.
And Mr. Eiley, does the cost difference between a unit of traditional methane and a unit of renewable natural gas change over time?
I'm sorry, between which?
Between traditional methane and renewable natural gas, does that change over time?
Yes.
Okay, great. And has the company presented an analysis of the expected difference between traditional methane and renewable natural gas prices during the time period of the Clean Heat Plan?
Our modeling was seeking to and achieved a model of cost-effective selection of resources. So it looked at RNG, it looked at electrification, and it looked at RNG with respect to the cost of conventional gas, because that is the cost input to the model. So there's a representation in the model that E3 had, and I'd encourage you to discuss that with Mr. Oz.
So your testimony here is that the analysis of the difference between traditional methane and RNG is contained within the modeling analysis that E3 performed.
I believe that's true, and I believe that would be true across the 5 years of the portfolios.
Okay, great. Let's move on from this topic. So I'd like to confirm, and if we could go to page 96, Ms. Federico. As you've put forward the flex portfolio here, the company is now proposing to spend at least $20 million annually on RNG until the 2026 check-in, correct?
I wouldn't put it as at least. I think that's our recommended budget amounts that we're proposing within this flex portfolio. It's not necessarily a floor statement.
Would you like to spend more than that?
Subject to the flexibility mechanisms that we discussed earlier, that could be a possibility depending on how the economics and availability of our recovered methane look compared to the other options. So within the context of the flexibility mechanisms, which are on page 83 of my rebuttal testimony, I refreshed on break, potentially it could, but it could also be lower depending on availability of methane.
Okay, that's helpful, Mr. Eiley. I do have another budget question. Ms. Federico, could we turn to page 126? This is table JWIR-7 that you looked at with Ms. King. And I'm going to be asking you to look at the recovered methane budget specifically in that flex base. So do you see there that there's a 90.8, and I believe that's millions of dollars set aside there in the flex base for recovered methane. Do you see that, Mr. Eiley?
Yes.
So I'm having a little bit of trouble figuring out how the company got to $90.8 million, given the fact that you've proposed to spend $20 million annually from 2024 to 2028. Could you, subject to check, of course, my math would be $20 million times 5 years equals 100 million. Assuming you agree with that simple math, can you explain to me how you got 90.8 million here in this table?
Yes, I agree with your math, number one. Number two, I share your confusion because I was kind of inquiring on that a little bit too in the last few days. So it gets into how we model this. So the way that the E3 model is intended, it operates, is that it's seeking a cost-effective optimization of different resources. By contrast, when we propose the flex portfolio as a response to answer testimony, we were sort of running the model backwards. We were saying, we think we want to spend about $20 million per year on recovered methane. So instead of the model telling us the level, we were telling the model that. And so the model had to go back and iterate, and on the time available, we weren't necessarily able to iterate it exactly back to $100 million 0.0. So it's a bit of a modeling iteration issue, and I think Mr. Oz can probably explain that more fully and elegantly than I can.
So from a ratepayer perspective, what are we to expect the budget on renewable natural gas will actually be?
I think it's the 100 million that you calculated in the earlier table. That's the intent in the proposal of the flex portfolio. The model didn't quite catch up to that exogenously determined number.
Okay. I'd like to spend a moment here looking at the expected emissions reductions associated with renewable natural gas. So appears to me in this table that that's the next column over, and it reflects 119,242 tons of CO2e per year. Is that correct?
Yes, I believe that's correct by 2028.
So that's a cumulative number over the first 5 years of the Clean Heat Plan. Is that an accurate statement?
Yeah, the budget is cumulative. The 91 million is cumulative, I believe. Well, I think it accumulates to achieving this level of reductions in 2028. There's a couple ways you can use the word cumulative in that statement.
Okay, fair enough. Ms. Federico, I'd like to have this available, but could we also pull up attachment KMH18 to Mr. Hayes' testimony, which I believe is hearing exhibit 500?
I'm going to pull up the public version, correct?
Correct. Thank you. Yes, we'll keep this public, this discussion public. So while she's doing that, Mr. Eiley, is it fair to say that the company is still in the process of procuring sources of renewable natural gas that would be used in the Clean Heat Plan?
Yes, we won't sign a contract, I don't believe, until we have approval to proceed, but we're assessing the market.
And so in response to discovery from CEO, and if Ms. Federico, you could scroll down, I believe there's an attachment here, and it's the public spreadsheet. I'm hoping it's the public spreadsheet. Yeah, thank you. So this was were the responses that you got when the company sent out an RFP looking for sources of renewable natural gas, correct?
Yes, and the sponsor on this discovery response is Mr. Weinberg, who is a witness and available and in this building for this hearing.
Appreciate that. I'm going to keep this high level and hopefully move through this pretty quickly. So just a couple of questions. I see here that there's a column, and Ms. Federico, could you blow that up just a little bit? Thank you again. Indicative carbon intensity score there. I see that number differs based on the different responses to the RFP. Do you agree, Mr. Eiley?
Yes.
So is it fair to say that depending on the source of the RNG that the company procures, the emissions attributes are going to differ based on these responses that the company received to the RFP?
Yes, they can, and I would certainly encourage further questions from Mr. Weinberg. He will bring more to this than I will.
So is it also fair to say that the emissions reductions number that you presented in your rebuttal case could change dependent on the source of RNG that's procured?
It potentially could. I think I've been pretty clear about the uncertainties in basically every one of the compliance mechanisms we could use under Clean Heat.
And when does the company expect to have a final answer as to the source of RNG that it's going to procure for the Clean Heat Plan?
I'm going to refer you to Mr. Weinberg for that.
So we won't have finality about the expected emissions reductions until we have a source. Do you agree with me?
Objection asked and answered.
Ms. Kotzer, any response?
I think it's important to drive home the point that he's admitted that there's difference in each of the bids, but I want to understand in the real world, how is this going to apply in terms of different emission reductions? So I don't think it's asked and answered. Sorry.
Mr. Riley, if you're able to answer on a clear answer, that would be.
Can you repeat the question, Ms. Kutzer?
Sure. I think putting it all together, is it fair to say that the company will not have finality about the emissions reductions that will be experienced through its procurement of RNG until it has a source of RNG identified?
We will not have finality on emissions reductions from electrification, demand side management, RNG, CNG, until we have further development across all these activities.
Fair enough. Thank you, Mr. Eiley. Commissioner Gilliman, that's all the questions I have.
Very appropriate timing here, right at noon. So real quick before we go to lunch, I forgot to just ask folks in the beginning, if anyone is planning to need a confidential session, it would be very helpful to know that in advance so that we can plan the schedule and get our staff lined up. And oftentimes we'll do those at the beginning or end kind of a session or before a break so that we can stack the room appropriately with who's allowed to be in there. So to the extent anyone needs that, please do it when we come back from the break or sometime later today or tomorrow morning. Let me know if you do anticipate needing confidential sessions for anything. That would be helpful. That being said, I do anticipate that I will do a confidential session with Mr. Riley. It looks like it'll be toward the end of the day today, the way the timing's going. And Mr. Larson, I just want to run by you, looking to go over some details from JWI 4. It's an executable attachment. I was not personally clear, is all of the information in the attachment considered confidential by the company, or is it just like gas commodity price forecast that we need to try to not show, just so I can understand your perspective on that? That would be helpful.
Yeah, thank you, Commissioner. We're in the process actually of looking through that, and we're going to do that over to lunch break. And as soon as we come back on, maybe we can pick up whether it needs to be in confidential session or not, if that
That
works.
would be helpful. And if it's just don't show the GCA page, I think I can get away with that. But it would be helpful to understand from you if we need to go into session.
We're looking at that in real time right now.
Thank you. Really appreciate it. Mr. Tate.
Thank you, Commissioner Gilman. A quick question. With respect to the confidential session you're anticipating and perhaps others, what needs to be done to make sure that I have executed the necessary documents to participate? I know I've executed some of the confidentiality agreements. I just want to make sure I have them all covered so that I don't miss any of the confidential sessions.
I think that's just a situation I need you to confirm with Mr. Larson and Ms. Dundas on our team. Generally, we'll get a list from the company if we do go into confidential session as to who is permitted to be in there. So I'll just have you confirm with Mr. Larson. And I would note this is regular confidential, not highly confidential, which sometimes have different lists of folks. I'm learning. So if it is the case that we need to go into confidential session, I would just ask you to confirm with Mr. Larson, Ms. Dundas.
This is my first hearing before you, so I will do that. Thank you.
Okay. All right. Anything else before we break for lunch? All right. Let's come back at 1 o'clock if that works for everyone. And I'll see y'all then. Reminder to turn off your cameras and mute yourselves. This will remain going during the lunch break. Thank you.
Thank you.
Mr. Tate, did you need something before we get started?
No, Madam Commissioner, I'm good.
Okay, great. Ms. King, did you need something before we got started?
I can certainly handle it on the record, but I just wanted to let you know that I've circulated those discovery responses we discussed at the beginning of the hearing and have heard back from many of the parties and have not heard any objections yet. So whenever you think is the appropriate time, I can certainly move to admit those documents into the record.
All right. You haven't heard from everyone yet, correct?
I don't believe I've heard from everyone, but I've heard from the lion's share of the parties here.
Okay, why don't we give it maybe until our afternoon break if that works for you. See if you can hear back from the remainder. Just make sure we got no issues.
Thanks so much.
Thank you. Let's see where I am. Ms. Crampton.
Thank you. I have two issues. The first is a quick issue. We had reserved 30 minutes of cross for Mr. Goodenough. I intend to waive that cross. And then the second is I do have some questions for Mr. Eiley that I believe treads into some confidential information. That's a short line of questioning. And so I wanted to just alert the commission to that now.
Thank you for that. Give me a little bit to work that out with council and stuff, see what we think's best. If we're gonna go into two confidential sessions or if somehow we ask them at a similar time. I'll work on that, Ms. Crampton. Thank you for letting me know. How long is your confidential questioning?
It's approximately 4 questions, I think.
Okay.
Long.
All right. Highly confidential, regular confidential?
I believe regular confidential.
Okay. All right. Ms. Dundas.
Was that for Mr. Eiley?
It is.
Was that for Mr. Eiley? Okay.
Yes, and it's in reference to another witness's testimony and report.
Ms. Dundas, what do you think? Should we look to do a short?
You say it's the last.
Okay.
Sorry, Commissioner Gudlin, didn't mean to speak over you. I was just going to say UCA typically goes last. So if you were to start with your commissioner questions after that, perhaps we could do one session if Ms. Crampton gave the confidential stuff for the end of hers. Would that work, Ms. Crampton?
Can you say that again? I'm sorry. Having the confidential questions last?
Last for your allotted time, or is it something you wanted to start your cross with?
I think maybe it would make more sense to start with it, but I'm not sure if there's another party that has confidential questions and we just want to do one collective session.
I think it's just me with you, unless I hear from Mr. Larson that we're not too worried about most of what's in that document. Mr. Larson, any responses for me on the JWI4 question?
Yeah, we did some checking around and there's GCA information and some other data that kind of permeates throughout the attachment. And we weren't able to run down with all of the respective data keepers that we can in fact do it publicly. So I think from our perspective, our preference would be to just do it in a confidential session. I know that's creates some logistical challenges, but we think that's the safest course of action.
Okay. Ms. Crampton, I'll maybe sort out a plan with Ms. Dundas. If your questions don't make sense last, perhaps it's that we'll try and fit this in right around our afternoon break for your short session. And then perhaps I'll hold mine until the very end of the day. And it might be 2 is what I'm hearing, unless that can't work, Ms. Dundas.
No, it's certainly possible to have two. It's just takes about 10 minutes to get the room set up. So that's why we generally try to avoid them, but it's no problem to have two.
Okay, well, the way it's looking right now, unless we cut some time, we'll move to UCA, you know, in the 3:30-ish time frame. So we'll plan to, you know, take a break when we're done with WRA, and then maybe set up the confidential session to come back from the afternoon break for that brief confidential session for you, Ms. Crampton.
And I appreciate that. I'm looking at it again, and I think that I could reserve these questions till the end, and then there could be one consolidated confidential session. So I know I said upfront, but I can move them to the end. That's fine.
Works for you.
That works.
Moves me up in the batting order too, so I'll have to be sure I'm ready. Okay. No worries. Anything else before we get started? Okay, do we have court reporter with us?
Yes, and I've been writing, so should I take all that stuff off the record?
Ms. Dunda?
If she captured it, let's keep it on the record.
Okay,
right.
I just started when you went to Miss Crampton, so I wasn't
No
sure.
worries. No worries. We're officially back on the record now for continuing Mr. Eiley's cross with sweep. Mr. Eiley, I'll remind you. Oh, Mr. Larson.
Apologies. We do have an update at an appropriate time this afternoon on the bench request that came from Chairman Blank this morning. We can cover that, you know, before we go to a break or whatever, but we have some things in motion. We have some clarifications we need. We can talk about that whenever, you know, you want to.
Why don't you go right now since we're not started yet anyway?
Okay, apologies for coming
Yeah,
in
no
with
worries.
that. So we've been able to kick the model off in terms of the remover of the scalars, and also we can run the CBA with both the utility cost test and the total resource cost test. The piece on the air conditioners, however, that Chairman Blank raised last, I think that's going to require some discussion with Mr. Oz. So our proposal would be, number one, I don't believe Mr. Goodenough has any cross-examination anymore at this point. I don't know if the commissioners have questions for him. In any event, Mr. Oz is right after Mr. Goodenough. We could have a dialogue with him to start his testimony in terms of that bench request, or we could handle it the commissioner question phase, however you all prefer to proceed, but it does require some discourse with him.
Okay. I was probably gonna have some questions for Mr. Goodenough, so I wouldn't say he's excused per se.
Okay. No problem.
And then, yeah, I mean, I guess, does it hold up the other work, like working on the scalar, if we wait to have this conversation with Mr. Oz on the air conditioner piece?
No, we've already started some of that work, and at minimum, we're going to be able to do a piece of it. It's just a question of whether we're able to do the last piece of it. So I think we can continue with that work. And then we'll try to get a better sense of the timing, you know, overnight and into the morning, and then we can discuss a process forward from there.
Okay, that sounds reasonable to me. Just remind me when Mr. Oz gets on.
We will.
What's going on here? Okay. Anything else before we get started? No worries.
No, thank you.
Okay, excellent. Now we will move on to Mr. Eiley. I'll just remind you, you're still under oath. We are going to move on to sweep with 50 minutes.
Thank you, and good afternoon, Mr. Eiley. I'll be asking you questions today on behalf of SWEEP.
Good afternoon, Mr. Hyatt.
So I'd like to start by discussing one of the big picture policy issues in this case. Would you agree that one of those big picture policy issues is how to balance emission reductions and costs?
Yes.
And isn't it the case that most of the parties here fall into one of two camps, where they either prioritize achieving emissions reductions or they tend to prioritize minimizing clean heat costs? Would you agree?
Those do seem to be the two major camps, yes.
And haven't you stated that the company understands both points of view You don't cast any judgment on how parties have chosen to prioritize these two issues?
I believe I said something very close to that in my rebuttal, yes.
In your view, the commission's job in this case is to strike the best balance between achieving the clean heat emission reduction targets and managing costs?
I think that's one of the decisions the commission has to make.
And now this clean heat plan is required by the clean heat statute, isn't it?
Yes.
I understand you're not a lawyer and you've already had a lot of questions about the statute, so I'll keep this brief, but are you generally aware that the overarching purpose of the clean heat statute is to reduce gas utilities' greenhouse gas emissions?
I would say it's to reduce greenhouse gas emissions associated with the service provided by the gas LDC utility.
And doesn't the clean heat statute include explicit and specific emission reduction targets for the years 2025 and 2030?
Yes.
All right, if we could please now pull up here in Exhibit 117, which is Mr. Oss's rebuttal testimony.
Yeah, sorry, I'm just trying to find it on my sheet. 117?
117, yes.
Thank you.
And if we could go to page 44, please. So now, Mr. Eiley, can you see that this is a figure from Mr. Oss's rebuttal testimony? And it shows that projected emission reductions and annual costs for each of the company's portfolios is presented in rebuttal. Do you see that?
Yes.
And this is not your testimony, but are you generally familiar with this figure?
I am, yes.
And didn't you include a similar figure in your direct testimony that represented the company's initial proposals in this case?
I did. We had the what was called the Clean Heat Plus portfolio. I would agree with similar, but the Clean Heat Plus portfolio was one of those that I characterized as achieving the emissions target. So it was on that dotted line to the right, which the significance of that is that it achieved, with our interpretation of different usages of different tools, it achieved a level of emissions reductions equivalent to that target. But yeah, with that qualification, it was a pretty similar figure.
Okay, thank you. And so focusing on this figure in front of us from here in Exhibit 117, you actually, I think, answered my next question, but this dotted vertical line on the right of this figure shows the emissions reductions necessary to achieve that 22% emission reduction target for the year 2030. Is that correct?
Yes, it is.
And a 22% emission reduction in 2030 equates to approximately 2.2 million tons of CO2e reductions?
Yes.
And for clarity, is it the case that the company is no longer actively proposing the amended preferred portfolio that is in green here and the electrification only portfolio that's in red?
Great question. So in rebuttal, we brought forward the three portfolios as we discussed earlier. I think amended preferred portfolio remains a potentially approvable option. I suppose electrification only might be also an approvable option, but our recommendation was the three portfolios, cost target, the two flex outcomes here, and then emissions target.
Okay, thanks for that clarification. I'm going to be focused on the three portfolios that you just mentioned that the company focused on in rebuttal. So as this figure shows, company projects that 2 out of those 3 portfolios you just mentioned, they would not put public service on track to achieve the 2030 target, would they?
I'm going to differ with you a little bit on that. I think the flex, I agree with you on the cost target. On the flex portfolio, I think it puts us in a range of still having the potential to reach the 2030 target, but I would also recognize there would need to be some more work done between, say, 2027 and 2030 to achieve that. But I think the flex portfolio does keep us in the ballpark of having a scenario that could achieve a 2030 target.
Okay, I'm gonna have some questions in a little bit on the flex portfolio, but to follow up on your answer there, would you agree this chart shows as we sit here today, the company projects the flex portfolio's emissions reductions would be to the left of that dotted line that represents the 2030 emissions reduction target, correct?
I want to double check something very quickly and reestablish my confidence in this. And would you mind repeating the question?
Sure. Would you agree that this chart reflects a fact that as we sit here today, according to the company's own projections, if the commission were to approve the flex portfolio, company's projections show that portfolio would not achieve the 2030 emissions reduction target based on the data we have today?
Well, the approval of any portfolio is only through 2028. So I don't know if I could agree that any approval of any portfolio can achieve the 2030 emissions target. This is sort of an extrapolation beyond this action period, if you will. So I'm not sure I can fully go along with you.
Okay. Don't mean to quibble with you on this, but could you agree that at least according to this figure, the two flex entries are to the left of that 2030 emission reduction target, which is the dotted right line? You can agree with that, right?
I agree with that. And the ultimate outcomes in 2030 are subject to a subsequent clean heat plan, or maybe more than one.
We've been focused on the 2030 target, and isn't it the case that none of the three portfolios would achieve the 2025 target, which is to reduce emissions by 4%, correct?
I believe that's true, yes.
So, Mr. Eiler, are you aware that the emissions reductions in this figure show how the emissions reductions for each of these portfolios, what they would be in 2030, compared to what the 2030 emissions would otherwise be without the portfolio? You aware of that?
This is a projection of 2030 outcomes across these portfolios.
And so when we're looking at here in this chart, the annual total abatement or the emissions reductions, that's not showing the emissions reductions compared to the 2015 baseline, is it?
No, I don't believe it is. I'm struggling on that one a little bit. I think it's a reduction below where emissions are more or less right now, or in the last couple of years, because what we pointed out was that there's been emissions growth since the 2015 baseline. So any portfolio has to start from that reality to get down to the 2030 target. So I believe, subject to check, that 2.2 is actually sort of a subtraction from kind of peak levels, recent peak levels, I might call that.
Okay. In the 2015 baseline, that's the baseline we're measuring the statutory emission reduction targets, correct?
Yes.
Okay. So for the cost target portfolio, are you aware that instead of reducing emissions, it's actually the case that if the commission approves that portfolio, the company projects the emissions will increase in 2030 compared to the 2015 baseline?
That may be true. You may need to put a figure in front of me.
Sure, I can do that. If we could please pull up here in Exhibit 119. This Quillian's rebuttal testament. If you scroll down to page 3, can you see Mr. Eiley here that attachment LWQ8 is a verification workbook for the cost target portfolio?
Yes.
All right. If we could now pull up that attachment. So that's here in Exhibit 119, attachment LWQ8. Scroll down to page 2, please. And Mr. Eiley, recognize this is not an attachment to your testimony, just following up on that answer.
Sure, understood.
Big picture here, can you see towards the top left of this chart, we see baseline year 2015 historical net emissions of 7.1 million tons. Do you see that?
Yes.
And again, this is a workbook that shows the company's projections for the cost target portfolio. Do you understand that?
Yes.
And if we scroll down slightly, please, on the bottom right of this figure for the year 2030, can you see that this portfolio underneath for emission reduction target demonstration is the header, the very first line there, clean heat plan projected emissions, 7.2 million. Do you see that?
Yeah, and I think you're asking me to confirm that that's a higher number than the 2015 number was, more or less.
Yeah.
Yeah, and I think the 2015 was 7.1 something, right?
Yeah.
Okay, I can agree to that.
Okay, so just to wrap this up, as this work paper shows, if the commission were to approve the cost target portfolio, company projects emissions would increase relative to the 2015 baseline, right?
Yes, subject to the fact that there are at least one subsequent clean heat plan to be approved that would actually be in place through 2030. This one is not.
Okay. So if we could now sort of bounce back to exhibits, we go back to here in exhibit 117, Mr. Hollis's testimony, please. There we go. So looking back now at this figure, are you aware of the fact the flex base portfolio here, it is projected to reduce emissions compared to the 2015 baseline, but by only about 11% in 2030. Does that sound generally right to you?
It sounds generally right.
So you've acknowledged in this case, haven't you, that the commission's decision on this inaugural clean heat plan is going to lay the foundation for achieving success in the future clean heat plans, correct?
Yes.
And yet, isn't it the case that one of the portfolios the company supports here is projected to increase emissions in 2030 compared to the 2015 baseline, and another portfolio would only achieve about half of the 22% emission reduction target for 2030?
Again, these are not plans through 2030.
But as the company projects, if the commission approves these portfolios, this figure represents projected 2030 emissions, correct?
It's one representation of potential 2030 emissions, again, subject to a pretty darn large caveat, which is we don't have that plan approved. We haven't even proposed it.
And if the company's very first clean heat plan puts it off track of achieving the 2030 clean heat targets, won't that make it more difficult for the company to get back on track to achieve the emissions reductions targets in the future clean heat plans?
I'd acknowledge there may be more emissions reduction work to be done with a smaller portfolio up front, but getting our programs in place and insights learned and developing technologies, developing Colorado's energy market. If the smaller plan remains affordable and acceptable to consumers, then it actually may increase the chances of hitting a 2030 target versus a portfolio that proves to be unacceptably costly and changes politics. So I struggle to kind of flat agree with that. I just feel like there's a lot of variables there. Political, technical, et cetera.
Okay, let's talk a little bit more now about this flex portfolio. So this is a new portfolio the company proposed for the first time 2 weeks ago in rebuttal testimony, correct?
I disagree.
In your view, when did the company first propose the flex portfolio?
The flex portfolio is a very close derivative of the amended preferred portfolio, which was proposed back whenever we filed the amended supplemental direct testimony, which was November 6th. This is a portfolio that essentially holds back a small, I shouldn't say small, $119 million worth of funds within that portfolio and subjects it to that check-in process. I do not characterize this as a new portfolio. That was your question. I think this is a close derivative, a small modification, responsive to answer testimony from the amended preferred portfolio, with respect, sir.
Okay, well, on this figure, it shows the two flex portfolios entries as being distinct from the amended preferred portfolio, correct?
Yeah, it's like a pretty tight constellation right there.
And that check-in process, at least that procedural piece and the holdback, that's a new concept as of 2 weeks ago, correct?
Not exactly. There's actually a rule in clean heat rules that suggests that plans could be amended. So I think this is pretty resonant with existing commission rule. I think it's also pretty resonant with the fact that a party could file a motion and seek to modify this plan. So it's a newer proposal, but it also has precedent from existing commission rule and historical practice. And it's, again, responsive to answer testimony.
Okay. So I think you've stated the company takes no position on which of the three portfolios we've been discussing the commission should approve. But does the company at least slightly prefer the flex portfolio?
I think we see certain advantages to it.
Okay. So under this flex portfolio approach and its decision in this proceeding, the commission would approve flex base portfolio that you can see in yellow in this figure. Is that right?
Well, they would approve the flex portfolio, and then these two outcomes are representations of potential outcomes, depending on how that flex process played out and actual market implementation as well.
Okay. And the flex base portfolio the commission would approve in this case, which is represented by yellow here. As you can see, that would achieve slightly less emissions reductions than the amended preferred portfolio was projected to achieve, correct?
I would agree.
And really the flex component of this whole proposal, that's represented by the flex high entry that is in light blue. Would you agree with that?
Yes.
And as you've discussed, and I think the basic principle here is the company will hold back about $119 million in additional funding. We'll file a report in 2026 on whether to unlock those funds and how to unlock those funds. Is that high level what the company is proposing for this flex high scenario?
Yeah, I'll add a statement, not so much to quibble with your question, but just it's the funds are, I want to be clear because I think this creates confusion. The funds won't be collected in advance. It's almost the commission would be asked to approve this level of expenditure up front, and then the reservation of funds is not actual funds collected from customers and held in some account somewhere. It's more the concept of releasing us to be able to use those funds for the last 2 years of the plan. So I agree with your statement. I wanted to add that in there because I think that's a potential area of confusion in the flex portfolio.
Okay, I appreciate that clarification. So you've noted several times in rebuttal testimony that the company's intent and kind of the spirit of this proposal, as we say here now, is to use those unlocked funds on beneficial electrification if market conditions warrant it. Is that right?
Yes.
So if the commission approves a flex portfolio, company would be required in the year 2026 to file that annual report and file its proposal on whether and how to unlock additional funds, right? That'd be a requirement.
Yes.
And in that filing, company could always propose to not unlock any additional funds for 2027 and 2028. That's an option, right?
It is, and parties could comment with their own views that could go another way. Yes.
And regardless of what the company proposes, that future commission in 2026 could always decide itself not to unlock any additional funds, couldn't it?
It could, and I'll give you a yes and on this again. So yes, and that future commission under current appointments is largely this commission. And that's one of the reasons we thought it made a little bit of sense here to bring this commission back to that question in a relatively short period of time without reinstigating a completely new litigating process.
And although the company currently states it intends to use those additional funds if warranted on beneficial electrification, it could always propose in 2026 to use those additional funds on recovered methane, hydrogen, or some other clean heat resource, couldn't it?
Yes, I don't know that we said that we intended to use it on electrification. I think we expressed openness to doing so, which represents a potential move from the budget from out of the clean fuels area and into an electrification one. But the latter part of your question is accurate. We reserve, the ability to propose what seems to make sense, either not spending it or spending it in the areas that make the most sense at the time, as driven by data and experience.
Okay, so turning back now, look at this figure again on here in Exhibit 117. That blue entry for Flex High, that result, that projected result, is not certain to occur if the commission approves a Flex portfolio in this case, is it?
It is not.
And so the blue Flex High entry here, doesn't it reflect the projected cost and emission reductions if a future commission later decides to unlock the additional funds, and if those additional funds are used on electrification?
It does.
And as far as timing, the company proposes to file that check-in report in the summer of 2026. And it also plans to file its next clean heat plan just 1 year later in the summer of 2027. Is that right?
Yes.
All right, let's briefly turn now to the emission target portfolio, or the large portfolio as you refer to it sometimes, which is an orange in the figure here. You see that?
Yes.
Now, the company also supports the commission approving the emissions target portfolio, right?
Yes.
As this figure shows, isn't this the only portfolio the company has proposed as projected, as we say here now, to put public service on track to achieve that 2030 clean heat target?
Yeah, as projected, I would agree with that.
And the overall emissions reductions under the emissions target portfolio, are you aware they're generally similar to the emissions reductions under the pollution-free buildings portfolio that SWEEP, WRA, and the Conservation Coalition have proposed?
Yeah, I believe that's true. I believe they're very close, if not the same number of emissions reductions.
And as you've acknowledged in your testimony, the overall budget for the emissions target portfolio and the pollution-free buildings portfolio, they're relatively similar, aren't they?
I don't know if I agree with that without seeing that.
Okay. I don't think we need to take the time to establish that.
Okay.
Would you agree that the main difference between those two portfolios, emissions target and the pollution-free buildings portfolio, is that in addition to DSM and beneficial electrification, the emissions target portfolio also includes funding for recovered methane and hydrogen. Is that accurate?
Yes, it does, as indicated by our modeling, which showed that portfolio of results.
Okay. We can take this figure down now. And I'd like to change topics and talk a little bit about implementation issues regarding beneficial electrification. I'd like to start by following up on your discussion this morning with Mr. Gerhardt about how the company is not proposing to offer any beneficial electrification incentives to its gas-only customers. Do you recall that conversation generally this morning?
Yes, I do.
All right, if we could please pull up here in Exhibit 116, which is Mr. Eiley's rebuttal testimony now. Go to page 67. This first paragraph on page 67, you discussed this with Mr. Gerhardt. But you highlight here, don't you, that neither Atmos nor Black Hills propose any beneficial electrification in their clean heat plan applications, correct?
Yes.
As you explained earlier, it's your position that for the company's gas-only customers, there should be equal treatment with the state's gas-only utilities, such as Atmos and Black Hills, right?
Well, I think we're pointing out that we face the same realities. I think we've also expressed in our case an openness to consider policy solutions that could enable this to be a more rational thing for our utility to do.
Okay. And you discussed a little bit this morning the timing and the fact that the company's clean heat application is kind of ahead of schedule as far as Atmos and Black Hills. Do you recall that?
Yeah, I think they're on the statutory timelines, as I understand it, for Atmos and Black Hills. which I think was January, and ours is August 1, I know.
Yeah, and just to clarify, I guess, question was, are you aware generally that Atmos and Black Hills filed their clean heat plan applications in December of 2023? Does that sound generally right to you?
Sure. I'm not completely sure when they filed.
Now, are you aware that just last week, the commission issued decisions in the Atmos and the Black Hills clean heat proceedings that directed both of those utilities to file supplemental testimony that evaluates including beneficial electrification and their preferred clean heat portfolios? You know that?
I've not reviewed those decisions, but I've listened to the deliberations, so that sounds right.
Okay. So we could take this testimony now, please. And let's slightly pivot beyond talking about eligibility for BE incentives and talk a little bit more about cost recovery for beneficial electrification. As in the case of the company proposes to recover 100% of beneficial electrification costs from its electric customers, right?
Yes.
And do you recall that staff recommends splitting beneficial electrification costs 50-50 between gas and electric customers?
I do recall that.
And the company opposes that proposal, correct?
We are maintaining our position that it should be 100% through the proposed electric clean heat rider.
And Public Service then also opposes SWEEP's recommendation to recover 75% of beneficial electrification costs from gas customers, right?
Yeah, again, we maintain our proposal as largely as similar to direct testimony.
And in your rebuttal testimony on this issue, you did not mention Denver. So are you aware that Denver recommended in its answer testimony that the company recover 100% of all clean heat costs from gas customers?
I think I do recall that, yes.
And are you aware that in its cross-answer testimony, Colorado Energy Office modified its initial position on this issue and ended up supporting staff's recommendation to split beneficial electrification costs 50-50 between gas and electric customers?
I'm not sure if I was fully aware of that, actually.
Are you aware that in Costa Cia's cross-answer testimony, they supported SWEEP's proposal of a 75-25% split?
I think there's a lot of opinions about this, Mr. Hyatt.
There are a lot of opinions, but would you agree with me that most of the parties who have weighed in and expressed opinions on this issue believe the company should recover at least half of beneficial electrification costs from gas customers?
Maybe you'd have to present me with a tally, because there are quite a lot of parties in this case before I can agree to that. I'm sure you can establish it in your statement of position.
All right, and I don't have a tally handy, so I will not present you with a tally now. Now, these beneficial electrification costs we're talking about, these are costs that are part of the clean heat plan, correct?
Yes.
The clean heat plan is a product of the clean heat statute, right?
Yes, I think we established that.
And the clean heat statute applies to gas utilities, right? I think we established that, correct?
Yes. Well, yeah, it does. Yeah.
And doesn't the clean heat statute apply to both gas-only utilities and combined electric and gas utilities?
Yes.
As we just discussed, hasn't the commission recently stated that it may be appropriate for gas-only utilities to include beneficial electrification in their clean heat plans? And that statement was in the decisions on Atmos and Black Hills clean heat plan applications. Do you recall that?
I recall commission activity asking for supplemental direct on this, exploring possibilities.
So a gas-only utility such as Atmos or Black Hills, if they do end up being required to include beneficial electrification in their clean heat plans, they will necessarily have to recover those costs from gas customers. They don't have any electric customers, do they?
Black Hills does have electric customers, just not where they have gas customers, is my understanding. Atmos has no electric customers in the state.
So Atmos, if it offers beneficial electrification in its clean heat plan, it will necessarily recover those costs from its gas customers. Would you agree?
I would, and therein lies the awkwardness.
Okay. To switch gears now, and the last topic I'd like to briefly discuss with you is a little bit more about the pollution-free buildings portfolio that SWEEP, WRA, and the Conservation Coalition have proposed. So is it accurate that one of your concerns with the pollution-free buildings portfolio is that you do not believe that the portfolio's assumed rate of beneficial electrification adoption is realistic and achievable?
I think we have pretty serious questions as to whether it is achievable. Yes.
And in general, isn't it the case that the company believes that the rate of beneficial electrification adoption that's assumed in the Greenhouse Gas Roadmap 1.0 is the realistic and achievable trajectory for electrification?
I think we regarded that more as one of the highest ones that we could present in this modeling, in our view, as we built this out. So I don't know if we view it as achievable. I think it wasn't, in our view, it wasn't necessarily built up from a bottom-up analysis that would result from customer surveys and that sort of thing. My understanding is it was sort of reverse engineered from where the targets needed to get to. And so we use that as a benchmark for our modeling. Mr. Oz can probably speak to this a little bit more, but we have questions about whether that rate is achievable as well.
Okay. So a rate that's faster in adoption than the Greenhouse Gas Roadmap 1.0 growth trajectory. Company believes that is infeasible, not achievable. Is that accurate?
I'd say we feel that it's pretty unlikely.
And the pollution-free buildings portfolio, it does assume a faster rate of electrification than those Roadmap 1.0 assumptions. Would you agree?
Yes, that's my understanding, is the kind of maybe the fundamental difference between that view and the view we took in our model.
Are you aware that the Colorado Energy Office is the primary state agency tasked with developing and drafting the state's greenhouse gas roadmap?
Am I aware that they are tasked with it?
Yeah, and that they are the primary state agency who's tasked with developing the roadmap. Are you aware of it?
Yeah.
And hasn't the Energy Office submitted testimony in this case that states that it believes the electrification trajectory in the Roadmap 1.0 is now outdated?
You might have to show that to me.
Sure, we could, I think, pull up your rebuttal testimony, which is Exhibit 116. And you could go to page 28.
Sorry, it's giving me a little trouble with the page numbers. Give me a second. Yeah, I'm gonna have to scroll to it. So it might take me a second longer.
Thanks. I think I'll scroll down to lines 14 and 15. Guess just, Mr. Eiley, can you review that paragraph that begins on line 14 there? Let me know when you're done.
Yes, thank you for the refresher on that.
So isn't it, to ask the question again, isn't the case that the Energy Office has submitted testimony here that it believes the electrification trajectory in the 2021 roadmap, which is the roadmap 1.0, is now outdated? You see that?
Yeah, we're citing that they stated that. I'd have to review Mr. Hayes' answer testimony, but I'll believe my answer testimony paraphrasing his, or my rebuttal paraphrasing his answer. Apologies.
Okay. Do you recall generally the Energy Office believes that a beneficial electrification trajectory that's approximately double the roadmap 1.0's assumptions is achievable and more appropriate for this clean heat plan? You generally recall that?
I don't actually recall what they stated about adoption level and pace, honestly.
Okay. Well, would you agree, just to save time here, that the emissions target portfolio the company has proposed, that reflects an electrification trajectory that is consistent with the Energy Office's recommendation? Recall that?
I would say that it's higher than the roadmap 1.0 trajectory, and we flagged our concerns with that adoption level in the creation of the emissions reduction target.
Okay, and on the screen here in Exhibit 116, lines 15, beginning on line 15 there, then you state that CEO thus believes that the trajectory for the emissions target portfolio is more appropriate to use than the one used for the APP. That accurately quote your testimony?
Yes.
So could you agree that the Energy Office believes the emissions target portfolio represents an achievable and feasible portfolio?
I don't know. Those words are not there.
Are you aware that the electrification trajectory in the pollution-free buildings portfolio is similar to the electrification trajectory under the emissions target portfolio?
I imagine they are somewhat similar. I'd have to look at numbers on those. I mean, you're asking me to agree to a lot of things that are not in front of me. So like, you know, if it's in the record, you can state that. But if you want me to verify things in the record that I didn't testify to, let's bring them up.
Okay. So I think to wrap up here, as you can see on this paragraph, begins on line 14 to 17, a second sentence. Could you agree, this is your testimony, Mr. Early, that CO believes the trajectory for the emissions target portfolio is appropriate?
The statement stands for itself.
Thank you, Mr. That's all the questions I have for you.
Okay. Good afternoon.
All right. Let me see who we've got next. WRA next for 60 minutes. Mr. Brosso.
Thank you, Commissioner. And just to advise for our afternoon break planning, I anticipate that this won't take the full 60 minutes.
Will or won't?
Will not.
Okay, thank you.
All right. Good afternoon, Mr. Eiley. We have met before, but for the record, my name is Parks Barroso and I represent Western Resource Advocates.
Good afternoon, Mr. Barroso.
And Mr. Eiley, I would like to start our discussion by zooming out and looking at the company's longer-term vision for the gas distribution system. Ms. Federico, if we could please pull up hearing exhibit 101, which is Mr. Eiley's direct testimony. And I'm looking at page 154, please. Page 154, please. Here it is. Thank you.
Yeah, sorry, my keyboard is giving me some issues, but I've got it.
Not a problem. And Mr. Eiley, in your direct testimony, you presented the company's analysis of two scenarios that examined the future of clean heat in 2050. Do you recall that?
I think there are actually three, but they sort of have two endpoints.
And the two scenarios were titled the 2050 Clean Molecule Future and the 2050 All-Electric Future.
Yes.
Do you recall those two?
Yes.
Thank you. And now if we could scroll down to line 17 in introducing those portfolios and the company's corresponding analysis, you stated that this proceeding is the first opportunity to specifically consider the long-term future of the company's LDC system. Do you see that?
Yes.
And scrolling down now to page 165 at line 14. Here you state that you believe the 2050 scenario analysis should be viewed as a separate exercise from the Clean Heat Plan, but that the company intends its Clean Heat Plan to be the first step on a path toward a net zero gas system. Did I summarize that correctly?
Yes.
And similarly, in your rebuttal testimony, Mr. Eiley, you noted that this first clean heat plan is, quote, a stepping stone in a broader and long-term evolution of the services that the company provides to customers.
Yes, I think that's an accurate quote or paraphrase.
And as part of this stepping stone proceeding that we're in now, as you refer to it, do you think one important factor in selecting a clean heat resource for this commission is whether that resource can be deployed at scale?
Yes.
And Mr. Eiley, under the company's modeling, it demonstrates that under any of the portfolios proposed by the company, total throughput on the company's system decreases during this clean heat plan period through 2028. Is that correct?
Can you repeat the question? I'm sort of thinking about Mr. Hyatt's previous questioning and where emissions went under cost target. So can you repeat the question, please?
So the question is, for the three portfolios that the company has presented in rebuttal, doesn't the modeling demonstrate that under any of the portfolios proposed by the company, as compared to the business as usual, total throughput on the company's system decreases during the clean heat plan period?
Yes, thank you for the repeating. As compared to business as usual, yes, I can agree with that. Even cost target reduces emissions or throughput relative to business as usual.
And if we could pull up Mr. Oz's testimony, please, which is hearing exhibit 117 at page 46. And scrolling down to line 10. Here, Mr. Oz notes that the flex scenario, for example, results in a 21% reduction in gas sales relative to the BAU.
Yes.
Do you agree with that?
Yes.
And now, Mr. Eiley, returning back to that longer-term view that we were discussing earlier, I think you've acknowledged that throughput on the company's gas system will, quote, significantly decline regardless of which future scenario is used.
Yeah, I think that's a fair quote or paraphrase from that section of my direct testimony. It varies quite a bit on which future happens. We do see a throughput reduction in any of those futures that do feature an emissions reduction that's, kind of zero or net zero type world. If we're talking 50, 80, 90, 100% reduction, we will see throughput reduction. It's a question of how much and when.
Sure. Thank you for that clarification. And let's take the clean molecules scenario, for example. With that one in your testimony, you've stated that the gas LDC throughput will be 20% of today's throughput by 2050.
Can you show that to me? That sounds right. Again, cleanliness of record is important.
It is. Let's turn to hearing exhibit 101 at page 158, please. And we're looking at line 13 here.
Thank you. I agree.
So in other words, even in a scenario that assumes continued reliance on alternative fuels, throughput on the system decreases by 80% by 2050, based on this modeling done by the company.
Yes, I'm looking at the context here just to make sure where we are on this. That is our statement, yes.
Great. And Mr. Eiley, I'd like to take that assumption of declining throughput and apply it to some of the alternative fuels that the company has proposed in this clean heat plan. And taking hydrogen first, and I understand that there are other witnesses that address this as well from the company. I understand that the company has not proposed a specific blend percentage of hydrogen, but has discussed blending at 2, 5, 10, all the way up to 20% by volume. Does that sound right?
I think you said we discussed that. Yeah, I think that's a fair characterization. Specifically on the blending, the residential blending that we have proposed in the market transformation portfolio was 2, 5, and 10. But there may well be conceptual discussion up to 20% within the testimonies of Mr. Jensen, Mr. Gardner.
Thanks for that. And let's assume that 20% remains the upper limit for hydrogen blending. And I'll represent to you, Mr. Alley, that your colleague, Mr. Jensen, has stated that hydrogen has the potential to be blended with natural gas up to 20% by volume. Do you agree with that representation?
I think that's somewhat unknown. That is a number that is often used. I think between now and 2050 is a long time, and it sort of depends on where we're talking in the system.
And so just talking generally, Mr. Alley, and taking this 20% figure as the limit, even under this blending percentage, wouldn't you agree that the volume of hydrogen that can be introduced into the system is limited by the volume of total gas throughput?
Can you explain what you mean by that a little bit more?
Sure. So in other words, as total throughput on the system decreases, the utility would blend comparatively fewer decatherms of hydrogen in order to maintain that constant blend percentage.
I think you're asking me to agree that if the hydrogen blending percentage is held the same as the overall volume of throughput declines, then the number of molecules of hydrogen declines. Assuming that the hydrogen percentage remains the same, that's algebraically true. But I guess I push back a little bit. It's conceivable you could have end uses that you could take to much higher than 20% hydrogen blending. That might have to be more targeted rather than system-wide, but there are 100% hydrogen demonstrations being done now in the world.
Okay, and we'll just stay at the general system level. To follow up on what you stated there in terms of what is algebraically true or not, if fewer decatherms of hydrogen can be blended as the system continues to decarbonize or as throughput continues to decline, would you agree with me that any infrastructure that's built to deploy hydrogen would correspondingly be used less than it would otherwise?
I'm not sure I agree with the premise of your question, honestly. Maybe we need to try that again.
Okay, Mr. Riley, you agreed that it's algebraically true that if you hold the percent blend constant and throughput declines, that fewer decatherms of hydrogen can be blended into the system.
Yeah, that asked me to agree to the 20% sort of blend wall it's sometimes described as, and I sort of think like it's just more complicated than a blend wall across the system. That's the world you're asking me to live in with this question. I struggle with it a little bit. I think it's much more targeted potentially in the long run.
Okay, well, if you'll indulge me and lean into that complicated world for just a second, that 20% is the blend wall. Would you then agree that as the system continues to experience less throughput, infrastructure that's built to deploy hydrogen would be used less?
I don't think I do agree with you. We're using 0% hydrogen today. So as there's no infrastructure injecting hydrogen in our system now, so going to a world where 20% is a blend wall limit, there's going to be more. I think you're sort of asking a really high level question about a long period of time. I don't know if I agree with you with respect.
And so is it your testimony that if throughput decreases and the blend wall remains in place, that more hydrogen could somehow be injected into the system over this decades-long time span?
I think you could have the same amount of hydrogen that could be 1% today. The throughput of the system could decline, and then you might end up at 3 or 5 or 10% hydrogen with the same amount of hydrogen molecules being blended. Again, algebraically.
Okay, pivoting just slightly now, Mr. Eiley. Through this discussion, we've been referring to total throughput on the company's system. but for purposes of clean heat, only emissions reductions from residential and commercial customers count toward meeting the clean heat targets. Isn't that correct?
Are you purposefully excluding industrial customers?
I was trying to purposely exclude transport customers, so let's
okay.
that.
Okay.
Would you agree that any throughput or emissions reductions associated with transport customers are excluded from the calculation of total emission reductions under clean heat?
Yes, under the statute that we have now, that is true.
Yet, when the company originally proposed its intent to blend up to 4% hydrogen by volume in its direct case, are you aware that the company used the utility's total throughput inclusive of transport customers?
I think that's true, yes.
And so if that is true, isn't it fair to say that the company may have overestimated the emission reduction potential of hydrogen if it was including in that denominator a percentage of customers that don't count towards clean heat accounting?
Maybe walk me through that a little bit.
So we've just agreed, Mr. Hiley, that transport customers are not accounted for in clean heat emission reductions. Do you agree with that?
Yes.
And you also agreed that when the company originally proposed its intent to blend up to 4% hydrogen by volume, it did include transport customers in the total throughput.
Yes.
And the company also represented that that 4% blend would achieve a certain amount of emission reductions.
Yes.
So isn't it also true then that that emission reductions is necessarily lower if you have to take transport customers out of that blend percentage?
I don't necessarily agree with that. And the reason why is because I think at that sort of scenario, we're going to run straight into the need to certify molecules. It would be true, I think, physically that hydrogen would be blended amongst both our let's call them, well, I don't know what to call them, our regular retail customers versus our retail transport customers. But our regular retail customers would be paying for all of that. And I think you can get into in fact, these exist, a sort of green attribute tracking system, very much like renewable energy credits. If my non-transport customers are paying for all that hydrogen, I believe that all those attributes belong to them. And therefore those emissions, they would be credited with the full amount, even though the molecules may be dispersed throughout the system.
That's an interesting aside, Mr. Eiley. Did the company propose this kind of clean molecule emission accounting system as part of its direct case or in its testimony anywhere in this proceeding?
No, but it does exist, or at least the conceptual discussions exist about this very thing.
But when you testified in your direct testimony about 4% blend rate and the associated emission reductions, you did not discuss this kind of emission trading and compliance system. Is that fair to say?
No, I don't think we did testify to it. I don't know if it's trading so much as just attribution, actually.
So, Mr. Eiley, I'd like to turn to your rebuttal testimony now, where you state that the company is seeking approval of, quote, its updated hydrogen blending demonstration approach, along with any hydrogen amounts and any clean heat portfolio approved by the commission. Does that sound right?
Yes.
And regarding the request to approve any hydrogen amounts in any clean heat portfolio approved by the commission, it's true that the flex portfolio budget, along with the emission target portfolio budget, include a requested budgetary amount for both blue and green hydrogen, correct?
It is a requested amount for the budget. The blue versus green split is really the model output. So I believe our request is for the overall budget level and a commitment from the company to try to maximize the source of green blending. I don't think we're identifying the blue versus green as sort of separate proposals, if you will.
Okay, and we don't need to rehash this because I think you walked through this with CEO's counsel, Ms. Colicchio, earlier, but just to level set, those budgetary amounts are identical to what the company requested for its earlier portfolios. Is that correct?
Yes, they are.
And at the beginning of your rebuttal, we can pull it back up if it's helpful. This is hearing exhibit 116 at page 14.
It would be helpful.
And here at line 7, you state that including and investing in clean fuels as part of the strategy now is not intended to make a permanent policy choice for the future of the gas business. Do you remember saying that?
Yes.
Great. And I'd like to explore here what you mean by permanent. Would you agree with me that investing in clean fuels, take hydrogen, for example, will necessarily involve investment in new infrastructure and assets, potentially along with investments in modifying existing infrastructure on the distribution system?
Yes.
And the company would presumably add those infrastructure investments to deploy hydrogen to its rate base. Is that correct?
Potentially, yes.
Can you help me understand what potentially does there? If not adding it to the rate base, how would those investments be funded?
I guess I could imagine a world in which there's something like independent hydrogen producers, and I don't know the exact terms under which we would offtake, if you will, or receive hydrogen. It's possible they could incorporate the cost of the infrastructure into contracts. It's possible we could own it as rate base. Probably more likely we would own some of that as rate base. In the spirit of your question, I just don't know kind of the mix of what that world looks like in the long term.
Okay, I'm hearing a lot of possibles there. So let's stick with what we think is most likely, which is that the company will own at least some or all of that cost as rate base.
Could be contracts.
And at a high level, could you provide an estimate of the length of time over which those infrastructure investments would be depreciated?
I don't know if I could. That's a good question. I don't know if I could venture that, actually.
30 years?
I don't know. I may want to consult with Mr. Gardner about sort of the length of infrastructure investments. I'm certainly aware that this is a conversation that is very in tune or attuned to the stranded asset question and durations of depreciation. So I don't know if there's, generally accepted accounting principles around hydrogen infrastructure depreciation, frankly.
Okay, well, Mr. Arley, how about, without putting a specific year on it, you would agree that these are long-lived assets that we're talking about?
Honestly, Mr. Broso, I don't know if you and I agree on what long-lived means. I think part of the point here is that we do see throughput for quite a long time, and I think we can easily.
Okay, Mr. Arley, and I appreciate that, and you can address that with your counsel on redirect. I'm just asking here about these infrastructure investments made to deploy hydrogen and what the general lifespan of those might be. And so if you disagree that they're longer lived assets, we can move on. My question to you is just whether we can expect those to be paid for by ratepayers over 5, 10 plus years.
I think that's possible, yes.
And so aren't we talking about a policy choice here for the future of the gas business when we invest in clean fuels that might require these types of infrastructure investments?
I think we're just across the whole clean heat plan, we're discussing investments that affect the future of the electric business and the gas business.
And as part of that general statement, a policy decision to invest in clean fuels does impact investments that are made on the gas business side.
It does. The magnitude and duration, I think, is to be discussed. And whether that duration matches the duration of the throughput on the system, which you and I did discuss a few minutes ago, is part of that conversation.
Okay, let's move on. And I think we still have Mr. Arley's rebuttal up, but I'm having trouble seeing it. We do, and if we could turn to page 126, please. And I'm looking at line 10, and Mr. Riley, I know you've discussed this already, maybe several times, but just to confirm, here in rebuttal, the company is stating that it's recommending that the commission approve one of three portfolios that it presented: the flex, the emissions target, and the cost target portfolio.
Yes.
Meaning that the company would support the commission approval of the emission target portfolio, for example.
Yes, I mean, it's, we need to understand the terms of such approval, but we, you know, and as a concept, yes, we would agree with that equally with the other two.
Okay, and just like the other two portfolios, the company believes that there is a sufficient evidentiary basis for the commission to approve the emission target portfolio.
I think that's fair, yes.
And keeping this emission target portfolio in mind, Mr. Riley, I'd like to turn up to page 29, please, of this hearing exhibit 116. And again, not trying to repeat your conversation with Sweeps Counsel, Mr. Hyatt, but do you recall discussing the pace of electrification that was assumed in the pollution-free buildings portfolio?
Yes, a bit.
And looking at your testimony here on line 5, you state that the emission target portfolio assumes that 389,000 homes will be electrified by 2030. Is that correct?
Yes.
And then looking down on line 8, you reference WRA Sweep CC's projections. And by that, are you referring to the pollution-free buildings portfolio?
Yes, I am.
And as you note here, the pollution-free buildings portfolio projected that 365,000 homes will be electrified by 2030.
Yes.
And those are similar adoption rates, aren't they?
I would agree.
And if we could scroll down to footnote 25 of this same page, you also note here that the company's amended preferred portfolio and the WRA Sweep CC portfolio, well, both project installations of over 300,000 space, I think that should be heat pump water heaters by 2030.
I agree, it says that, and I agree with your impromptu correction.
Thank you. And so again, same question for you, Mr. Riley. These are similar, if not identical, adoption rates.
Yes, I would note that elsewhere in testimony, we've expressed that the rate that's similar to the amended preferred portfolio, which is now a flex portfolio, is sort of the highest realistic rate that we thought we could present to the commission. But I think what we're saying with the higher target is we respect the commission's judgment to have a different view on that.
Thank you, Mr. Riley. Those are all the questions I have for you today.
Thank you, Mr. Brosso.
All right. Next up, we have Ms. Crampton. So, Ms. Crampton, I think we'll go with your non-confidential questions. Does it still work for you to do them at the end, or?
Actually, I looked at it again, and I think I can ask all the questions from the public exhibit. So I don't need a confidential session.
Okay. Simplified our life. I anticipate we'll probably take a break when you're done, and we'll see how we're doing. So I have got you down for 45 minutes.
Okay. And I don't think I'll go that whole time either. Good afternoon, Mr. Eiley. I'm Kate Crampton. I'm one of the attorneys who represents UCA. I know we've met before, but it's nice to see you.
Nice to see you, Ms. Crampton.
And Mr. Eiley, I just want to start with some background questions for you. You are employed by Public Service as Regional Vice President of Regulatory Policy. Is that right?
Yes.
How long have you been in this role?
This specific role, about 18 months. Prior to that, I was Director of Regulatory Policy, so fairly similar activities, leading similar types of cases.
Okay. And how long were you in that position as director?
About 5 years prior to my promotion.
And you said similar responsibilities in these two positions, and those responsibilities are overseeing the company's regulatory filings and strategy regarding resource planning, transmission planning, and distribution planning. Is that right?
Yes.
And these responsibilities of this role, they're certainly not limited to this clean heat proceeding.
No.
And is it fair to say you are aware of and have been involved in other regulatory proceedings in front of this commission?
Yes.
Okay. Does that include rate cases, gas infrastructure planning cases, and resource planning proceedings?
In order, I have a lot less involvement in rate cases. That's usually led by my colleague, Mr. Steve Berman. I'm aware of rate cases, but much less level of responsibility. The gas infrastructure plan, the inaugural one, I was very heavily involved in the rulemaking. I had some involved in the creation of that filing. I didn't lead it. Resource plans, yes, I have deep familiarity with those. I've been involved in about 4 of those different ways over the years.
Okay. And is it fair to characterize you as sort of the lead analyst or lead witness for public service in this clean heat proceeding?
Yes.
And as lead analyst, did you review your colleagues' testimonies?
Most of them at different times. I'd say lead witness, yes. Lead analyst, I don't know if I can if I can follow you there, but we'll see where we go.
Okay. And as lead witness, did you review the intervener testimonies in this proceeding?
It varies. I tried to review many of them. We do, especially on rebuttal, it's pretty challenging. Like we have a sort of delegation and teamwork system, a summary system, but I've tried to review the testimonies.
Okay. And you'd agree in your rebuttal, you respond to a lot of intervener answer testimony.
Certainly, yes.
Mr. Eiley, would you agree that when the legislature passed the clean heat statute, the legislature appeared to sincerely believe that the clean heat emissions targets could be met while also maintaining the statutory cost cap?
I don't know if I can say that.
Would you agree the legislature provided the directive for the 2.5% statutory cost cap?
They provided that. They also provided means by which we could propose another portfolio that meets the emissions cap target without the cost cap needed.
Okay, and kind of anticipating my next question, they did provide a framework for the company to exceed the cost cap, but only if certain conditions were met. Is that right?
Yes.
If achieved, the cost cap, if the statutory cost cap were met in the clean heat plan, this would result in approximately $213 million of spending over a period of 5 years. Is that right?
Let's see.
Would it be helpful to look at a portion of your rebuttal testimony?
Yeah, I'm pretty tempted to go to table JWI-R7, and I think I agree with you. That's in quote unquote vertical 1. That's the compliance portfolio is $213 million over 5 years under the cost target for that table.
And so that's if the plan were to meet that statutory cost cap, that's the amount of spending we'd be talking about.
Yes.
Okay. And fair to say it's become evident in this proceeding that the clean heat proposals offered by the company and by other interveners to meet these clean heat targets far exceed that statutory cost cap.
As far as cost?
Correct.
Yeah, they tend to do that, including our own analysis.
Okay. And the company's amended preferred portfolio, which was sort of the preferred plan up until rebuttal testimony was filed, the estimated cost of that is $696 million.
That sounds right. You may need to cite me to that, but if you're quoting me, I can go with it.
Okay. Does that sound right from your rebuttal testimony?
I don't think we testified much on the amended preferred portfolio in my rebuttal testimony.
If we could go to hearing exhibit 116 and page 96 to 97. And Mr. Eiley, these are actually figures that represent the flex plan, is that right?
Yeah, they do.
And the flex plan starts at a cost of approximately $565 million. Is that right?
For the vertical one compliance portfolio, I'm showing about 567.
And that cost can be flexed up with that additional 119 to approximately 695 million.
Yes, and yes, I just wanted to add, and this isn't any quibbling with your question at all. There is a little bit of difference between what you see on pages 96 and 97 and what you see on page 126. And that's due to that model iteration process that I think I talked about a little bit this morning. But conceptually, I'm following you in agreement.
Okay, and conceptually, these amounts, or maybe not conceptually, these amounts, these are budgets that are over 3 times that statutory cost cap of approximately $213 million. Is that right?
They're about 3 times, yes.
Okay.
And more in some cases.
And with these projected budgets, with this flex portfolio projected budgets, the commission is sort of facing a proposed portfolio that both exceeds the statutory cost cap by over 3 times and does not meet the emissions reductions targets as set forth by the Clean Heat statute.
Yes, and it achieves more emissions than the cost target, and it costs less than the emissions target, but I do agree with you.
Okay. And that's sort of the tricky thing about this Clean Heat proceeding. Is that fair to say?
Yes. It's hard to be in the middle in America in 2024.
Sorry, I didn't catch that.
I'm sorry, it was a joke. I said it's hard to be in the middle in America in 2024.
I appreciate that. Another tricky thing about this Clean Heat statute is it provides no statutory guidance on how the commission should consider offsetting the costs of the proposed Clean Heat budgets, correct?
I'm not sure I'm following you. Do you mind running that by me again?
Sure. For example, your colleague, Mr. Mark, discussed that in a traditional DSM proceeding, the commission can utilize the modified total resource cost test to measure if the benefits of a program exceed the costs.
That is true. We also have cost benefit analysis included in this record.
Okay. And Mr. Mark also indicated that in Clean Heat, benefits are measured by the total emissions reductions.
Yes, emissions reductions by nature of the statute are much more the focus or the objective as compared to a DSM, where it tends to be other metrics, you know, avoided kilowatt hours, avoided decatherms, avoided peak kilowatts, for instance.
Right. And those are measures that are available in other proceedings, but not in Clean Heat.
The measures of DSM, is that, or the metrics?
The metrics.
They're sort of the objectives of the DSM proceedings. Here they do happen, but the primary objective is more around the emissions reduction. Or I should say
and the cost effectiveness of the measures are considered relative to other emission reduction measures.
Yes.
And sort of kind of because of this scenario, these tricky aspects of Clean Heat that we've discussed, You've had an opportunity to review the answer testimony of UCA, where UCA recommends that the commission look beyond conventional approaches with respect to gas infrastructure planning as part of the clean heat process.
Yes.
And specifically, UCA offered provided testimony that gas system growth, emissions reductions, and cost containment are fundamentally incompatible.
I believe that's a characterization of the testimony, yes.
Okay. And that the commission must reconcile these incompatible issues in order to achieve the goals of the clean heat proceeding.
I'm not saying I agree with those statements. I think you're reading your own testimony.
You had a chance to review UCA testimony where they provided those recommendations.
I have, yeah.
And in that answer testimony, UCA recommended that the commission take steps to evaluate gas infrastructure capacity reduction approaches as a necessary component of clean heat planning.
I believe that's part of the recommendation. We may need to bring up Ms. Henry Sermos' testimony.
Sure, if we could pull up hearing exhibit 301 and page 7, lines, I believe, 1 and 2.
Thank you.
Okay, and what UCA had recommended was the commission take steps to evaluate gas infrastructure capacity reduction. Is that right?
Is that what you're saying lines 1 and 2 say?
You had a chance to review that. Is that right?
Yes.
Okay, and you'd agree that that's one of the recommendations of the UCA?
Well, what you said and what's said here may not be exactly the same thing. So I'm not sure. Maybe rephrase the question.
Okay. UCA noted that gas system capacity measures will contain costs and create a larger pool of offsetting costs with which to create more cost-effective future with which to create more cost-effective future clean heat plans. Is that right?
Can you repeat the question? Because this was some of the stuff that we were struggling to completely follow in UCA's testimony.
Okay, and if we could scroll to lines 16 through 18. And I apologize, I think I have the wrong citation. Let me just ask you this generally, Mr. Eiley.
Okay.
In answer testimony, UCA raised these recommendations. Is that fair to say?
Yes.
Okay. And in their discussion of gas capacity reduction measures, UCA also raised concerns about stranded assets created by new gas infrastructure.
Yes.
And they raised a concern about assigning those costs to all ratepayers.
Yeah, they did. Yes.
Okay. And this is kind of related to that discussion you just had with Mr. Barroso. Is that, you recall that?
I'd say it's related, yes.
Okay. In your rebuttal testimony, you were critical of UCA, saying that UCA's focus on reducing capacity additions is not a serious proposal.
I think we didn't understand it in the context of the clean heat plan. It feels more like a GIP type discussion. Understanding that they're overlapping.
Okay. And you likened UCA's testimony to reflecting an antipathy for customers' health and safety.
Well, it seemed to be dictating that costs must go down on our investments. And at a certain point, capacity is only one part of those investments. I think it's about 20 to 25% of those investments. Well, I won't get deeply into it. In the current gas rate case, we're not sure how to maintain their safety and reliability which is at least the remaining 75% under what appears to be UCA's testimony.
And
kind of struggling to
and
tie
those
it
are your
together.
words, right? That this reflected an apathy for health and safety.
Those are my words, yes.
Okay. And you were critical of UCA's suggestion that the commission should, quote, order reduced capacity in the system. Is that right?
Yeah, we don't understand how that works. To give you context, we had about 15,000 new customers on the gas system last year.
Hold on, Mr. Eiley.
We're reducing capacity, but we don't quite know how to do that yet.
Okay. And I think you said something earlier this morning with Mr. Smith. You said that words matter, right?
I may have said that. They probably do.
And that language that UCA recommended that the commission order reduced capacity in the system, those are in fact your words, correct?
That was our understanding of the testimony.
If we could pull up hearing exhibit 116, Rev 1, page 60, please. And if we could go to lines 13 and 14. And Mr. Eiley, that language that the commission should order reduced capacity in the system, you agree that that's your testimony. Those are words you wrote, correct?
Yes, this is reflecting what we believe that UCA had testified.
Okay. If we could pull up hearing exhibit 301, please, again, and that page 7, line 1 and 2. And Mr. Eiley, UCA did not recommend that the commission order reduced capacity in the system. What UCA recommended was that the commission should take steps to integrate capacity reduction approaches to further progress gas sector emission reductions through the opening of an investigatory docket on cost allocation of new and capacity related infrastructure investments to the cost causers, correct?
Object to the form of the question. Council's testifying at this point.
Mr. Eiley, you've had a chance to review Ms. Henry Sermos's testimony prior to today.
I believe there's an objection waiting. Sorry.
And Ms. Henry Sermos didn't recommend that the commission order capacity reductions.
Same objection.
If I may respond, I think it's proper impeachment. He indicated in rebuttal that UCA recommended the commission order that. I'm showing him, in fact, what UCA recommended.
Can you just rephrase it so it sounds a little more like a question?
Mr. Eiley, Ms. Henry Sermos did not write that the commission should order capacity reductions, correct?
I don't know. She did not write that here.
Okay. And what she wrote here was to open an investigatory docket to explore the issues of cost allocation for new capacity related infrastructure investments.
She did, and I don't object to that recommendation, actually.
Okay. And I think it sort of came to mind when you had that conversation with Mr. Barroso about imagining a world where an independent hydrogen producer might be responsible for the cost. Does that fit in that? Does that imagination fit within this recommendation?
Possibly. I guess I read this recommendation as more around demand, and Mr. Barroso and I were discussing potential new supply to the gas system, that being hydrogen. I read this as very much more around demand, especially when I read the phrase cost causer, but maybe you can illuminate what it means.
Okay. And UCA also recommended that any approved clean heat plan should prioritize the use of clean heat resources that maximize greenhouse gas emission reductions and provide reasonable costs to ratepayers.
Are you asking me what UCA wrote?
Yes.
Can you show that to me?
You just have an opportunity to review lines 4 through 7.
I'm reading lines 4 through 7.
Oh, I'm sorry. If we could go up to page 6, please, lines 15 through 17.
Okay, thank you.
Okay. And you'd agree that's different than ordering the commission to reduce capacity?
I don't think it's even related to reducing capacity.
You testified earlier that you have been involved in prior proceedings in front of this commission. And I know you indicated that you're not necessarily involved in rate cases, but are you aware that this position of UCA is consistent with their advocacy in the company's prior gas rate case 23A-0392EG?
Which I don't know if I disagree or agree with you. I'm not intimately familiar with UCA's testimony in that gas rate case.
Okay. Are you familiar with the company's quote net zero vision for natural gas?
Yes.
Okay. And are you aware that that net zero vision for natural gas was introduced in the company's prior gas rate case 22AL0046G? Does that sound right?
Introduced to the commission, that does sound right. I think we announced it publicly a bit shortly before that, and I think bringing it to the commission happened during that rate case, as I recall.
And if we could pull up what's in UCA's box.com exhibit 306, please. And Mr. Eiley, are you familiar with this document?
Yes.
Okay. And is this document that net zero vision for natural gas that I just referred to?
This document represents that, yes.
Okay. And are you familiar with that from your role as Regional Vice President of Regulatory Policy?
Yes.
Okay. And do you recognize it from your involvement, from your role and your involvement in resource planning?
I do as a matter of my general duties, yes.
And I would move to admit UCA hearing exhibit 306.
Any objection, Mr. Larson?
No objection.
So admitted.
And in this net zero report, the company detailed their commitment to achieve net zero emissions from the natural gas system by 2050. Is that right?
Yes.
And in the report, the company detailed its intent to get to net zero by implementing a number of measures. And if we could just turn to page 7, please. And Mr. Eiley, do you recognize those measures that the company proposed to achieve net zero in natural gas?
And you're looking at the bottom half of the page?
Yes.
I am, yes.
Okay. And you'd agree with me that some of these technologies that are proposed in this net vision plan introduced in the prior gas rate case include hydrogen, carbon offsets, and renewable natural gas. Is that right?
Yes.
As well as purchasing certified natural gas.
Yes.
And these are similar to the clean heat technologies that were initially proposed in the company's direct case in this proceeding.
Yeah, the three you were citing were renewable gas, hydrogen, and certified natural gas. Is that right?
We have offsets,
Yes.
renewable natural gas, hydrogen, and certified natural gas.
Yes.
Okay. And those technologies were proposed in the company's original direct case in this proceeding.
Yes.
Okay. And some of them have been maintained through the company's rebuttal testimony proposals.
I think in different forms, all of them have actually. I can explain if that's confusing.
Okay. And are you aware that in that prior rate case, UCA was critical of the net zero report, indicating that it sidesteps the huge need to reduce real greenhouse gas emissions from the system and the likelihood that reducing emissions will financially harm the company's gas business?
Objection, Foundation. Mr. Eiley wasn't involved in that case, and you're reading him testimony from the UCA and asking him to confirm that.
If I may respond, I asked him if he was aware of that. He hasn't responded yet.
Mr. Eiley, can you just respond if you're aware?
I'm not closely aware of that, no.
Did you have an opportunity to review testimony in that prior gas proceeding?
No.
In your rebuttal testimony, you referenced the West Metro CPCN proceeding 21A-0472EG. Is that right?
If you can, that's probably right. If you could point a reference to me, that'd be helpful.
Sure. If we could go to Mr. Eiley's rebuttal testimony, page 61, lines 3 through 12. And do you see where you reference that West Metro proceeding?
Yes.
Okay. And I think if we could just scroll down to the bottom of the page, in your testimony, you cite Judge Murbaba's order, and you cite that order in your footnotes. Is that right?
Yes.
Okay. If we could pull up what's in UCA's boxes here in Exhibit 304, please. And if we could, oh, Mr. Eiley, you recognize this decision R220457. This is the decision that you cited in the footnote of your rebuttal testimony where you discuss this West Metro case. Is that right?
Yeah, my testimony cited an extract from this decision.
Sure. But you had an opportunity to review this decision before you cited it in your testimony, correct?
Not in whole.
You just picked a part of it before writing and put that in your testimony?
We picked an extract as a indication from a recent commission decision we thought was.
Okay. And you recognize that this is the case number from that decision?
Let's see. Yes.
And if we could scroll down to paragraphs, sorry, I don't have the page number, I have the paragraph number, I believe it's 149. And Mr. Eiley, you discussed this West Metro case in your rebuttal testimony in reference to sort of your concern that UCA UCA had an apathy for customer health and safety. Is that right?
Yes.
But when you reviewed the West Metro proceeding, you'd agree with me that it was not UCA that recommended rolling blackouts in that prior proceeding.
I'm not sure it was. I'm not sure we stated it was. I believe there was a statement from litigation staff, commission litigation staff in this direction that the ALJ was responding to.
Okay, it was so to be clear, it was staff that had made that recommendation in that prior proceeding.
Subject to check. That's my recollection from a case I was not directly involved in managing or witnessing.
If you say subject to check, if you would it refresh your recollection to review paragraphs 149, 150, and 151?
Possibly.
Let me know if and when you need me to scroll.
Please scroll up so I can see all of 150, please. Thank you. I've got 150. We can try to get 151 in view. That would be great. Thanks. Okay, thank you.
And it was staff that had advocated for rolling blackouts and to whom the judge was directing these comments, correct?
Yes, in this paragraph, that seems to be the case, exclusively staff.
And in this proceeding, in this clean heat proceeding, UCA does not ever advocate for rolling blackouts.
I'm not sure UCA did.
And if they had, you agree that's something that would be reflected in their written testimony?
I would think so. I think where we're getting sideways is the capacity reductions and our struggle to understand what that actually meant.
And in this proceeding, what UCA actually advocated for was what we've discussed, and it sounds like the company supports, which is the commission taking steps to integrate capacity reduction approaches through an investigatory docket.
Well, I think specifically it's around the cost recovery for those potential capacity increases that would arise from new customer addition or customer demand increase of some other form.
Mr. Eiley, on this concept of capacity reduction.
I don't think I said I support it. I said I don't think we oppose it.
Okay.
Don't have an objection.
I think that's fair. Now, Mr. Eiley, on this concept of capacity reduction, and as part of your role as the lead witness in the case, you said you've had the opportunity to review other intervener testimony in this proceeding, correct?
Yes.
And as you know from your review of other intervener testimony, other parties to the proceeding have also expressed support for the notion that the commission evaluate gas infrastructure capacity reduction approaches.
And we have as well through the gas infrastructure plan, as well as some of the elements in the market transformation portfolio. To be specific, through non-pipes alternatives proposals that we ourselves have made.
Okay, thank you. And specifically, COSA witness Mr. Kruger provided cross-answer testimony where he expressed COSA's similar concern that the company's clean heat plan relies too heavily on measures that will lock in continued use of the natural gas system with measures that are not cost-effective and will not eliminate emissions, correct?
That's his testimony. I don't necessarily agree with those statements Mr. Kruger made.
And likewise, WRA witness Mr. Sabuco expressed concern forecasting that the company forecasts gas system capacity investments from 2025 through 2029.
I'm sorry, are you asking me to agree to a statement a WRA witness made?
This WRA witness was expressing this concern about gas capacity expansion investments.
If they are, it's in the record.
And are you familiar with WRA witness, Mr. Sabuco's attachment referred to as the Stratogen report?
I'm probably not super familiar with it.
Would it refresh your recollection to look at a copy of that document?
It may.
If we could pull up hearing exhibit 1401 BC 1B, the public version, please.
Sorry, I just want to make sure I got the number right. 1401 BC1 public?
Yes.
Okay.
We could scroll to page 11, please. And if we could just scroll kind of to the top of, or the middle of the page, please. And Mr. Arley, do you recognize this document, the Stratogen report from Mr. Sabuco's testimony?
I'm not sure I reviewed this one, but it seems to be picking up our own analysis, which I am familiar with.
Okay. And what the concern raised by WRA in the Stratogen report is that gas capacity expansion investments are at the highest risk of becoming stranded because these investments may only be useful for a few years.
And WRA's own testimony shows that gas throughput is only reduced somewhat even through 2030, and clearly not on a trajectory to be reduced to zero anytime after that, or anytime soon after that. And
I appreciate that, but WRA also raises this concern that was raised by UCA about stranded assets.
I'm sure they do.
And instead of gas capacity expansion investments, WRA likewise recommended avoiding capacity expansion by targeting electrification investment in areas forecasted for load growth and implementing electrical and demand side non-pipeline alternatives.
Which is what we have proposed also in the market transformation portfolio and in the gas infrastructure plan.
And in this discussion of gas capacity investment, WRA witness Mira Fickling and Cross Answer recommends that the clean heat proceeding focus on the most cost-effective measures.
I'm going to object to the form of the question. She's reading other witnesses' testimony back to Mr. Eiley. It's not his testimony.
If I may respond, I'm not reading her testimony. I'm asking him about what another witness said in Cross Answer. He indicated earlier that he'd read intervener testimonies.
If you want to put it up on the screen and ask him if he has a reaction to it, we can do that, but you're just reading it off and he has no foundation for it.
Ms. Crampton, you can ask him if he's aware of the testimony. If he's not, you may try and pull it up.
Are you aware of Ms. Fickling's testimony that recommends focusing on the most cost-effective emissions reduction measures?
I'm aware that those are the concepts she's advancing. I think our plan is seeking to do exactly what that phrase says.
Okay. And your colleague, Mr. Mark, notes in his testimony that DSM and BE measures are likely the most cost-effective measures to drive emissions reductions.
He does state that. Also, the work of Mr. Oz and the modeling that we did was meant, it's explicitly pursuing the most cost-effective mix of technologies.
And Are you aware that WRI witness Ms. Fickling testified that the company can offset the overall rate impact of the clean heat plan and beneficial electrification investments by seeking out opportunities to avoid gas distribution system investments?
Can you point me to the specific statement?
Sure, if we could pull up hearing exhibit 1404, Ms. Fickling's cross answer testimony, specifically page 7. And if we can, lines 13 and 14. Have you had a chance to review that, Mr. Eiley?
Yes.
Okay. And you'd agree Ms. Fickling provided testimony that the company can offset the overall rate impact of clean heat by seeking out opportunities to avoid gas distribution system investments.
I'm generally aware, yes, that's not exactly what it says on lines 13 to 15 here.
Ms. Fickling indicated that there were that the recommendation was to exploit opportunities to avoid gas distribution system investments.
That's what it says here, yeah. You said something slightly different than that, so that's I'm just again trying to keep a clean record on words that are apparently already in the record.
In answer testimony, Physicians for Social Responsibility also discussed how the adverse effects of both indoor and outdoor air pollution emitted by the combustion of methane to heat buildings cause health concerns, including risks for asthma, stroke, heart attack, and cancer. Is that right?
Can you show me the phrasing, please?
We could pull up hearing exhibit 1908. Ms. Swain's answer testimony, page 27. And lines 7 and 8. And Mr. Eiley, have you had a chance to review this?
I am reading, I've read that paragraph. Thank you.
Okay. And so Physicians for Social Responsibility discusses the risk of these adverse health effects from indoor and outdoor pollution emitted by the combustion of methane to heat buildings. Is that right?
That's what they're stating.
Okay. And if we could just scroll up to lines 3 through 6, Physicians for Social Responsibility indicated as well that it is often Black, Indigenous, and people of color or BIPOC communities that are disproportionately exposed to this air pollution, including from residential air pollution sources.
That's their statement.
Okay. And this is their answer testimony, correct?
Yes.
You had a chance to provide rebuttal testimony in this case.
Yes.
Okay. And you didn't challenge these conclusions of Physicians for Social Responsibility in your rebuttal testimony, correct?
I don't think that we did. We left a general statement that if we didn't directly rebut a statement, that doesn't mean that we agree with it.
And so sort of like UCA, Physicians for Social Responsibility recommend that, and I'm looking at page 14, lines 5 through 8. And so like UCA, Physicians for Social Responsibility also recommends that reducing the combustion of methane in buildings must be a leading consideration for this commission when it evaluates which clean heat strategies are in the public interest. Is that right?
They state that, and electrification is the largest portion of every single portfolio we brought to this commission.
Now, we've talked about some of the interveners and their positions with respect to the company's gas system as it relates to clean heat. But it's not just intervener groups that have discussed reconsideration of gas capacity expansion projects. Is that fair to say?
Objection vague.
Mr. Eiley, you mentioned earlier you're familiar with the company's gas infrastructure proceeding 23M-0234G, correct?
Yes.
Okay, and I think you testified that maybe you weren't the lead witness, but that you were involved in that proceeding.
Yes, I did.
And you referenced that proceeding in your rebuttal testimony when responding to UCA. Is that right?
You may have to show that to me in my rebuttal. Apologies.
Sure, if we could go to hearing exhibit 116, I believe it's page 60.
And as I recall, Ms. Crampton, the GIP decision came in very shortly before our rebuttal was due. So this was some.
And I'm sorry, page 56, please. And I appreciate that. I'll get to that, Mr. Eiley. And if we could just scroll down to lines 14 and 15. Mr. Eiley, I'm just pointing out where you reference the GIP proceeding in your rebuttal.
Yes.
Okay. And you just indicated a moment ago that the commission issued a decision sort of recently in this GIP proceeding. Is that right?
Yeah, I'm trying to remember now. I want to say it was late in the week before we filed this rebuttal. I think this rebuttal was on a Monday. I believe that decision came in Thursday or Friday just before that, as I recall.
Just a few days before your rebuttal testimony was filed is when this decision issued. Is that your understanding?
Yeah, for what
Okay.
it's.
But you had an opportunity to review, you were involved in that proceeding and certainly had an opportunity to review the decision of the commission in that GIP proceeding, correct?
Yes.
Yes?
Yes.
Okay.
Both are true.
And you would agree that that decision was issued prior to your rebuttal being filed?
I think I just stated that.
And in that decision, and if we could pull up, just for ease of reference, what's been proposed as hearing exhibit 30, or what's been marked as hearing exhibit 303. And Mr. Eiley, do you recognize this document as the commission's decision in the gas infrastructure case?
I do.
Okay. And you indicated that you have had a chance to review this order.
I have.
Okay. I would move to admit hearing exhibit 303.
Mr. Larson?
No objection.
So admitted.
And if we could scroll down to paragraph 17.
Ms. Crampton, I just wanted to check on your timeline.
I think I probably have about 15 minutes left.
Okay. I had you at concluding close to 3, so if you can wrap it up in a slightly quicker manner than that would be great.
I will try. Thank you. And in that decision, Mr. Eiley, the commission noted that the gas utility industry is already undergoing a significant evaluation in how it must do business.
I'm sorry, what are you asking me? Sorry.
You know from your review of this decision that the commission noted the gas utility industry is already going in a significant evaluation in how it must do business, correct?
That sounds right. That seems fairly consistent with the tone of the order, yes.
Okay. And in reaching that conclusion, the commission in fact cited Senate Bill 21-264, which is a statute that gives rise to the clean heat proceeding, correct?
It is.
And in this decision, the commission stated that the company's gas infrastructure planning, forecasting, and budget was overly reliant on its legacy planning processes.
Can you show that to me?
You could go to just the first 2 lines of paragraph 17.
Okay, thank you.
And that you agree that's what the commission indicated in that GIP proceeding.
It's on the page, I agree.
Okay. And that the commission described the company's gas infrastructure planning as, quote, a business as usual approach that is no longer acceptable or in the best interest of ratepayers.
That sounds consistent. I'd benefit from looking at it.
And
sorry, there it is. Sorry.
There's not lines marked, so
you're making me reread a lot of things that are there. So there it is. Yes.
Okay. And in this decision, the commission also cited the gas infrastructure planning rules and noted that the planning rules are intended to, quote, significantly change and modernize utilities infrastructure and capital planning processes.
That sounds right. Can you point lines to me, Ms. Crampton? It is consistent with what I kind of gleaned from the order for sure. And I did read every word, I assure you. We seem concerned about my homework habits.
I'm looking, I don't have a line for you, but the paragraph or the sentence that starts the gas infrastructure planning rules are intended to significantly change.
Yeah, it's about in the middle of the page.
Okay. And in that, the commission also indicated that the significant change brought about rulemaking should include an analysis of alternatives to capital investment.
It does say that.
And similar to the answer testimonies in this proceeding of UCA and WRA, the commission also expressed concerns about stranded assets in the gas infrastructure system, correct?
Yes.
And on this issue, the commission noted that under the current business as usual gas infrastructure planning approach, the company lacks meaningful incentives to restrain investments, only to those which are most necessary.
That sounds like what may have been in this order. I'm not sure if I see it here right now.
Okay. Sounds right from your review.
I'm sympathetic to the fact you don't have line numbers.
I appreciate that.
Yeah.
And if we could go to paragraph 95. And Mr. Eiley, you recall from your review of this order prior to today, as well as what's in front of you, you'd agree that the commission in its decision also denied the company's request to limit the number of non-pipeline alternative projects to 5.
Yes.
And they did so indicating that at this critical point in the transition of decarbonizing heating, that it's imperative to evaluate feasible options to save money for ratepayers, reduce the potential for stranded assets, rather than continuing in a business as usual fashion with infrastructure investments.
It doesn't indeed say that on lines 2 through 4 of page 39 of this order.
Okay. And in this decision, if we could go to paragraph 138, please. And Mr. Eiley, you know from your prior review as well as what's in front of you that in this decision, the commission also expressed a hesitancy to initiate new riders, in particular for cost recovery of projects that they only have a modest comprehension of.
I'm going to object to this line of questioning. This decision speaks for itself.
Ms. Crampton,
I can move on.
it works.
Mr. Eiley, just a few more questions. I just want to shift focus to discuss the projected rate impacts of the company's portfolios, which I know have shifted a little bit through testimony. So specifically focusing on the newly proposed Flex portfolio. I think we talked earlier that the Flex portfolio has a budget of up to 695 or 696 million, which is a budget that is 3.25 times the intended statutory cost cap. Is that right?
Yes.
Okay. And you indicated in your testimony that this budget is indicative. Is that right?
I think we did, and I would generally agree with that.
Okay. And in transmission planning, the company has defined as indicative as a best guess, which is not defined or imply a level of accuracy, but is based on the estimator's experience. Is that right?
It's a similar concept. That's in the in the context of a very specific project for transmission. I think we're using the word here to denote the uncertainties in the cost and performance of these plans. So a much more holistic portfolio type of statement, it's a fairly similar usage, but as opposed to a specific project, we're talking about quite a number of activities. And I think I've been clear about the uncertainties throughout my proposal, and then the budget flexibilities we seek or have proposed and adjusted are meant to kind of help govern, the potential variabilities in the ultimate budget outcomes.
Okay. And this clean heat proceeding and the commission's determination come at a time where customer affordability already is a critical issue for consideration.
I think it's always a critical consideration for critical consideration, yes.
As Vice President of Regulatory Policy, are you familiar with the governor's letter on affordability that was penned just over a year ago in February of 2023?
I do recall that, yes.
Okay. And if we could pull up from UCA's box, hearing exhibit 307.
While they're pulling that up, Ms. Crampton, I just want to check back in with you on your timing.
Less than 5 minutes.
Thank you.
Well, about 5 minutes. And And Mr. Eiley, do you recognize this as the governor's letter we've been discussing?
Not from what I'm seeing here. I don't have reason to believe you're showing me anything else.
If we scroll down, will that be helpful?
Yeah.
And have you had a chance to review this letter prior to today?
I do think I did, certainly during the winter of the last winter, 22 to 23 had some pretty high gas prices, which caused a lot of customer affordability concerns on the electric and gas side. So I think I reviewed it at the time. I have not reviewed this recently, no. We've had a gas price commodity environment, frankly, over this winter.
Do you recognize it as the document that you reviewed then in 2023?
I think so.
And you have no reason to doubt that that's what it is?
No.
I would move to admit hearing exhibit 307.
Mr. Larson?
No objection. I would note that this is going to speak for itself again, so reserve the right to object to any line of questioning around it.
Yes, sir. So admitted.
And if I may respond, I understand the document may speak for itself, but these questions pertain to responding to Mr. Eiley's rebuttal testimony and the issues presented in this case. Mr. Eiley, in this February 2023 letter, the governor noted that Coloradans are vulnerable to unpredictable costs of natural gas. Is that right?
Can you show me that statement?
Sure. If we could go to page 2, paragraph 2. And first and second line.
Okay, I see it.
And so the governor noted that Coloradans are vulnerable to the unpredictable costs of natural gas.
It said Colorado rather than Coloradans, but yes.
Okay. And in this letter, the governor implored the company to work with state agencies like UCA to develop responses that can help reduce the energy cost burdens for the company's customers.
Yes, and we've taken some of those actions.
And since this letter was sent, the commission has approved, considered several proceedings and approved, I guess, portfolios that have had rate impacts on the company's customers in several proceedings. For example, the electric rate case, the coal displacement case, the 2022 gas rate case, and the DSM beneficial electrification case. Is that right?
Since this letter was issued, is that the question?
Yes.
I'm sure the commission has taken actions that affect customer rates.
Okay. And that's in addition to any costs that customers would shoulder for costs associated with this clean heat proceeding, correct?
Yes, this clean heat proceeding and the costs associated with it would be in addition to the items you cited.
And as you've testified, the clean heat statute permits the commission to approve a portfolio that goes above that cost cap, but only if it includes mitigation of rate increases for income qualified customers.
Yes, that's one of the conditions.
Okay. And the company acknowledges that if the clean heat proposals are approved, there would be bill increases that would raise customer bills significantly.
They could, yes.
And you talked a little bit about this with Mr. Smith, so I'll try to move through this quickly, but the company did offer in its rebuttal what it perceives to be rate mitigation measures offered by the clean heat proposals, specifically the APP and the flex portfolios. Is that right?
Sorry, that was kind of a long sentence. One more time, sorry about that.
In your rebuttal, you talk about what rate mitigation you believe the company has offered, and you wrote it sort of with respect to the APP, which is the original portfolio that the flex is derived from, correct?
Yes, and I was being careful there because some of the things we offered would apply to the other portfolios as well.
Okay. With respect to bill assistance programs, and one of the things you note is bill assistance programs.
Yes.
And with respect to bill assistance programs, you would agree that any customer who is not income qualified for bill assistance program would be responsible for the full bill impacts of any clean heat proceeding rider.
I think that's true, yes.
And so that would include customers who make just $1 more than the income needed to qualify for bill assistance.
That would be true. Hopefully they're also able to avail themselves of some of the things that could reduce bills. Energy efficiency actions could help with that. And these plans would build additional energy efficiency optionality.
And these ratepayers who maybe make just $1 more than what would qualify for them for bill assistance, not only will they pay the full increase in their bills, but they will also finance the bill assistance programs that are available to IQ customers who do qualify for assistance.
Yes, I think that's probably always going to be true with that type of a program.
And as noted in the governor's letter, state and nonprofit systems in 2023 were already overwhelmed with the volume of energy assistance requests in calendar year 2023.
Objection form. There's no question.
And Mr. Eiley, you know from your—
I'm going to ask you to wrap this up within the next minute or so. We've gone 22 minutes past your schedule.
If I may, I did waive my 30 minutes for Mr. Goodenough. So I've done a bad job at estimating my time here, but I am almost through.
Wrap up in just a few minutes. We've about used up all of your waived cross already.
Mr. Eiley, generally speaking, a customer seeking out bill assistance is a function of the fact that their energy bill is unaffordable, correct?
Objection, speculation.
Ms. Crampton?
I think the witness can answer the question. I don't think it calls for speculation.
Mr. Riley, to the extent that you believe there's speculation involved, can you could represent that in your answer?
I'd be speculating to, I guess, understand the motivations of the behavior, but presumably someone has a budget issue and they have motivation to seek bill assistance.
Mr. Smith spoke with you about amortization, so I'll move past that. Mr. Eiley, one of the things that you noted in your rebuttal testimony is that a form of rate impact mitigation is the fact that the company was selecting at that time the APP/flex portfolio, correct?
I think so. We might need to go to the context, but our portfolios have generally sought within the realm of what they're trying to achieve. Our portfolios have sought cost-effective combinations of resources.
And you'd agree with me that selecting a portfolio that is 3.25 times the cost cap may be a preferable choice, but is not mitigation of that 3.25 times the cost cap expense itself.
I'm not sure I know how to answer that. It shows more value through the cost benefit analysis, which notably includes the value to society of avoided social cost of carbon, social cost of methane type factors.
And Mr. Eiley, we talked earlier about WRA's recommendations and earlier UCA's recommendations of using avoided infrastructure to offset the costs of the clean heat proceeding cost. Do you recall that conversation?
Yes, and I would point out that increased infrastructure could arise from some of these actions as well.
And if we could just go to page 3, paragraph 1 of that letter. And Mr. Eiley, this concept of avoiding infrastructure to control costs, that's something that also appeared in the governor's recommendation from your review, where the governor directed the commission to implement new rules at the PUC regarding, we could just scroll up to the bottom of page 2. Okay. That the commission implement new rules requiring gas utilities to submit plans for their gas systems that provide more PUC oversight of gas system costs, and then ensure ratepayers do not subsidize the cost of new gas development. Is that right?
Object to the form, compound.
I can break down those recommendations.
I think you should. Thank you.
Mr. Eiley, you're familiar with this letter as you testified earlier. And do you recall from this letter the governor's recommendation that the commission implement new rules regarding gas utilities to submit plans for their gas systems?
And I think the commission has done that.
Okay. And that these new rules provide more commission oversight to gas system costs, correct?
That's what it says.
That any gas infrastructure plans actually align with the state's greenhouse gas pollution reduction targets, correct?
Now you've inserted the word infrastructure and it doesn't say that, Ms. Crampton. Doesn't say that anywhere in that bullet.
That the plans align with the state's greenhouse gas pollution reduction targets.
It says
Correct?
that, yes.
Okay. And this is with respect to gas utility planning. Correct?
It's the plans that we're required to submit.
Okay. And that to ensure that ratepayers do not subsidize the cost of new development.
No object to the line of questioning. We're reading the letter at this point.
I don't have any further questions.
Okay. Thank you, Ms. Crampton. Okay, we are going to take a break for our court reporter here. Let's return at 3:40 if that works. Harriet, does that work for you? 12 minutes?
Sure.
Okay. Let's come back at 3:40 and we will start up with commission counsel and commercial questions. Thanks.
Thank you.
me just check if we have our court reporter back.
I'm ready.
Thanks, Harriet. Next we'll go to Commission Counsel for any questions on Mr. Eiley. Ms. Dundas, Ms. Harper, are you out there?
No questions. As far as I know, this is Miss Harper.
Thanks, Ms. Harper. All right, we will go then first to Chair Blank.
Thank you. Thanks for letting me go first. I guess, hey, Mr. Ali, I want to follow up on a statement you made in response to Ms. Compton. I believe you testified that there's a need to invest significant dollars in the natural gas business to support, I think you said, 15,000 new natural gas customers per year. And it just seems like one way to reduce this investment could be to start going all electric. And
You're on mute. We missed maybe the last two sentences, Michelle.
Sorry, can you hear me?
The last thing I heard was go all electric.
All right. And not building out new natural gas infrastructure to large multi-home residential developments. It seems like in the TEP, the company argued that the marginal cost of meeting new growth is lower than the average cost, such that growth lowered everyone's electric rates and bills. Do we know if the same is true in the natural gas business, or does growth raise everyone's rates? And is there analysis comparing marginal costs and average costs in the electric and natural gas businesses on this record or anywhere else?
That was a heck of a question, Mr. Chairman.
I've been waiting all day.
Yeah. You cooked up a good one. So maybe we'll unpack that a little bit. The premise, or really the statement I was making, was just, it was pointing out the reality that we're seeking to manage as a company. We still have customer growth going on. We did some looking at our records, and over the last 4 years, we've had a total of 50 new, according to our records, we've had a total of 50 new all-electric homes over the last 4 years. So all else equal, that probably means there's 40, 50, 60,000 new gas customers. So, through, I would say, no particular action or fault of the company, this is what's happening out there. Whether that requires a lot of new investment is another question, but it's just saying that the trend is there. Our gas volumes, our volumetric sales were up about 2.3% in 2023 relative to 2022. I don't know if that's a 1 year type trend due to weather. Certainly it's been kind of going up, and we showed that because in our baseline calculations with respect to the emissions trend we've seen. So I agree with you. We need to bend that curve, and I guess if you hear, sometimes it feels like we're shouting past each other in this discussion a little bit, and it's like, I certainly understand the need to avoid stranded investments, and where we can to slow the investment down in the gas system if that's what makes sense for the customer. At the same time, we still got these fundamentals with new customer growth coming on the system. So I really made this statement to point out the kind of not quite meeting narratives and we have to meet that, we have to manage that. So I get the frustration that came through in the GIP order. But I also get customers kind of seeking something that the policy debate here isn't reflecting as well. But to your economic questions, yes, we do think that the electric vehicles joining the system can bring benefits. I mean, I'll make the statement that I think it sort of boils down to, does the incremental revenue from the customer exceed, or is it less than the incremental cost to serve that customer? And we feel like in the EV world, we're pretty confident that incremental revenue can be greater than the incremental cost to serve them. And so that brings a direct economic benefit to the system. To your gas question, I don't know if I know that, to be real honest with you. It's a great question. There are proceedings afoot, to enact what came out of Senate Bill 23-291, which was to stop the line extensions on natural gas. And I think that may be live, and pardon my ignorance if I'm a little loose on that case schedule. But I think that type of a question might be examined there. Because I don't have an answer for you today. It's a good question. It's that incremental cost versus incremental benefits question, right? If I've got it right, I hear you.
Yeah, it's the costs and benefits of growth. It's just clearer on the electric side, if you believe the TAP, that growth on the electric side can reduce everyone's rates, but it's just not clear that growth on the natural gas side isn't raising everybody's rates. Let me try getting at it this way. It just seems like we have measure-specific incentives and rebates. Have you guys looked at a comprehensive all-electric incentive for homes that don't have natural gas hookups? Have we done a dollar per house global incentive in support of having newly constructed entire homes or neighborhoods going all electric? Have you guys looked at that?
On a neighborhood basis, I don't know that we have. I'd probably kick that question to witness Mr. Nick Mark on a sort of all-in electric new home. I'm not as familiar with our portfolio on that.
All right. So say this commission did want to promote all electric new construction on a neighborhood basis as a clean heat resource that maybe cost effectively, given the TEP finding, reduces GHG emissions over the 50 to 70 year life of the new structure. Could we do it in this case? What do you think about giving, say, a dollar per house incentive, say, I don't know, 5,000 or 10,000 per house to the developer of an all electric neighborhood as an outcome of maybe even this case? Any thoughts on that?
Yeah.
Concerns?
Yes. Inside our market transformation portfolio, and I want to get the exact phrasing right, there is a proposal that looks very much like that. So it was one of the 8 proposals, and it was an electrification proposal, and it was specifically targeting new neighborhoods. And so I would urge you to look at that. We have one of the attachments in my direct testimony is a document fully describing the market transformation portfolio. There is a new neighborhood targeting electrification proposal there that's really intended to do exactly what you just said. I don't think we articulated the incentive level particularly, but I'm not sure that that's wrong, the level that you put out there. And those market transformation portfolio items featured partners in that one. I believe at Rocky Mountain Institute is one of the working partners on that. So I think we're 2/3 of the way down the road where you want to go with that piece of the market transformation portfolio.
And just to be clear, would that proposal forbid natural gas hookups to qualify? I mean, to me, the economics is largely driven by the ability not to build the new infrastructure. And it's not only the new local infrastructure; it's also that these new hookups seem to be driving increases in design day peak demand in Denver, which is flowing through other capital expenditures. So did your market transformation program specifically say no natural gas hookups?
That's certainly the intent of the outcome. I'm not sure if there's a specific prohibition, but I think that's consistent with what it's proposing. It's specifically supposed to be a new all-electric neighborhood type concept.
All right. That's all I had. Thank you.
Thank you. My condolences also, Mr. Chairman.
Appreciate it. It's been a very difficult few weeks. Thanks.
Thanks, Chairman. Move on to Commissioner Plant.
Thank you, Commissioner Gilman. Good afternoon, Mr. Riley.
Good afternoon, Mr. Plant.
How are you doing?
I'm doing fine.
Holding up? Good. I had a couple questions, some along the similar lines of Chairman Blank's questions. But before I get to that, I did want to clarify one thing in my mind anyway. We've had a lot of discussion around the seams issues. And my understanding from your testimony is that the company is suggesting that the program should be limited to dual fuel customers. And I understand the argument that you've had with some other interveners with respect to the gas only customers. But does the company intend to include electric only customers as the other sort of seam issue there? And is that included in the modeling?
We did not include them, and I don't know how to phrase this. It was somewhat out of an acknowledgement that other utilities would take our gas customers, and we didn't want to advance with a proposal that's taking another gas customers or gas utilities customers away. It felt like having that discussion in a balanced way in the M docket that we recommended was the next step forward there. And I think we're really quite interested in constructive approaches to that. I think we're not, at this point, we're not quite sure if those are regulatory solutions, statutory solutions. I'm not sure there's anything that blocks us from and we do have about, just for reference, we have a little more than 400,000 electric only customers as well. So our system is really very much like this. So potentially we could have proposed to do that. We felt like it would be, I don't know, unsporting if we did that and not electrify that's the wrong phrase, but at this late in the day. But if we weren't offering to do it for the gas only customers, we thought it made sense to not propose to do it for the electric only customers and try to figure out if there's a more holistic solution amongst the utilities and the policymakers in the state on this issue.
Well, I'd argue that it's kind of the opposite, that you got to have it one way or the other. I mean, if you're saying that the gas customers shouldn't be paying for this, and then you're simultaneously saying that, well, we don't want to pay for the electric customers to take away a gas. I mean, it's got to be one or the other, right? Unless you're gonna find some way to split the cost between the two. I mean, frankly, according to your argument, I would think that we would not only do the electric only customers, but that in some cases, those might be a priority, particularly if you're talking about propane, because the benefits can be exacerbated through that sort of a switch. But, it would be helpful to see electric customers included in the modeling to see what the impacts are there. If we're going to be charging electric customers for the cost of electrification.
Okay, understood. And I don't know how to respond on the modeling there. I think I totally understand the interest in seeing it. It's a pretty wholesale revision on the modeling, I believe. So maybe we need to take that back a little bit.
Yeah, if you could either, if we can address that, in this during this proceeding or in the SOP, that would be very helpful.
Yeah, I'm not having been pretty involved in the modeling. I'm not going to guarantee that timing. We do need to talk with E3 about that. It's a pretty holistic revision, I believe. But let me check with E3 and our folks here.
Okay, great, thank you. And similar to Chair Blank, I was thinking about, the testimony in the TAP that you had modeled downward pressure on rates from the electrification of transportation. And I was wondering if you did any similar modeling within the BE portfolio. I'd note that I think it was JWI 17 has the rider impacts, but not the rate impact. And I'm wondering if you saw any modeling of downward pressure on electric rates due to beneficial electrification.
We have I'm going to our rate discussion. Were you referring to my direct testimony?
This would be with, I'm just wondering if the company did any modeling.
Well, we did. We have, as you know, we had the rider impacts, and those were sort of the first level of analysis, but they were later in the levels of analysis in my direct, and we recreated some of these figures with the rebuttal. We didn't testify in as much length on it, but that is that there's an attachment in my rebuttal that shows that. But we have what we should call a comprehensive rate impact. And maybe we pull up exhibit 101, page 131.
Sorry, my computer froze for a second. I'm pulling it
I
up
wasn't
right now.
honestly sure if I was allowed to request this, but I'm trying to answer the question. So page 131, or actually 133 is a little bit better.
If Commissioner Plant lets you, then you're allowed.
All right, so the earlier figure that we discussed was the rider only, but then this one is reflecting a couple of things. So it shows the baseline estimate of electric rates. That's the blue line. And then the orange line is the rider only impact that we analyzed. So that is another reflection of the rider only impact. But then the gray line is reflecting the increase in volume. So that does create a downward pressure in this showing on the electric rates. So that is a look at that. Now that's our direct case, and this is for Clean Heat Plus. We did update it in my rebuttal, and we can probably I don't know if I know the attachment number right now. It is an attachment to my rebuttal. We may be able to signal where that is for you.
That's okay. I can look it up. Thank you for.
Yeah, we updated this. So there's some downward pressure on rates here. I will say, and kind of in response to Chairman Blank's earlier questioning too, I'm not fully as confident that downward pressure will exist on a long-term basis on the electric side for heating as it does for EVs. And it's simply because EVs, we have a good ability to move those loads around. And I agree with the commission that we should be seeking to do that to ensure the downward pressure on rates. But with heating, as soon as the system crosses into a winter peaking system, and we are seeing that that's a possibility by about 2030, then as you're adding heating load, you are adding incremental electric demand that you need to serve. And I'm not sure those lines don't start to cross at that point. I don't think we have an analysis of that, so I'm giving you my informed speculation. But that to me is a really important part of this transition for us to keep an eye on. And by that, I mean, I want us to keep good data on heat pumps that come into the system, what they, the usage patterns that we see, what that does, what that portends for winter peaking, and what that may mean for incremental system planning. So I suspect that's going to be a discussion over future resource plans, future DSPs, future clean heat plans. So all that to say, I like what this line looks like on figure JWI D9. I am not confident that downward pressure will exist indefinitely at higher levels of electrification, given that we saw some pretty stout incremental costs in some of our estimates.
So yeah, what I hear you saying is it's sort of the incremental increase in sales will have a downward pressure on rates, but your ability to manage that demand may or may not offset some of the distribution infrastructure costs and impacts on the overall rates.
Yes, and we may get into this as we look at attachment JWI4. There was an explicit modeling step we took where we're kind of giving the system credit for the quote unquote slack between winter and summer peaking capacity. And I think this downward pressure could be pretty good until the winter demand exceeds the summer demand. And then I think we need to take a real careful look at it.
Then you start to run into peak system costs.
Yeah, once you start driving peak system costs with additional heating, we need to figure out how much we can manage that heating load on the system and what it's going to cost.
Right. Do you see, and I didn't see this in your analysis, but maybe I missed it. Do you see a corollary on the gas side? So by decreasing the sales ostensibly in a sort of a comparable way into which you're increasing sales on the electric side, that you would have an upward impact on rates within the gas system?
I don't know if I'm prepared to speculate on that. I mean, you sort of asked the inverse question of what the chairman asked a few minutes ago. These are good questions. I don't know if I can speculate on that sitting here, and I think we should consider that further.
Okay. Yeah, I would be interested to know if you see decreased sales volume having any sort of a proposed impact on the gas side.
Yeah, and we did model that in the long-term sense, and again, that's an attachment JWI-4, which was it was the long-term rate forecast that sort of was the companion analysis, if you will, to the 2050, long-term scenario analysis, call it, that we put in my direct. We then turned around, and that was in it was in my supplemental direct. We developed that long-term rate forecast. So we definitely showed some dynamics there in a live spreadsheet that explored those dynamics further in a long-term sense. Great.
Thank you for that.
Yeah.
I'm gonna move on to another issue. You can take that down if you want. In the discussion, I think that you had in your response testimony regarding, I believe it was WRA's example of the main program, you brought up the fact that they have fuel oil, they don't have as extensive of a gas LDC there, and I think fuel oil is probably about 3 times the cost of natural gas, although that differential may have been different last year. But I understand that argument that the main program is going to be different from Colorado because of differences in the heating fuel mix. But did you have any substantive disagreements with Mr. Pierce's testimony regarding the recommendations that he had for the Excel program and the lessons that could be learned from the main program?
As far as sort of like marketing techniques and how you maximize your program effectiveness,
right.
I don't think we do. That's a great question for Mr. Mark, who's more of our program implementation witness.
Okay.
But yeah, you already noted, but we're pretty, we think we should be mindful of the kind of fundamental economic differences and sort of convenience differences that the main customers are facing versus a Colorado customer on our gas system.
Yeah.
That's not to say there aren't positive lessons to be learned from their experiences. Yeah, I'd love to talk to someone who's administered 100,000 heat pumps that could be very beneficial to us.
Yeah, I appreciate that. I thought there were some good sharing of best practices as well. And I'd also note that they highlighted on-bill repayment and financing, but I'm not going to go into that because I know you're going to get that taken care of in the DSM proceeding. One quick question about that I had, just sort of a basic understanding of how programs within this proceeding would differ from the DSM BE proceeding. You've got those programs that are designed for beneficial electrification and DSM. You've got additional programs here. Does the company see this as just having more rebates? Does it see it as having increased rebates? Does it see it as having a different target? You're targeting contractors and workforce, or what are the fundamental characteristics of a CHP BE proposal that are different from your standard DSM BE proposal?
Yeah, this has been a question that's kind of been bouncing around since the bill passed. And it had particular incrementality language in there that said the budget shall be in addition, I think I'm paraphrasing, but shall be in addition to existing DSM budgets. We see these as supplementing and potentially building on the programs from DSM. Some of the programs may be the same. Ultimately, customers are coming to Xcel Energy and interested in rebates, and so are their contractors to take these actions. They, of course, won't care as much about which program the funds came from. They want to know what it does for their, for their heat pump installation, for their air source water heater installation. We see these as potentially adding to the number of rebates we could issue, as well as potentially increasing the value of those rebates in order to achieve the levels of implementation that are contemplated here, which they're pretty aggressive. That's our position. These are very aggressive rates of implementation. We think that there may be a need for increased rebates over current levels, even though the current programs are operating reasonably well, as I understand it. We may need to increase some rebates to accelerate that. And that gets into the kind of the scalars discussion we have. I mean, agree with it or not, that sort of propelled the intellectual thinking behind the use of the scalars. And this is one where Mr. Mark can, I think, can opine, with more greater insight, because he comes out of that DSM implementation world and thinking about how we'll take those funds into the DSM program. It's the same teams and the same customers at the end of the day. So yes, more rebates, potentially higher rebates, and probably Mr. Mark could supply more insight.
Yeah, I can, and I can, follow up with Mr. Mark. I guess that'll probably be tomorrow or something, about this. But I'm wondering if there's, just as a sort of a highlight to Mr. for tomorrow, I'm wondering if there are limitations that are placed on the current DSM or BE programs that do not exist here, and whether or not the funds from here can, make those investments more effective, more useful, get to more people, reduce market barriers, et cetera, et cetera.
Like differences in how we can target action, between customers, contractors, OEMs, et cetera.
Yeah. Just different ways of utilizing these funds in order to make the entire thing just more effective and faster.
Yeah, I think I'll let Mr. Mark take that.
Okay. Yeah, that's fine. And then, I think we had this discussion with UCA. I think both the company and WRA want to choose the most cost-effective solutions, but I guess that depends on sort of what your cost-effectiveness metric is. And on page 50 in your response testimony, you say the WRA sweep CC cost benefit analysis only includes utility program costs, unlike the company's analysis, and excludes the remaining incremental costs that must be paid by customers. I recommend the commission carefully evaluate the cost assumptions in their testimony. I assume you're talking about a TRC versus more of a UCT approach here.
Yeah, and partly that's alluding again to this dynamic with the electric system. Noting that these are preliminary figures, we saw some pretty impressive incremental electric system costs, and even in the near term in some cases. When you say
incremental electric system costs, you're talking about distribution infrastructure improvements, or what are you talking about there?
Everything: distribution, transmission, and generation. It depends on the specific scenario as to when those costs came into play.
Okay, and you're saying that within the WR sweep CC analysis, they did not include those infrastructure costs?
I believe that they did not.
Okay. And I had some other questions on the sort of the development of the program, but I can bring that up with Mr. Mark tomorrow. As it relates to the hybrid heating systems, you mentioned on page 52 of your response testimony that heat pumps are going to be a component of the transition to all electric. I'm curious about whether or not the company has certain standards on the hybrid systems. I mean, obviously, much of the efficacy of a hybrid system is going to depend on when that system switches from natural gas to electric and back. And I'm wondering if the company has within the structure of the hybrid heat pump systems that are approved within your program, is there a certain temperature target there? As an example, I'm just, if you have a 40-degree switch point, you're probably going to be using natural gas all winter, in some parts of Colorado. If you have a 20-degree, it's going to be a significant reduction. And I don't know if that's reflected within the set point of an approved heat pump, and if that then corresponds with what you're using for your modeling in terms of how often that natural gas would be used instead of the electric. How does that work within the company?
I feel like that's excuse me. I feel like that's a question that's something of a programmatic question in terms of how we implement our programs and what's required for those. I'll kick that to Mr. Mark. In terms of the modeling, I'm not sure how explicitly we have that modeled at this level of modeling. That I might want to ask Mr. Oz about that, or might ask you to ask Mr. Oz about that.
Okay, I can follow up with Mr. Oz.
I appreciate the question. I mean, it's definitely an area of interest, both in planning and in that part of the industry as well. It's like, well, certain heat pumps can definitely go into lower temperatures. They're rated at different temperatures, but then where is the set point set by the installer and the customer? And it might just be the installer. Where is that actually being set? I understand that itself is something of a point of, kind of study, if you will, or interest.
Yeah, that's why I was wondering if there is some sort of company standard or if there's some sort of an assumption that you're using in terms of that temperature, but I can follow up with.
Fair question. Yeah.
On the certified natural gas, can you tell me if there are any either federal or state protocols around certification that either this, what you're proposing, the CNG that you're proposing would adhere to, or if there's one out there?
I don't know if there are federal or state proposals. That's usually where the regulation happens. This is a little bit more akin to third-party self-certification, if you will, or the standards are developed really, frankly, by the industry and by the certifying organization. So there are 2 or 3 of these organizations out there, and I don't know if you're familiar with the Green E. That's a certifying organization that was is present in the renewable energy sphere for a long time, with respect to like voluntary renewable markets. I think these are a little bit of sort of a distant cousin of that. So Canary is one, which is led by Governor Chris Romer, the son of Governor Roy Romer. There's one called MIQ. I think there's a third one. So they're really independent certifying bodies. And our intent is to be very transparent about what we use and willingness to show what sort of differentiation and certification they're offering. Noting that needs to be, credibly better than the system average, if you will, system average emissions rate. That needs to be part of that protocol. And Ms. Quillian is the higher expert on this in the case.
Okay. And have you approached at all the AQCC or any of our sort of agencies that would do that kind of air quality certification in order to try and create some sort of standard of that nature?
I don't know that we have. I mean, I get the sense that they are very busy implementing actual regulations and not so much voluntary.
Who isn't?
I hear you. We're all doing that. And we're actively pushing on them to enact further protocols for types of recovered methane we could use. So my general sense is I don't know that we've approached them with that specific question. That's another good question with Ms. Quillian. She's much more in frequent contact with AQCC over the last few years than I have been.
And just so I can understand sort of the scale that we're talking about within certified natural gas as you're proposing it here, is the is the are the upstream emissions that would be reduced from a certified natural gas product, would they be about the same as what our current Colorado requirements are, or would they exceed the Colorado requirements? Or are we basically just taking those Colorado requirements and basically placing them on gas that might be coming from anywhere? How does that work exactly? Or what's the relative impact of the certification versus our current rules?
Well, certainly the intent of the certification is to exceed what is a mandated regulation. I don't think we'd be trying to claim reductions that regulation would have driven anyway. So it's meant to be a voluntary but additional set of standards that a supplier, and there's midstream aspects to it potentially also, would be meeting, such that they would be exceeding a state average or other applicable type of benchmark or baseline, if you will.
But I'm assuming some of this natural gas is not coming from Colorado.
That's true. We source gas from places besides Colorado.
So what I guess I'm wondering is, does would the certification of the gas, would that be from primarily out-of-state sources that are not subject to the requirements here in Colorado, but would get them to an equitable level? Or does it compare favorably to Colorado's existing regulation?
That I probably want to defer to Ms. Quillian. There's also another witness in this case, and I don't remember if we've excused him or not, but Mr. Lush, who works for Williams, which is one of our partners in the market transformation portfolio element, which was meant to sort of launch our involvement in CNG. I think you'd find him educational. I don't know if we excused him or not.
Okay, well, check with Commissioner Gilman. She can tell me if we excuse them.
Mr. Lush is still in.
He's still in. Okay.
I can tell.
All right, let me see what else I had here. On the hydrogen, with respect to the hydrogen, on page 18 of your response testimony, you said customer appliance impact is not an issue at low hydrogen percentage blends. And I was just wondering, in saying that, are you talking here about specific damage to appliances, or are you talking about combustion of the fuel? What do you mean when you say not an impact at that level?
I'm not seeing that. Sorry.
I think I had in my notes that it was page 18. Is that not correct?
I don't appear to be discussing hydrogen there. I'm discussing the various portfolios.
Oh, great. I wrote down the wrong thing then.
Sorry.
I don't know if you recall that where you were talking about low integration of hydrogen did not have an impact on appliances at that level.
I think that's our general position, and I think we're discussing the impact on the appliances, as well as just industry experience.
Okay.
Mr. Gardner and Mr. Jensen are closer to that than I am. I would have been summarizing what their test, because they both have substantial portions of their testimony dedicated to the factors around hydrogen implementation.
Okay. Thank you. Understand. You see if I think I had one more. Yeah. So my last question, since it's my last question, I get to go a little Western, get a field a little bit. But I'm just wondering, I was curious in reading, we've obviously been discussing, green hydrogen versus blue hydrogen. And I was wondering if the company is involved at all, or you may not know, I don't know, in the geologic hydrogen project that is being pursued by mines and USGS
I don't know that we are. I don't know if I've heard of our involvement in that particularly.
Okay.
I could be wrong. Yeah, Mr. Jensen and Mr. Gardner might be worth chatting with about that.
Okay, great. I will follow up with them. Thank you very much, Mr. Riley. Appreciate it.
Thank you.
All right, back to me. Sorry, just trying to get a sense for our confidential session. I probably have 25 minutes of questions first, so I'm just trying to get a sense of how annoying it is to set up and if we'll take it at the end of the day today or tomorrow morning. So I'll hear back soon and then we'll know. Let's see, I'll just go on for now and then maybe we'll cross that bridge when we come to it. It'll be toward the end. Good afternoon, Mr. Ivey.
Good afternoon, Commissioner Gilman.
Acting
Chair Gilman.
Yeah. I did appreciate that you lamented over having to recall 380 pages, but you wrote it. We all had to read 380 pages.
I get it.
Okay. Few questions. The first few are from several different areas, so I'll move around kind of quickly in the beginning here. First, with regard to workforce, and I was curious, to what extent did the company investigate, or do you plan to investigate ground source heat pump or networked ground source heat pump systems, which might provide for much more kind of directly transferable skill set for some of, especially your pipeline workers?
We're looking at that. We actually have a statutory requirement to submit a project to you all by September 1. So we are looking at that. As far as the particular workforce aspects of that, we will. I don't know that we have looked at that closely yet or not. It's a good point as far as transferable skill sets into that area.
I think along the lines also of, you've brought up some of the electric system impacts, which you've characterized as either substantial or, very large in some of these cases. And I think that's primarily based on the backup, if we have electric resistance backup to electric heating, which clearly, a ground source solution could eliminate. So just curious, if in this initial round, the company considered ground source at all, given that attribute as well.
We didn't look at it in the modeling, to my knowledge. I don't think that impact arises exclusively from resistance backup. It is kind of the combination of the heat pump and the backup function, but that might be something you might want to chat with Mr. Oz about. Okay. But I agree that there's interesting potential to avoid some of that with the geothermal systems. I think there's questions about scale there again, and it's a very interesting area for us to continue to evaluate, but it's at this point, we didn't look closely at it. We do need to bring that application to you. I believe it's an application requirement by September 1. And that statute also, as I understand it, made that an explicitly eligible technology for clean heat. So I think that technology is knocking on the door, and we're going to struggle to complete cases and also kind of adapt to everything. We need to try to build flexibility into this and adopt or adapt to new things as they arise. This feels like an example of that.
Okay. Question on distribution system for electric. I hosted a workshop. I don't believe you were there. No worries, we missed you. February 22nd and proceeding 23M-0464EG, which is implementation of some of the 291, Senate Bill 291 measures. But we were talking in part about integration of state policy goals with DSP planning. And in that meeting, a company representative stated they were getting close to finalizing forecasts for the 2024 DSP. And so I was wondering, with this ongoing and kind of so much implication on the electrification side, as you note, in almost any of the portfolios, I was just wondering to what extent and upon what portfolio is the company doing their forecasting for the DSP, especially as it relates to the electrification component?
I don't know if we've landed on one. I mean, I think the decision in this case will be strongly indicative of where we need to go. And I'm certainly aware we need to do a low, medium, and high type look at electrification. So I think it's going to be more reflective of this case than not. So it's under development, and it's one of the reasons that we did seek that deferral of the filing.
Okay, so to your understanding, the company will be able to incorporate the outcomes of this proceeding in terms of like indication of quantities of electrification into the DSP forecasting and planning for the 2024.
Sorry, yeah, interrupted you. That is my understanding, as well as while that team is adopting a new model, kind of getting a new model up and running to improve the forecasting there.
Okay. With regard to the SEAMS issue, I understand that the company's broad perspective is it's essentially unfair to have the gas customers fund electrification of gas only customers, correct?
Yes.
So help me walk through kind of the flip side of that. If the electric rate base is funding a significant majority of the measures necessary, or in the electrification only case, all of the costs associated with compliance for the gas business in a statutory greenhouse gas reduction, is that fair?
So I'm just trying to understand the question. So agree that the electrification only case would be charging all the customers, all the costs through the electric rider. I think that's part of the framing here, right?
Yep.
Why
So
are we
just trying to
charging?
understand, essentially to some degree talking about a cost of compliance with the statutory greenhouse gas reduction required of the gas business. And is it fundamentally fair to have electric customers who are at different rate base shoulder all of the compliance costs if we say went with an all electric portfolio?
If you went with, you're talking about the electrification only portfolio?
Yeah. That's the most extreme example. In the others, the lion's share of investment is still taking part in the electric rider, but that is the most extreme example.
It's definitely the most extreme example, and that's somewhat by design. I don't think we really thought through the specific rider application on that one as closely. It was never one of our preferred portfolios. It was almost a far edge illustration exercise. I sort of get your question as it distributes across other more electrification heavy portfolios. Yeah, that's an interesting question. I don't know if I have a specific response to it right now, depending on which portfolio you're thinking about.
Okay. All right. So a couple questions on certified natural gas for you. So the company proposes to recover the cost premium for certified natural gas through the clean heat support gas adjustment, correct?
We actually changed that because we backed the CNG out of the in the additional supplemental direct testimony. We backed the certified natural gas out of the clean heat eligible portfolio. We left it as an additional measure, so that we started to call it vertical 3 in the rebuttal testimony. But long story short, we applied it to the GCA, the gas cost adjustment, those incremental costs, instead of the clean heat support gas adjustment.
Thank you for clarifying. And that new one is a very tortured acronym.
Yeah, it is.
No way to pronounce that, so you can't make that better. Okay, so in your vision or your ask here is that the certified natural gas kind of concept would be approved here, but then the actual cost would be approved in future GCAs?
Yeah, they would flow through. It would be approved for recovery through the GCA. Now, the fuel itself would be just like any other natural gas purchase. it's the incremental piece that's really what the approval sought here is. And it tends to be, as I understand it, on the order of 5 or 10 cents per million BTU. So, at a gas cost of $2 or $3 or $4 per million BTU, relatively small adder on top of what you're already seeing flowing through.
Thank you for clarifying. I wasn't up to speed, but there's a lot of details here, so benefited from that. How will new EPA rules concerning methane emissions interact with the certified natural gas market and kind of its voluntary nature and what the baseline would be of what's considered certified natural gas?
I'll answer at a high level. I mean, great question for witness Lauren Quillian, our company witness Lauren Quillian. Our intent with the CNG is really, if there is some good work to be done sooner than the regulations catch up to the market, and we can obtain those emissions reductions, this is a good practice for us to do. So I don't know if I'm close to EPA's methane regulations, and really CNG is seeking to create additional emissions reduction than the minimum regulations would employ. CNG should be driving additional emissions reduction. That's the idea. If the regulations catch up to us and CNG doesn't really add value anymore, we've won. If this is only a tool that's useful for 2 or 3 or 5 years, that's okay. We're reducing emissions, especially in the state of Colorado. And if it sort of becomes redundant, or the regulations just render it sort of superfluous, great. Then we have better regulations.
So you kind of led me to my next question. I'm wondering, what are the typical terms in terms of length of CNG agreements or contracts?
We've done some very short-term deals. Again, I'd probably ask Ms. Quillian to opine about that. She's stayed closer to that more recently.
Okay.
I'm sorry, and Mr. Lush, I apologize, of Williams as well. He might be he kind of works in this quite intensively, as I understand it.
Okay, great, thanks. As I understand the certified natural gas proposal, it would basically set kind of a floor of leakage that's based on the average of emissions in Colorado, kind of the upstream, and then you would be considering the carbon emissions of the delta of the average and what you're getting. Is that accurate?
Yes, conceptually that's accurate.
Okay. I was curious if you could tell me today, how do the upstream emissions of the natural gas procured by the company compare to the state average upstream emissions?
I don't think I do know that. I suspect they're going to be pretty similar because we source a fair amount of gas from Colorado, but that's we'd have to come back to you on that. Maybe Ms. Quillian can, maybe we can develop an answer that will be ready for her by the time she gets up.
Okay. A few questions on market transformation and innovation. So first on the advanced mobile leak detection project, and I think Mr. Gardner might know some of these if you don't, right? So
yeah,
see how it goes. How does the verification that you all proposed in the advanced mobile leak detection project vary from any current or upcoming regulations around advanced leak detection?
I am probably going to defer that to Mr. Gardner. I don't know those details in enough detail, or those regulations in enough detail to answer that.
Okay, I can hit you with perhaps a more general rate recovery. You're always here for the rate recovery questions. Given that this proposal around the advanced mobile leak detection would include rider recovery, is that correct? Are you proposing to recover those costs through the Clean Heat Rider?
That's right.
If the level of advanced leak detection in your program became commonplace or became required by any new regulations, would those costs still be recovered in the rider, or should those transfer to more conventional rate recovery?
I guess it feels like a hypothetical. I'm not quite sure where those regulations stand right now as far as how rapidly they're advancing. I could see that, like, you know, there's other regulations that drive activities that we do that we would recover more through a rate case type structure. So I could see that shifting to that world.
Yeah, I think it's fair. It is a hypothetical. Just I think part of the pitch for these as part of rider recovery is that it's kind of above what's required, right? It is a proactive measure. So I'm trying to figure out where we stand with rider recovery if it's no longer a proactive measure.
Yeah, in that case, I think you have that discussion. I mean, I'd point out that methane reduction on our system is one of the eligible technologies for the clean heat plan. So we see this as consonant with the objectives of this statute.
I read in the testimony the advanced leak detection budget here is for 2 monitoring units. Are you familiar with the details, or should I just save these questions for Mr. Gardner?
The first part's true, and you probably want to go next to Mr. Gardner.
Okay. Looking to better understand kind of what amounts of the system that gets us surveyed on the interval. So I'm reading that I should probably ask him that, so I'll move that to him. For the commercial flue gas capture project, what's the potential concept of where the flue gases go? Where are they stored or separated or transported?
That one is so we have a separate set of, you know, I would almost call them concepts under that under that rubric, and that would be further developed and then proposed back through the 60-90 day process. This is somewhat like in the TEP we had, and we called it the Partnership Research and Innovation Portfolio. We did several projects there, which involved B2G. But to your question, I think that's all to be developed. We understand that's a concept that has arisen in the market that we think may be interesting, especially for the hard to decarbonize type sectors. So we'd have to develop that further. I'm not aware that there's been a lot of specific project development on that. I think we're kind of waiting to see where the case goes here and how that's incorporated or not in the market transformation portfolio. We're certainly willing to report further back on it.
Okay. And what's the specified budget for that in the market transformation?
I want to say there's no particular number on that. I think we left a certain amount of those funds kind of unspecified and basically brought those concepts as potential examples. And that is similar to what we did with the PRI portfolio and the TEP.
Okay. So if the commission approved the total budget, it doesn't sound like we have an exact idea of what projects will kind of be prioritized or receive what portion of the funding.
As we propose, the way that we propose it, we'd work with stakeholders to kind of further those concepts. Again, we really do try to find like good common ground where people support things. That happened in the TEP. We worked with our stakeholders to develop those concepts and advance things that really didn't have opposition. So it would arise in a similar fashion as we propose it here.
Okay. Going to the recovered methane coal bed study. Is there a budget for this particular program?
Is this the Ute Mountain one?
Yeah.
Yeah, there is a budget proposed for that.
Are you familiar what it is?
Trying to think the quickest way to look that up.
You can find it on redirect. I don't want to torture you.
Yeah, it's here. Sure, that works.
Yeah. And this is for the actual project, not just the study, right? To actually move forward with the project procurement. Right. Okay. Regarding the statutory clean heat resource, inclusion of coal mine methane, but not coal bed methane, is the company aware of any pending legislation that would add coal bed methane as a clean heat resource?
I don't know that I do have familiarity with that at this point.
Okay. In the testimony, it indicated that a Department of Energy grant was awarded for this project. I was wondering if you had any details for me on kind of the status and details of that grant, like who was the applicant? Do we know an amount of the grant or what portion of the project it funds?
I think I'll direct that to Mr. Weinberg. He's been closer to that project than I have.
That works. Now, as I understand it, this is essentially a coal bed kind of seeping, I think was the word I saw in testimony, seeping methane into the air right now. Is there any kind of verification or measurement as to the amount of coal bed methane currently being vented into the atmosphere on an annual basis by that project?
I would ask Mr. Weinberg to what sort of like monitoring and baseline activity have occurred for that project.
Got it. Okay. Okay. A couple questions on the hydrogen demonstration project. So it's my understanding from the testimony that the company has already spent $700,000 on preliminary activities. Is that correct?
I would probably need to confirm with Mr. Gardner. I don't know that number was in my testimony.
Okay.
But I
don't have a note where I found it, but I found it. Is the company seeking cost recovery of any already completed expenses regarding a hydrogen demonstration in this proceeding?
We need to confirm the number, but I think we would seek to recover those, yes.
Okay. Do you have any explanation of what those costs are, or are they shown in the record to your understanding?
I think I want to have you ask Mr. Gardner that.
Okay. Let me just make sure I write his name right where I need him. As part of the kind of retooled hydrogen plan, you plan to identify commercial partners in hard to decarbonize sectors. Do you anticipate that analysis is around kind of analysis and conversion around serving customers with 100% hydrogen or some blend? What's kind of the concept on how, what the product is you're having those discussions with?
I think it could be either. I think our intent is to run an RFI and sort of see what customers in the market are seeking. We have reason to believe there are customers with sustainability interests, and they may be in sort of hard to decarbonize sectors. So I think we want to find a fit with a partner, and it could be a blend or it could be 100%, depending on what their specific needs are.
And these are typically customers already taking natural gas service. Is that a fair assumption?
I think it is a fair assumption.
Okay.
I don't know if, it's a good question. It's like if we were serving them electric, but there's somehow, I guess I could conceive of customers that have process heat, not from our natural gas, but they might be electric customers. That probably gets into interesting certificated service area questions, but I think our main intent is those who we are serving natural gas from.
What if they're transport customers who aren't paying into the rider?
I'm not sure they'd be eligible. I think that would be philosophically consistent with how we propose the overall case here.
Okay. And I know this is the whole plan is to kind of study and begin to figure out what this would look like, but I'm kind of struggling to understand how they would or could be isolated on the system if only they kind of agree to take a certain percent of hydrogen. How does that work in essentially an integrated networked system where the molecules kind of go where they will?
Yeah, I would ask Mr. Gardner that. Sort of how do you get downstream and isolate the molecules?
Okay. I think you went over this today earlier, but you identified the residential blending project that was originally proposed is not off the table, but rather on a lengthened timeline, which would be contingent upon that 2026 check-in point proposed by the company. Is that accurate?
That is accurate. Also on the development of the proposal to test the hydrogen at our own company-owned facilities in isolation, and also on that customer pilot that we just discussed.
Okay, so the company's current concept is that it would be possible for that abbreviated check-in process with just the rounds of comments, that the company could seek approval to move forward with the residential hydrogen project in that flex budget. Is that accurate?
That's the proposal, yes.
Given that we heard some concerns, especially from customers in that area in opposition to the project, how could we, through a process like that, provide an appropriate venue, especially for interested or affected customers, to be involved in this process?
I certainly want them to have the opportunity to provide their views to the commission. I think we've done our fair share of outreach on this, which you may not glean from the popular media. I think you could certainly do a commissioner's information meeting or a sort of a hearing that is prioritizing the voices from that community. That's an option to hear from that community. We're not opposed to at all to getting alignment with that community, and I think that's part of the spirit of sequencing these projects in this way. We want to A, learn more, and B, ensure that we have alignment with those customers if that pilot goes forward.
Okay. And you identified in your rebuttal that you expect costs for the new scopes to be around the new hydrogen scopes, I should say, to be around the previously communicated $6.3 million total, but are quite uncertain of the actual costs and request flexibility to reallocate part of the MTP's funding if needed. Are you proposing any caps as to what could be reallocated?
We weren't as specific on that in the market transformation portfolio. By and large, those projects are meant to be not to exceed type estimates in that market transformation portfolio. Upon a fairly quick pivot, we thought the 6.3 could cover the other two projects that we proposed in the hydrogen realm, and then we thought we could come in and have the discussion in 2026 about any further funding on hydrogen blending or usage by customers.
Okay. Now switching gears a little to non-pipe alternatives, CEO brings up in their testimony that the addition of Pearl Street and the F3 reinforcement, and that the company should pursue the Meade to East Longmont reinforcement and Fort Lupton compressor stations as MPAs, perhaps even as part of the clean heat plan, I think, as I understand it. So just trying to understand the linkage here, in its decision and conclusion of the GIP, the commission indicated we were encouraged by these analyses and were concerned that waiting to implement the NPAs might make them infeasible if we didn't continue to kind of move forward on this analysis and potentially implementation on potentially feasible projects. So we directed the company to continue to move forward with a more robust analysis and cost estimating to ensure that any cost-effective NPAs could be pursued in order to avoid the need for the project. So I just wanted to kind of check in with you on the timing, especially of these two other potential NPAs that floated around during the GIP process, and kind of understand how any analysis on them would move forward, especially if we just approve the two NPAs out of the GIP now and not those others.
So these two additional ones, and just I'm sorry, are they? Yeah, You might remind me what the GIP order said about those. I apologize.
I think the GIP order expressed some concern that if we wait too long to continue robust evaluation, we could miss the window of potential implementation. So I'm trying to think through. I know the company's made it pretty clear that establishing cost recovery beforehand for NPAs to be viable is very important to you. And so these just recognizing kind of the cadence of these different filings and when, any further analysis for these others might come before us. I'm trying to understand the feasibility, if you don't seek cost recovery for other NPAs now, how that ever kind of gets in the flow and provides you the cost recovery you've said is necessary to even begin implementation of NPAs for other projects.
Yeah, I'm thinking through that now. We didn't propose them in this case. I'm trying to think if there's something we could do in the general GIP stream, or maybe because I know that we have to propose the cost recovery coming out of that GIP order for the other two NPAs. Maybe that's something we can take back and figure out if there's some kind of response we can make to that question in that order. I'm sitting here just thinking through, like, the next GIP is May of 2025. I know we have the sort of GIP check-in, but I'm not quite sure if that fits that scope or not. And it doesn't sound like you want to wait till May of 2025 to hear about this next. And I hear that and understand that for the NPA timing reasons. I'm not sure I have an answer to that sitting here now, but that maybe we can opine about that in our response to that GIP order on the cost recovery of the two NPAs that are approved, presumably.
Thanks. Yeah, just want to kind of better understand how we see it all integrating together, especially I take the company's point that figuring out the cost recovery is important. So I'm trying to figure out what the cadence of these proceedings, if y'all are still analyzing some of these big things, but determine it's feasible, where does that put us?
Yeah, and I appreciate your willingness to at least hear us out on the cost recovery piece and the resources we want to bring to bear on those.
Let's see. You also mentioned the Mountain Energy Project. I think it's called the Mountain Energy Project, which is broadly a capacity constraint on the gas system in the mountain region. Is that accurate?
It is.
You bring up that Mr. Martz addresses it in his direct testimony in 24A-0392EG, which is the company's new gas rate case, correct?
Yes.
Now in that testimony, he indicated that the company has been intensively reviewing alternatives to the gas infrastructure solutions for nearly a year and anticipates putting forth a solution that focuses entirely on NPAs and no traditional infrastructure. So I was just wondering, and especially in the context of the Clean Heat Plan and not seeing it here and understanding your arguments for cost recovery, kind of what is the company's plan to present that NPA? As I understand, you would probably be seeking some cost recovery.
My understanding is we plan to bring that in 2024. And I'm not entirely sure on the timing of that filing, but that's my understanding of that.
Okay, so some sort of out of cycle filing.
Probably, yeah, probably a distinct application. Honestly, originally that the potential conventional capital investment on that absolutely merited a separate application outside of these plan filings and kind of required it. Now we're looking at more of a super NPA type approach. I don't know if it's, I'll trust Mr. Martz on whether it's exclusively NPA and zero conventional investment or mostly, put it that way. But
you put the word no and it was italicized.
What's that? No in italicized?
It was. I just read it last night. Okay. Well, I would say perhaps as you all are planning that that filing, think through my other questions on the other NPAs, and let's try and figure out how we get this timing to work, just so we don't miss them as a result of the cadence, and come up with, what could a plan be where you all have the time to evaluate NPAs, but we're not missing them in these proceedings and missing the window where they're viable.
Right. And we're always looking for an opportunity to streamline filings. I don't know offhand if there's some synergies between these 2 or 3 threads that you've just mentioned or not. It's worth thinking through.
Okay, great. I have probably 15 more minutes of questions. I think it's clear we'll get to the confidential session first thing tomorrow morning in my timing. But I'll move us as quick as I can. Ms. Federico, you don't have a hard stop at 5, do you?
I don't.
And Harriet?
Sorry, I'm fine.
Okay. All right. I'll try and wrap it up as quick as I can. Next, a question, Mr. Eiley, about health impacts, which I know are addressed by some other witnesses, but in all honesty, I did not find much on the company in this regard. Just wanted to understand if the company is aware of reputable studies identifying and linking health impacts of indoor combustion of methane or natural gas.
I'm aware of studies, yes, that discuss these issues. I'm not an expert on them.
Okay. So how has the company valued within the plan or cost benefit analysis of the potential benefits associated with the reduction in indoor air pollution, where indoor combustion appliances are reduced or eliminated?
I don't believe that we have accounted for that in the cost benefit analysis. I may want to confirm that with Mr. Oz. I don't believe that we did. We definitely looked at social cost of carbon, social cost of methane, but that's different from the effect you're going for. So I don't know that we actually have that. I'd put that in the room, in the realm of, area for improvement and future plans.
Okay. And
not diminishing the seriousness of the issue at all. It's just, we just didn't have information to bring to bear at that time.
Okay. So would you acknowledge that there is an indoor pollution factor here that many sources have linked to health impacts, which likely would carry some societal costs?
Yeah, without testifying to the magnitude on any of those factors in that logic chain, I think there's connections there, yes.
Okay. Let's see. Does the company have any forecasts of the impact of kind of business as usual or ambient electrification that might be induced by building codes or the significant federal and local incentives available for electrification?
I'm sorry, I'm not totally following. So in the analysis that we performed?
Yeah, have you included any of that in the forecasting?
There's definitely inclusion. I don't think this is exactly what you asked. There's definitely inclusion of the IRA type benefits in terms of like heat pump rebates. You're asking more around like planning standards, local municipal standards. Again, it's an evolving policy environment. I don't know to what extent we capture those.
Okay. I know we'll talk about JWI for attachment tomorrow morning. Has the company presented any kind of business as usual version of rate projections? Or really just rate projections on the different clean heat portfolios and how they play out?
We did in my direct testimony through 2030. I'll have to look at JWI 4 to see if we try to carry that through 2050 or not. But we did in my direct testimony. We were actually looking at that with Commissioner Plant a little bit ago in those figures. In my direct, it is somewhere around page 127. Yeah, it starts at 127. There's about 9 pages on rate impacts.
Okay, I'll review it.
Yeah.
Let's see.
And there's an attachment that updates many of those figures from that direct testimony. There's an attachment to my rebuttal that seeks to update those as well.
Okay. Let's see. Sorry, try and cut a few to get us closer to the end of the day here. So in response to the chair's question about kind of some of the asymmetry in how the company appears to characterize the economics of electrification in the TEP versus electrification here in the clean heat plan or even NPAs that we've seen, which I think generally characterize more negatively than in the TEP in terms of the cost of system impacts. Are there kind of specific load factor or coincident peak characteristics driving your assumptions or your concerns that lead you to be, you know, at least in my view, kind of more critical of the electric additions in clean heat rather than transportation?
It's many of the factors that we discussed earlier. We're seeking to take the conclusions where the facts lead them. And recognizing the facts need to evolve. We need to learn more about these facts. But basically, you can control to a large extent, at least in theory, you can control an electric vehicle's load. Typical driver can come home and plug their car in, but it doesn't need to be charged right away when they come home. There may be a 12-hour window during which you can charge that car any 2 hours or so. To get them to that kind of 40-mile average commuter range. So you've got a fair amount of at least hypothetical flexibility. We're trying to pursue that with, what we think are pretty cutting edge managed charging programs. On the heating side, it's, I think as I showed with the figures that we were discussing with Commissioner Plant, there's some potential benefits there. What we're seeing is as you get to higher levels and you get into that winter peaking mode, if you switch over to winter peaking mode and driving more electrification of heating can obviously, maybe I shouldn't say obviously, but can logically get you to that point. It would be a driver of getting you to a winter peaking condition. Once you're winter peaking, further heating load can increase that peaking condition. So that's what and I don't know if we're trying to be negative about it. I think we're pointing it out as a factor that we need to monitor. There's a ton of attention on gas infrastructure and avoiding gas infrastructure investment. And I think we're saying, okay, we agree with that. Let's monitor that and see if there's opportunities for that. I don't think you can do that and ignore the potential for potentially incremental electric investment on generation, transmission, and distribution. I don't think that's a fair analysis of the questions. That said, there's probably some room before we hit winter peaking mode. So I think we have a few years to figure this out. But some of the numbers that we saw, and challenge them as you will, but they're telling as a sort of analyst by nature, they're sort of telling us something. They're telling us we should be watching that.
So do you see some measure of integration in either a DERMS or demand response program, even a, thermostat program, something like that as an important component of optimizing the costs around electrification of heating over the long term then?
Yes, and I think the hybrid model has some merits to kind of carry us through the kind of near to midterm and help us to understand that. But yes, they do. I'm not as bullish that will take us as far as it can with electric vehicles, just because of when people want to heat their homes.
Sure.
We've had a lot of discussion in the phase 2 electric rate case about timing of rates, and I start to get a little bit concerned that we're trying to send the signal to customers like the important part to avoid is a little deeper in the evening. Company agrees with that, but at what point do we need to start signaling them to avoid early morning energy usage? And we're not doing that right now, and I don't know that we need to, but you start to anticipate that world. So there's a rate component to it. Absolutely, there's a managed demand component to it. We need to, let's get smart about that from the outset. I think we can agree on that and see if we can minimize this. But there is a fundamental factor that people turn off their thermostats when they wake up or just before they wake up. And that's just not true for electric vehicles necessarily. There's this focused window of time when that service is sought. When it's cold at night, you want to wake up, you want to warm up your house. Typically speaking, I don't want to speak for everyone's daily schedule, but that's the load pattern we see on the gas system.
Does the company have any data about if say a cold climate heat pump reverts to electric resistance in a cold temperature, kind of what the typical duration of that has been?
I don't think we do, and that's exactly the example, or maybe we do and I'm not fully aware of it. That's exactly the example of things I think we should monitor during the course of these next few years as we roll these heat pumps out. And then, you know, as the coefficient of performance on that unit kind of converges to 1, the difference between operating in heat pump mode and electric resistance mode actually shrinks. So, you know, whether you're flipping onto electric resistance or your coefficient of performance is coming down to 1, the difference may not be huge, but the effect on demand is similar. But that's exactly the type of thing that we just need to monitor, right? I think we're raising this as a really fruitful area to keep a close watch on as we build out this electrification initiative.
Let's see. Regarding your concerns about increasing winter peak, I was curious if the company sees replacement of legacy electric resistance heat with heat pumps as a strategy to improve efficiency and controllability of those systems.
That's a good question. I think I'd give that to Mr. Mark if hopefully he's still monitoring these referrals, just because it's sort of a program implementation question. I mean, that feels a little bit like the history of DSM where you replace less efficient things with more efficient things. It might be a very fruitful area of programming. I believe, and Mr. Goodenough may be able to verify this. I want to say that there's something like 9 or 10% electrification of customer residences on our system now, and I bet quite a few of those are resistant. So I would agree that may be a market to look at for programming.
Real quick on IQ mitigation, bill mitigation. So you mentioned that customers who participate in PIP or affordability programs won't see large rises in their bills, right?
We would hope not.
Okay. You know, and looking at some of the rate projections, I think I have some concerns about how durable that is as the main plan if we do see sales shrink on the system considerably. So, you know, I think one result that a lot of people have expressed concern about is that the customers who lack the capital to change equipment may be stuck on the system, may stay on the system longer than others, especially if rates begin to rise due to defection of other load. So I was wondering, are there other kind of more durable solutions the company's been considering or looked into? And just to channel Commissioner Plant over there, is on-bill repayment a reasonable option to reduce the upfront barrier that very specifically challenges IQ customers to be able to change their heating equipment?
Yeah, that could be a tool. I also think that rate design itself is a tool. I mean, some of these, you know, kind of runaway rate increase figures that you see, and some of them we put in front of you as a result of developing that long-term rate forecast. If you look at the revenue requirements on the gas system, they don't run away nearly like that rate does. It's basically the shrinking of volume, but the revenue requirements are pretty flat across these cases, and in fact, some of them go down. So that means that while the rate may increase, if we get the rate design right, the household bill doesn't necessarily increase, if you get what I'm saying. And what you'd have to do is flip some of the recovery more to a fixed situation than a variable situation. I don't know if I'm making sense at this end of a long day, but if you look at, you know, pages, and this is explored in the supplemental direct where we did that long-term rate forecasting. If you kind of flip through pages 35-ish, you can see both the rate increase, which is, I think, what motivated the question you asked me, but the revenue requirements don't follow that trend. They're much flatter.
Right, but spread over a lot fewer decatherms of sales.
Exactly. So the household bill doesn't have to climb in the way that rate indication would show that you otherwise would think it would.
Well, I guess for customers who remain on primarily gas heat, it would, notwithstanding some DSM measures that save some percent.
I think you can do a lot to help that situation with rate design.
Any suggestions?
Yeah, going more to a fixed charge and this is, this is not tomorrow. This is as these realities materialize and we work our way through phase 2 rate case discussions. On the gas side, I think looking at more of a fixed component to the rate is going to prevent the bill shock.
Okay. That would also probably impact the cost to customers who just continue to use natural gas as a backup rather than a primary heating fuel, right?
Yeah, it would.
But in fairness, if those customers are using it on the coldest day of the year, they are contributing significantly to the capacity needs of the system.
Yeah,
right?
no, exactly. You're just sort of, I think it's a more accurate allocation of costs. Really, my point is we don't have to live in a world in which the rates go, into this like super exponential growth mode. I don't think we're going to. We can shift some of that to a fixed component and not make that so shocking to a customer who may have a more higher volumetric contribution if they're on the system and they haven't moved over yet, especially if it's an IQ type customer who didn't have as many options to do it.
Okay. I have a few questions on JWI 5, and then I'll let us go for the day and we'll start up tomorrow. Now, JWI 5 is non-confidential unless you correct me, Mr. Larson. I didn't see anywhere that it is. So I think we're good to go on this one. Thanks, Ms. Federico. Appreciate it. So I just wanted to walk through a couple of these numbers with you to understand where they come from, just so I can understand the functionality of the sheet, Mr. Eiley.
Yep.
Can you go maybe to the emissions targets tab, Ms. Federico? Yeah, left. There you go. I thought that looked a little too small. All right, just scroll up a little so we get content in the whole screen, maybe. Okay. So on line 3, this is your line 3, I should say. I'll use your line numbers, not the actual cell line, if that works for you. So on your line 3, we can blow it up a little if you need, Mr. Riley. On your line 3, there's a gas to electric load conversion factor, 84 kilowatt hours per decatherm. Where did that come from?
I believe that comes out of our DSM programming area. So
do you know what it represents?
I'm sorry.
Do you know technically what it represents?
I'm trying to think where this is being used. So this is okay. So we're electrifying here. And I think what this represents is when we replace a decatherm of energy that's no longer being extracted from heating, we expect that there's 84 kilowatt hours of electric energy used per that decatherm.
That assumes some efficiency. Do you know the rough COP that's assuming?
Yeah, I was just kind of thinking through that. I'm not totally sure if that's just sort of a unit conversion of an energy expression or if it's actually accounting for a coefficient of performance type factor in there, to be real honest with you.
Well, I'm super interested because all your electric infrastructure costs come from it.
Yeah,
So,
yeah, I get it.
all right, well, we'll keep going. On line 7, again, your line 7, you list the in total increased electric non-coincident peak demand. You see that?
Yes.
999,000 kilowatts. That value was hard entered from what I could see. Do you know how this value is derived?
Is the this one, so this is for electrification, and we made an assumption around the heat pumps to derive that. And this emissions target, I want to say, has, I think we went over this earlier, 300,000 to 400,000 heat pumps plus a fair amount of water heaters. So it's derived from an estimate as to what the non-coincidental peak demand would be for those.
Any idea like what the assumptions were in that?
Per air source heat pumps, it's, I think it's between 5 and 10 kilowatts. I'll be real transparent with you, Commissioner. This was probably done by Steve Wishart. He left the company. He would have been a fine rebuttal witness to bring in, and I'm going to try to do the best I can, and we'll backfill as we need to answer the questions. We'll find a way.
Yeah, and I'm not trying to gotcha. It's just as you stated, we've got a ton of electric infrastructure costs assumed here, which heavily influences the cost benefit of any given portfolio. So we want to understand where we're getting the assumptions for these major costs.
Yep.
And I know not everyone loves spreadsheets, but I love spreadsheets.
I love them too, but I love them more when I actually built them. But
true.
I get it.
Okay, line 9 is also hard entered here. So line 9 is the approximate change in coincident peak demand. This is a hard entered 80%. So from what I could glean, we take the non-coincident peak demand and say, well, 80% of that is coincident peak demand. I mean, that's what the math does. So confirm that's what it looks like is going on here.
I think that's exactly what's going on.
Where'd the 80% assumption come from?
That is the type of, so that came from our looking at our program experience with heat pumps. We do have, I think, 2,000 or 3,000 of those out there. I will say it's an educated guess right now, and you heard me kind of extol the virtues of monitoring exactly these types of facts. That's exactly the type of number we need to learn about as we move from 2,000 or 3,000 heat pumps to 10 to 30 to 50 to 100,000 heat pumps. It's the number we need to understand. It gets right into the conversation we just had about how these things contribute to incremental peak demand. We don't know the answers yet. We were taking a guess. We don't think it's 100% contribution. We felt like we thought it was more than 50. I remember having the conversation with Mr. Wisher and some of the DSM program staff, and it's an educated estimate.
Okay. And when we're talking about coincident peak demand here, we're still talking about the summer coincident peak demand. Is that fair, or have we changed when we're projecting the coincident peak demand to be?
That's where we're getting into row 11, which is that's sort of a headroom factor of summer versus winter peaks. And I'm trying to think through how the relationship between those things goes here.
Yeah, I'm trying to figure out, probably at its core, in part, are we assuming everyone uses these for cooling and we're adding to the summer coincident peak because we assume they're using it for cooling on the summer coincident peak, or are we somehow building a new winter coincident peak?
I don't think it's the increase in summer peak, because I think actually as you implemented these types of heat pumps, you'll probably find, compared to like a 15-year-old air conditioner, I think you may find some benefits on that unit by unit basis. So I don't think that's what's happening here. As you see in row 12, it's showing net increase in coincident peak is 0.
Because you didn't fulfill
think,
your summer peak, right? Either somewhere between your winter peak and your summer peak.
So I think what's going on here is line 11 is sort of the expression of headroom, and that's what I mean by that is you've got summer peak and you got winter peak. So, but before winter peak catches summer peak, you've got that headroom expression, which is that 1,000 or 1,036 kilowatt hours, 36,000 kilowatts. Pardon me. The 799 is lower than the 1,036,000. Therefore, the net increase in coincident peak in whatever year we're looking at here is actually 0.
Yeah, I see that. When does your winter coincident peak occur now? What sort of condition, time of day?
Early morning, January, early morning.
Okay, so you have reason to believe what is your winter peak right now will remain your winter peak. We just build on it. In terms of time frame.
Yeah, I think that's true. This would be a system that would feature a lot more heat pump usage than it does now. But I believe the winter peak is now driven by heating load in the wintertime. So I believe that's more of an early morning type peak versus in the summer, more of a late afternoon type peak.
Okay. Does the company make any assumptions about the impact of demand response generally, or VPP and equipment or control opportunities more specifically in any of the assumptions about peak impact?
Not at this stage. I think that would be, I mean, roughly captured in that 80% factor. You don't want to assume that these are leading directly to peak exactly on the hour that is the peak hour. So, you know, could you use that to move that number from 80 to 70? That's a very fine discussion to have with more data.
Okay. And then if we go down just a little bit on you know, lines 18 to 20, I think, show distribution system costs. And what the company's done is taken the embedded distribution system costs and then multiplied it by 2 for the assumption on what any incremental increase in coincident peak would do in terms of distribution system expense. Can you identify for me how you determine that 2 times the embedded cost is the right number, most accurate number to use?
This was through average embedded is going to be cheaper because you've got, you know, the whole history of installed equipment. So that's definitely going to be cheaper than something you buy new today. This was influenced by our understanding of markets on, you know, transformers and things like that are so number one, they're new versus the average, you know, it's like comparing the cost of a new car to like the average value of any car out on the street or something like that. So there's that factor. There's also kind of the general increase in costs that we've but been seeing really since COVID on infrastructure. Supply chains have influenced that. So it was, you know, again, a like high level estimate. It's certainly higher than average embedded costs. Can you debate around 2? Probably.
Okay. For generation, which is lines 30 to 35 or so, if my eyes are still good, you are basing the assumption for the cost of any additional generation on coincident peak to assume all of the replacement generation is battery storage. Is that correct?
Yeah, that was the metric used here.
Okay. Why is that the most appropriate assumption for what generation source and cost would be indicated for all coincident peak additions?
Versus some other technology?
Yeah, or a mix of generation sources.
It was, you know, an attempt at a high level estimate representing of a cost for one technology, which may not be a lot different from another one. You could do a mix of resources there, yes.
Okay. Let me see. Let me see if I have anything more here. Let me see if I have anything more on this sheet. I don't think I have anything more on this sheet, Ms. Federico. I just want to understand, does the company count as savings any avoidance of future gas expansion projects that might be needed if electrification, especially in new construction, doesn't come to pass?
Can you run that by me again? I'm trying to just follow it through.
So the company represents in a different exhibit potential savings of gas infrastructure under different portfolios.
Yes.
Is there any assumption on the potential for continued development of capacity expansion projects if electrification levels do not come to pass to avoid future capacity expansion?
I apologize. So we're talking about if electrification doesn't come to pass per targets that we may set. Is that where you're going?
I can show it to you. I'll show it to you in JWI4 tomorrow morning, because there are specific assumptions in there
Okay.
on what it'll be. So it'll probably be more clear to represent that then.
Yeah, yeah, JWID4 was the sort of long-term, attempt at forecasting very long-term rates. So
Okay. And we just went through, last question, I promise, and then we'll go for the day. We just went through with the companies assuming for potential transmission distribution costs. Now Sweep notes that the levels assumed of cost for avoided transmission and distribution here are significantly different than what was provided in the DSMSI filing. Any thoughts on differences we're seeing in the cost for incremental transmission distribution?
this was later than the DSMSI, and as we updated those figures, they looked more expensive, and especially at JWID4, we were looking at pretty long term. I don't know offhand, is the SI looking at quite that long of a term of this. The duration of the timeline of the analysis, I'm not sure if the SI work is as long. It doesn't surprise me that the numbers are different.
Okay. All right. Those are my questions for today for you. Sorry I kept us late. I too am bad at estimating my time. We're gonna start tomorrow with Eiley confidential session. I'm just looking, I think it'll take about 15-20 minutes. So we'll get that set up at 9 a.m. unless you correct me, Ms. Federico, that won't be how it works. I presume Mr. Larson, Ms. Dundas, you've worked out who can access that session.
Yes, we have.
Okay, excellent. After that, we'll go to Eiley redirect, and then we'll plan to take Project Canary Witness Miller out of order after Eiley's done tomorrow. That works for everyone. Any other matters we need to get to today before we recess for the day?
Nothing from the company.
Okay. Hopefully I'm using the right language, Ms. Dundas. I think we're recessing, but yeah.
That sounds good for today. Thanks.
I'm a little fuzzy. It's been a while. All right. With that, I'll see you all at 9 a.m. tomorrow.
Thank you.
Mm-hmm.
Good.